morning, everybody. Happy Friday. Oh, I know I'm not the only person who is really glad that it's Friday today. This week has just taken a little bit out of us. Surprise half day, didn't know what was happening. We had that new video from the Sally port. Now we've got all this chaos with changing theories of the case. 4 weeks into trial. 3.5 years after John O'Keefe's death. And we don't know what's coming today as far as witnesses and so forth. We just know we are getting close to the end of the Commonwealth's case. And they're, wanting to change things up before they call their accident reconstructionist. So leads me to suspect they're not going to call the accident reconstructionist today. Probably get more people from the state police crime lab is going to be my guess on that. Because they're going to want to give Bev time to sort out what she's allowed to do. And last we left it, Mr. Alessi is supposed to come back this morning and let the judge know if how long of a continuance would be necessary to deal with this newly discovered theory timeline of the Commonwealth. So she wants to explore this potential remedy of a continuance. We'll see what he has to say. But guys, I was thinking about this last night, and it just aggravates me so much. It really does. The double standard and the just lack of interest in applying the same laws and the same rules to both sides. It just really is aggravating, and it reminded me of when I got annoyed by this previously. And went and looked down some rabbit holes about what was going on. In the course of all this, I found a case. It's a case I'm going to share with you guys. Part of the reason I'm going to share it is because Judge Cannone herself is familiar with this case. Why do I know she's familiar with this case? Because she cited it in her ruling on whether they were going to impose sanctions on the defense lawyers for various statements that they made. This was earlier this year. Remember, David Yanetti had put something in the motion that was covered by the protective order relating to grand jury proceedings. So the Commonwealth asked for sanctions for that. Then they're going into the oral argument on the motion to exclude ARCA, and the Commonwealth is accusing the defense of misrepresenting the facts vis-a-vis their relationship with ARCA, and that's been this long-standing issue pretty much ever since. This is not real super visible on the screen, is it? But it's unfortunately the version of the case I have. I don't know that I can make it. Yeah, I can make it a little bit bigger. And so Judge Cannone resolved all those in a single motion and cited this case in her ruling. So that ruling, just to remind everybody, she decided that there was no basis for imposing sanctions. Well, not no basis, but she wasn't going to impose sanctions on Mr. Yanetti based on the inadvertent. She agreed. It seemed it was inadvertent, violation of the protective order. He said he would be more careful, just had overlooked it. So she was fine with that. And then they went and dealt with the request for a gag order. So part of what was going on with the whole just litigation that was going on in this particular time frame. And so this was based on statements that were made during the various interviews He was really trying to pin statements of Karen Reed onto the defense lawyers so that he could argue the defense lawyers have acted unethically, violated the ethical restrictions on the things that they're allowed to say pre-trial. But the problem is that, her speech is not their speech, so you don't really get to do that. But they were able to put a couple of statements into Alan Jackson's mouth, and so based on that, the judge entered that gag order that basically just restated, you guys have to follow the rules of professional conduct, which is not news to anybody. So that's our context. But it's particularly when she was saying we're not gonna impose sanctions on Mr. Yanetti. She was really looking for a basis for it. But this case is one of the grounds she cited for her authority to impose sanctions under that situation. And I had gone and looked at that case, and I found it very interesting. Because what that case is about prosecutorial misconduct arising out of discovery violations. So I'm gonna share this with you and see what you guys think about whether there's something here that maybe should be fresh in Judge Cannone's mind. She read this case not that long ago, right? Because she cited it in her brief. Maybe she should remember what's going on here. The reason why this irritated me in the first place is because we shortly after this got the order on the motion for the motion to dismiss, the defense's motion to dismiss, based on egregious prosecutorial misconduct, a substantial chunk of which had to do with the Sallyport video and the trickling out of it. Remember that while we're looking at this case. So what had happened is a judge had imposed a $5,000 sanction on the prosecuting attorney for a discovery violation, and basically found there was a willful violation. I'm not going to go through like all the facts here, but basically alleging that the Commonwealth had filed a false certificate of compliance with discovery. Remember, part of the certificate of compliance is that you have to make a reasonable inquiry. You've either produced it or you've made a reasonable inquiry into the existence or non-existence of certain items. And so in this particular case, they hadn't turned something over, but they had filed this certificate of compliance. And so the Commonwealth does not challenge the fact it was required to provide the defendant with this police report, supplemental police report. It merely characterizes the ADA's failure to do so as an inadvertent mistake. In our view, the Commonwealth misconstrues the scope of its discovery obligation under Rule 14. What the Commonwealth fails to acknowledge is that pursuant to Rule 14A3, it had an obligation of reasonable inquiry, and that in this case, none was made. Here's an example. Commonwealth v. Martin. Prosecution had duty of inquiry regarding existence of scientific tests conducted by Commonwealth's crime laboratory, and discovery obligation not satisfied merely by turning over information contained in prosecutors' own files. You have a duty to keep up with what your experts are doing and to produce it, not just wait for it to show up in your file. That's part of your duty of inquiry. At the very least, even a cursory reading of the incident report would have informed the ADA that the defendant had reported an assault to the Cambridge Police Department and that further inquiry was in order. Notwithstanding the fact that the ADA here missed this reference, a prosecutor's belief that no inquiry is necessary or required in the circumstances of a particular case, based only on the prosecutor's assumption that he already has all of the items and information subject to discovery, does not comport with Rule 14A3. The language of 14A3 does not limit the duty of inquiry to instances where a prosecutor becomes aware that additional discoverable materials may exist. Reasonableness is the only limitation on the prosecutor's duty of inquiry. As such, it is incumbent on an ADA to ask a police prosecutor or other similar official whether all discoverable materials relating to a particular case have been given to the Commonwealth. More examples of cases. Commonwealth v. Martin. A prosecutor's obligations extend to information in possession of a person who has participated in the investigation or evaluation of the case and has reported to the prosecutor's office concerning the case. Only with such an inquiry can the prosecutor make an accurate and true representation on the certificate of compliance. Here, although the ADA seems to have misunderstood the import of Rule 14A3 and his obligations thereunder, the prosecutor plainly knew that he did not make a reasonable inquiry as to any outstanding discovery, even if he were operating under a misapprehension that he already was in possession of the relevant police reports. By signing the certificate of compliance, which stated that the Commonwealth had made a reasonable inquiry, the ADA made a false representation to the court. Why did this annoy me when we were talking about that Sallyport video? Remember that? That's where this came out. She had just cited this case in a previous ruling and then goes and excuses the failure to turn over the Sallyport video because Proctor had it. Proctor should have turned it over. Police should have turned it over. The prosecuting attorney has a duty of inquiry to find it and then to certify that they did that. Where's that rule being applied in this courtroom? Never once. Never once has that rule been applied in this courtroom. So they have an obligation to go look for stuff, not just to wait for it to passively show up in your inbox. So if your expert is going to be going out, doing new analysis, coming up with new opinions, developing new facts, you have a duty to be aware of that and to keep defense apprised of it. That is part of your obligation. So they concluded the ADA wasn't acting in bad faith. So under Rule 14C, now let's talk about sanctions. The judge can impose a variety of sanctions on the Commonwealth for failure to comply with pretrial discovery rules. See, for example, let's look at some of these examples. Grant of a mistrial followed by a new trial is typical relief where defendant is prejudiced by prosecutor's failure to properly disclose exculpatory evidence. That's your Brady remedy. Dismissal of indictment may be proper remedy for Commonwealth's failure to comply with discovery order. Judge properly limited scope of testimony from Commonwealth's rebuttal expert witness where Commonwealth failed to disclose appearance by such witness in violation of the discovery order. Yeah, you exclude stuff that's in violation of the discovery rules. And she's going to act like Alessi is asking for something completely unreasonable, like this is the first time she's ever heard of such a thing. No, actually, they'll do worse than that. They might dismiss an indictment, some courts, over discovery violations when it renders the proceeding fundamentally unfair. Like maybe changing direction in the middle of trial. To that end, so as we have stated, sanctions pursuant to Rule 14C are designed to protect a defendant's right to a fair trial. To that end, such sanctions tailored to cure any prejudice to the defendant resulting from a discovery violation are remedial, not punitive in nature. So what this case actually holds is that a $5,000 sanction is not a remedial sanction. It's not authorized under this particular rule. It's under this other rule. That's what Judge Cannone cited it for, is literally like this route right here. This sentence is like all she apparently cared about in this entire case. That if you're going to impose monetary sanctions, you have to do it under Rule 48 and not Rule 14. Sanctions are to ensure that the defendant receives a fair trial. That's what it needs to be. Found something else while I was out looking around, going down this little bit of a rabbit hole. This is a form of the certificate of compliance for discovery for the prosecutor. See if I can make this a little bit bigger too. Not really, no. Oh, there we go. Oh, look, there's a place for it to be a supplement. You can file a new supplement. Why might you do that? Why might you do that? Here's what they have to certify to: that to the best of your knowledge and after reasonable inquiry, the undersigned has disclosed and made available all items subject to automatic discovery Other than reports of experts and all items ordered by the court, the identity of each item of discovery which have been provided is as follows. What's down here at the bottom? Intended expert opinion evidence. Other than stuff that deals with insanity. Intended expert opinion evidence. You certify you've turned it all over or you've made a reasonable inquiry. That's part of the certification. Think that's been done here? I think Mr. Alessi made a pretty good case yesterday that this has been an outstanding issue for at least months. This has been in multiple reports. This has been in Ian Whiffin's report since December. This came out at the first trial because of Richard Green's testimony about the Waze clock. He discovered the Waze clock. It's on a monotonic clock. It's different from the display clock on John's phone. And so you had to have an offset if you were using that Waze data to try to calculate where they were at any point in time and use that to establish a timeline. And you didn't bother to ask your expert if he was going to deal with all that? Really sounds like a you problem. Really sounds like a you problem. Or, like Mr. Alessi is suggesting, what's a little bit more troubling here. Sounds like they just maybe didn't recognize they had a problem until after Ian Whiffin testified, and the defense blew their timeline apart. They just had a shitty theory. And now that's been exposed, and so now they're scrambling to try to have to deal with that. So these are the things I had in mind after yesterday. Just thinking about those standards, those double standards, and how happy she was, how eager she was, even enthusiastic to turn the defense inartfully denied paying ARCA in the context of whether we've paid ARCA for their initial opinion. The defense, made a statement that was broader than it should have been. Never paid ARCA. You did pay ARCA for showing up at trial. Paid them for their time. Somehow that is eagerly transformed into, I've found multiple willful violations of the discovery rules by the defense with respect to ARCA. I don't recall that she has. Don't actually recall that she has. But that's what this is blown up into. Meanwhile, the Commonwealth has filed a certificate of compliance before the first trial. Didn't bother to look into any of this Sallyport evidence, including what has now been shown to be impeachment evidence. That video of Brian Albert there at the wrong time, doing stuff other than what he said he was doing, going places where he denied going. And not even a problem. Not even a problem. So if there's any question about why this is so frustrating to deal in a court like this, it's because the system is rigged. The rules are rigged. When you have an umpire that's going to call everything you throw a ball and everything the opposing side throws a strike, how's that a fair game? You're not even playing the same game. So very, very frustrating. Very frustrating, ongoing. But that's the pattern that's been established. And so that's why Mr. Brennan is continuing to lean into this. He's found a weak spot. She's dying. She's just absolutely dying to find a reason to punish these defense lawyers and this defense team and these ARCA witnesses. Take the shine off of the ARCA witnesses because, yeah, the fact that they were independent, not hired by the defense, made available to either side, and it just turns out that the defense is who wants them because physics are favorable to the defense in this case. Yeah, that's really strong and compelling. That is a gift. You rarely get that in a trial. You never get that. You know, the best, the closest, like, best alternative is when you get to turn the state's expert, you know, into your favor. You get to elicit something positive for your case from the state's own expert. That's like the next closest good thing you get. You don't get a free independent expert that has just fallen out of the sky and who isn't immediately confronted with, well, you're a hired gun for the defense, aren't you? And isn't that what you do professionally? You're professionally a hired gun for the defense. It's routine with experts. And so ARCA doesn't have that. They have that shine of we are not partial in any way. We weren't even hired by these people. We were hired by somebody completely different. Of course, we're not allowed to say who. And we simply looked at the evidence, looked at the laws of physics, looked at the nature of the human body, and we concluded Karen Reed did not hit John O'Keefe with a car. It's extremely powerful. And so if you're going to try to level the playing field for the Commonwealth, yeah, you got to take that shine off. So Hank Brennan found this a long time ago. This is a weak point, a little opening that he has with the judge because she does want to find a problem here so badly. And that eagerness has allowed this issue to grow beyond what it even is. Where did we get to? I mean, I'm still just baffled. I'm still baffled. She says this in open court. I found multiple repeated violations of the discovery order. When was that?
Counsel at sidebar, please.
Yeah, sidebar. Of course we are. When exactly was that? Because there have not been repeated willful violations found, not in any document filed in this court. But so eager to find a problem there to help the Commonwealth out with their problems with their technical case. So given all that and given all that context, is she going to find a discovery, a Rule 14 violation here? Well, we'll see. We'll see, won't we? She's got two avenues. No Rule 14 violation. Yes, Rule 14 violation. She finds no Rule 14 violation. No, Commonwealth just gets to keep investigating, and there's no indication they sat on it unnecessarily and they turned it over when they found it. That's it. If she finds a Rule 14 violation, then the question becomes, what do you do about it? What's the remedy? What's the remedy? Her language yesterday hinted that this is where she's going because she's trying to evaluate what are alternative remedies. Mr. Alessi, if I don't give you the remedy of excluding this new information, what's an alternative? What else might you ask for? And he's resisting that appropriately because that's her trying to find a way to say, well, you said this would be good enough, so I'm going to give you something other than what is necessary to produce a fair trial here. which is to require the parties to stick with the positions that they adopted in the time frame that they're afforded to be able to develop their positions. That's what the adversarial system is all about. It's not about one side has facts and one side has truth. Parties advocate their positions on the evidence, and it's up to the jury to make that determination about what the truth is and where the truth lies. So when you talk about not having trial by ambush, what that means, you have to commit to your position before trial. That's your job. That's what your investigation is designed to enable you to do, to commit to a position. Commit means you're stuck with it. Otherwise, what do we have? You have ambush. If you don't have to commit and you can just willy-nilly change things, that's how you have ambush. So she's, perhaps signaled she's inclined to find, yes, this is a Rule 14 violation, but we're going to look for some alternative remedy, and then combine this with, Hank is still leaning into this ARCA issue. He wants to have rebuttal of ARCA. He wants like a special benefit because you don't ordinarily get that in Massachusetts in expert evidence. You don't get to just keep going back and forth and back and forth and back and forth with the experts. That's why you have pretrial discovery. So all of that is exchanged, all of that is fleshed out ahead of trial, and the positions are established and committed to. So it's frustrating. It's very frustrating because we're just seeing this leaning into getting some special treatment by the Commonwealth that she seems happy to give them when she won't apply the same standard to the Commonwealth's own production. She didn't apply it before the first trial. She's not applying it now. She's saying, yeah, the defense had an obligation to turn over ARCA stuff, even though they couldn't, and you gave them a deadline to turn it over by, and they turned it over by that deadline? You're the one who said May 7th, and they turned it over by May 7th. Now he's complaining and he wants a remedy because he got it on May 7th? But the defense would have liked that Sallyport video quite a bit before the first trial. Bet they would have liked to have that video of Brian Higgins back when they were cross-examining him the first time. Bet they would have liked that. Did that raise any concerns whatsoever? None. None. Seen a few times now come back up in the commentary out there on X and the clips and things like that. Mr. Lally lied about communicating with the crime lab, the status of the DNA testing, claiming he's calling them every week to check in, see what the status is, when the reality is he had ignored them for so many months that they closed their file and they didn't do anything. And this is why DNA testing is late. Does that sound like a reasonable inquiry? Does that sound like candor to the tribunal? And did it raise any grave concerns whatsoever on this bench? None. So this is how you get a shit show. It doesn't matter if you're looking at a sporting event. It doesn't matter if you're looking at a trial. When the referee doesn't equally apply the rules, even-handedly and fairly, you get chaos. You get one side taking advantage of every little bit of leeway that they've been given. And you have one side that's going to at some point say, fuck it. We got to do what we got to do. Client's life is on the line here. And the ref isn't going to keep things in order. So we're going to have to take care of it ourselves. And you get chaos. You would think the judge would learn that your own job gets a lot easier if you're just fair and consistent. You wouldn't have Hank coming at you with all these motions, all these requests for special accommodations that you then have to go and research to see, can I even come up with a justification to give him what he wants? If you just even-handedly applied the rules in the first place, if you hadn't bent over backwards to try to give him a hand up, he wouldn't still be here asking in the middle of trial, thinking that it's okay, that it's going to be fine. Within days of resting his case to change his theory, change his discovery, change his facts, change his experts' opinions. And the irony in all of this, every time the Commonwealth tries to make a technical case, they just create a new problem with their own theory. So their theory that they came into trial with, a 12/31 whatever trigger time, trigger event, major problem with it, right? Because we've got volitional activity on John's phone after that. It's physically impossible. Their theory coming into this trial, physically impossible, rebutted by their own evidence. So they're going to have to deal with that by changing the timeline yet again. Change the clocks now. So now the trigger event is at 12:32. We've solved this problem with the John's phone and the phone, the lock, using the button to lock the phone after that. Okay, we can reverse that. We can fix that time. Now you got the problem of the 4-minute gap between the trigger event and Karen logging on to John's Wi-Fi at One Meadows at 12:36. And somehow making this 6-minute minimum drive in like decent conditions in 4. You got a whole other set of problems. So I mean that's the irony in all of this, is that every little struggle, it doesn't even help them. It doesn't even really help. You would think the judge at some point would recognize that. Look, your guys' flailing is not my problem.
Any business before the Honorable Lally Cannone, Justice of the Norfolk Superior Court, and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Good morning again, counsel. Good morning again, Ms. Reed. Good morning, jurors. So I appreciate your patience. I have to ask you those 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left yesterday?
Yes.
Everyone said yes and nodded affirmatively. Were you also able to follow my instructions and refrain from doing any independent research or investigation into this case? Yes. Everyone said yes and nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? No. I have one other important instruction for you folks, and it's so important that each and every juror can hear the evidence or the testimony that's presented, can follow the testimony, and can understand and evaluate the testimony of each witness and the exhibits. In order to do that, I just want to be very clear that it's important that people do not comment on the evidence or make any comments. Once you enter the room, it's probably a good idea to just listen. Don't talk, don't make any facial expressions, no muttering under your breath, no audible noises, because people need to hear what's going on and to understand everything. So out of respect for your fellow jurors, I would ask that you be very careful to make sure you don't do that. And out of respect to the lawyers who worked so hard to get this case before. Okay, thank you very much. With that, Mr. Brennan, your first witness, please.
Or if I could begin by offering a stipulation that's agreed to between the parties.
Okay, can we turn the AC down, please? Thank you. Yes.
Your Honor, if I may, I'd like to read a stipulation agreement between the Commonwealth and the defense.
Okay.
And the stipulation between the parties is as follows. Now comes the Commonwealth and Karen Reed, the defendant, in the above captioned matter. Both parties respectfully stipulate to the following. The two Massachusetts State Police troopers present at the autopsy conducted by the medical examiner, Dr. Scortibello, on January 31st, 2022, were Trooper Keefe and Trooper Watson. Former Trooper Michael Proctor was not present.
Thank you.
Please just stipulate, Your Honor.
Yes, thank you.
Okay. This is
With
not
that, Your
Proctor.
Honor, I'd
Sure looks
to
like
introduce
Proctor.
and play clip number 21.
Okay. Paul, turn the AC off. Hold on one second, please. I just want that. Can the jury see better with that on?
So John's laying there, his left and his right, and I approach John from the left. That's where the street is. And he had a piece of glass, like perched on his nose, like just wedged like a splinter would be. And I just pulled it, and as soon as I pulled it, it just gushed blood down his face.
So we need this.
So not there for very long.
Now the item.
John wasn't out there for very long if he's still actively bleeding. He's actively bleeding. His heart is pumping.
Mr. Lally, your next one.
Your Honor, the Commonwealth calls Andre Porto to the stand.
There we go. The DNA guy from the lab.
Do you solemnly swear the evidence given in the court and jury in the case now hearing to the truth, the whole truth, and nothing but the truth? So help you God? I do.
A little bit of a problem with the theory, huh?
Hey, Mr. Lally, whenever you're ready.
Thank you, Your Honor. Good morning, sir.
Morning.
Could you please introduce yourself to the jury, spelling your last name for the court?
Yeah, my name is Andre Porto, last name spelled Porto.
And what do you do for work, sir?
I'm a forensic scientist too in the DNA unit at the Massachusetts State Police Crime Lab.
And where did you go to school?
I received my undergraduate Bachelor of Science in Microbiology from the University of Massachusetts in Amherst. And then I received a Master of Science in Biomedical Forensic Sciences at the Boston University School of Medicine.
Now, following your education, where did you go to work?
I started at the Massachusetts State Police Crime Lab in the DNA unit.
And how long have you worked at the state lab?
Slow down.
Oh, yeah, sorry.
How long have you worked at the state lab, sir?
Since September 2019.
Now, when you joined the lab, what was your position and title that you were initially hired for?
I was hired as a forensic scientist 1.
Now, can you please explain to the jury your duties and responsibilities as a forensic scientist 1?
Sure. So a forensic scientist 1 is a training position where we're hired and we undergo an extensive training program where we do undergo the analysis process in training casework samples, where we learn how to do the lab work and analyze profiles. And at the end of this training, I took a competency test to make sure that I was able to accurately conduct the DNA analysis process. And once I passed that, I was then put on to do casework. And a year after completing both my competency tests and a year after my hire date, I was then promoted to a forensic scientist 2.
And so you're currently a forensic scientist 2, is that correct?
Correct.
And what is the difference between a forensic scientist 1 and a forensic scientist 2?
So a forensic scientist 2 is just the automatic promotion that you get after a year of hire and passing the initial competency test. And we're able to do the DNA process in casework samples.
Now, so what type of analysis do you currently do at the Massachusetts State Police Crime Laboratory?
I can do the DNA analysis process in casework and no samples. That includes the lab work as well as analyzing the DNA profiles that are generated from the work.
Now, first, just in general terms, but specifically with reference to DNA analysis, can you explain to the jury how is that analysis performed?
Sure. So there's 4 steps in the analysis process. The first step is extraction, where we apply heat and chemicals to the samples to break open the cells and release that DNA to be available for use. Step 2 is called quantitation, where we take a small sample of that extracted DNA to estimate, and we use chemicals and run it through an instrument to estimate how much DNA we extracted. And then we proceed to step 3, which is called amplification. And that's basically, think of it as a molecular photocopier, where we target specific areas of the DNA to make millions of copies of it. And then we run it through go to detection, where we run it through an instrument, and we generate the DNA profile as an electronic file on a computer.
Now, is the state lab where you work accredited?
Yes, it is.
And by whom?
We are accredited by an organization called ANAB, which stands for ANSI, National Accreditation Board, and ANSI stands for American National Standards Institute.
I need you to slow down, please.
Raleigh's going to bore us to death on
Sorry.
this because the DNA evidence is not helpful to the Commonwealth.
Now, Mr. Porto, are there steps taken in your lab during that process that you were just explaining to prevent against contamination?
Yes, there are.
And can you explain what those are?
Sure. So there are various steps.
Anybody
One step
know?
to prevent contamination between analysts would be to bleach and wipe down the workstations before use and after. Another way to prevent DNA transfer from analysts to the samples is to wear personal protective equipment, such as lab coats, gloves, masks, hairnets, and beard guards. And a way to prevent transfer from sample to sample would be to frequently change gloves, as well as only have one sample open at a time.
Now,
Technically, it's only
is
one
your
sample
work
in the
lab,
room
is
at a
there
time.
A review process.
You don't even
that
have
your
2
work undergoes?
samples
Yes, there is.
in the
And
same
can you
room.
describe that process to the jury?
Sure. So once I complete my work, the file undergoes 2 types of reviews. The first is a technical review, where another qualified analyst will take the file and they'll do their own independent assessment and make sure that they come up with the conclusions and that they agree with the conclusions that I reached. And they'll also make sure that all the protocols were followed and every decision is scientifically sound. Once that review is completed, it undergoes an administrative review, where another qualified analyst will then look through the file and they look for clerical errors, such as typos or missing page numbers or missing case numbers. Once those 2 reviews are completed, the results can then be reported out.
Now, as a part of that accreditation process that you were speaking about a few moments ago, do you undergo anything called proficiency testing?
Yes, I do.
And can you explain to the jury what that proficiency testing process consists of?
Yeah, so a proficiency test is a test that's administered twice a year by an external vendor. And the results of this test are not known to the analyst at the time. And we basically treat it like it's a real case, where it undergoes the analysis process as if it were a real case. And this test is used to show that the analyst is demonstrates ongoing competency in the DNA analysis process. And successful completion of the test is required to maintain qualification as an analyst.
And what areas do you specifically undergo proficiency testing in?
DNA analysis.
And have you successfully completed each of those proficiency tests that you've taken?
Yes.
Now, Mr. Porto, could you explain to the jury what exactly is DNA?
Yeah, so DNA stands for deoxyribonucleic acid, and it's basically the building block that makes us who we are.
Of human.
We each have 2 copies of our DNA, one that we inherit from mom and one that we inherit from dad. And that this combination makes sure that, barring with the exception of identical twins, we all have different DNA.
And is DNA the same in every cell of a person's body?
Yes. So what that means is, if I were to take a blood sample and a saliva sample from the same person, the same DNA profile will be generated.
Now, you spoke a bit earlier about the different steps included in the DNA testing. If you could, just a little bit slower, go through each of those 4 steps again for the jury.
Sure. So like I said, it's a 4-step process. So extraction, quantitation, amplification, and detection. So extraction, we use chemicals and heat to burst open the cells to make that DNA available for use. Quantitation, step 2, we take a small sample of that extracted DNA. We use a different set of chemicals and an instrument to estimate how much DNA is available for use. Amplification is the 3rd step, which I mentioned is the basically molecular photocopier, where it makes millions of copies of specific areas of the DNA. And then the 4th and last step is detection, where we run those amplified copies through an instrument, and we generate the DNA profile as an electronic file on the computer.
Now, Mr. Porto, what is STR?
So STR stands for short tandem repeats, and they're the locations that we're making the millions of copies of.
Now, in your work at the lab, do you have something that's referred to as a known item?
Yes.
And can you explain to the jury what a known item is?
Sure. So a known item is an item that's taken directly from a person to be used as a reference sample, so we know what the source of that profile is.
Replication errors in
Conversely, what is
gametes.
a questioned item?
A
Both
questioned item
different.
is an item that's taken, let's say, from a crime scene where we don't know what the source is.
Now, do you also have terminology within your lab as far as a parent versus a child item?
Yes, we do.
And can you explain how those labels are and how they reference to what you do in your work?
Sure. So a parent item is, for example, the original item, and the child is a sample of that item. So for example, this box of tissues would be the parent item, and if you were to swab the outside, the swab would be the child item. So the box of tissues would receive, let's say, an item of 1-1. The swabbing of the outside would receive an item of 1-1.1.
Now, what are positive and negative controls?
Yeah, so a positive control is a control that has it's a known sample with a known DNA profile that we use in every step of the DNA analysis process to make sure that each step and instrument worked as expected and properly. And then a negative control is a sample that has no DNA in it. It only receives the chemicals that we use, and that's to ensure that the chemicals that we're using don't have any DNA inherent to them.
Now, when you as an analyst or a forensic scientist too are assigned work within the DNA unit, where do you retrieve that evidence from?
Yeah, so I retrieve it from a locked cold room that's only accessible via keycard.
Now, why are items kept in cold storage?
Yeah, the cold storage helps preserve the DNA for long-term storage.
And as far as the heat versus the cold, why is it that it's specifically kept, or why does the coldness of the storage room help preserve the item?
The cold can help prevent, let's say, growth of bacteria and mold that can degrade DNA.
And what does heat do conversely in reference to an item of forensic value?
Heat can help degrade DNA, and also promotes bacterial and mold growth that can further degrade that DNA.
Maybe
Now,
you should
when
keep
you
it
receive
in
an
your
item from
garage.
the cold storage, how is that item typically packaged when you retrieve it from there?
Sure. So the item comes in these plastic, clear, transparent plastic sealed containers that has a label with a case number on it. And inside of that, each sample is within like a small plastic tube that has a label with a case number and item number.
Now, at some point, were you assigned to perform some work on a lab case number 22-02184 pertaining to this defendant, Karen Reed?
Yes, I did.
And what type of work in general terms were you assigned to do in this case?
I was assigned to do the DNA analysis process.
And that was on several items, is that correct?
Correct.
And could you explain to the jury the sort of the process that you used to analyze evidence in this case?
Sure. So the case underwent the 4 steps that I explained before. So extraction, quantitation, amplification, and
Did
detection.
it twice now. Third time.
And there
We
was
know.
a known standard that was done in this case, specifically in item number 8-1.1.1. Is that correct?
Correct?
And did another analyst test and report the results from the known blood standard from that item 8-1.1.1?
Correct.
And how is that done?
Yeah, so that undergoes the same process that I explained. It'll go through the 4 steps: extraction, quantitation, amplification, detection. And then the analyst that did the interpretation and reported that out, the known standard out, they went through the profile to make sure that it's one person or single source. And once that went through the review process that I explained, so technical and administrative review, and once that was all completed, the standard was available to be used for comparisons.
And to whom was that known standard identified as belonging to?
John O'Keefe.
Now, you used the word in there as far as a single source. Can you explain to the jury what your understanding of that term is based on your training and experience?
Sure. So a single source is just a DNA profile that has one contributor to it. So only one person contributed DNA to that profile.
What exactly is a DNA profile?
Yeah, so a DNA profile is basically the combination of all of the locations that we amplified during the 3rd step of the process. And it's basically, you can think of it as like a chart, like an EKG, where it has peaks and valleys, and each peak has a specific number. And the DNA profile is just a combination of all those numbers put together.
Now, can you explain to the jury in general terms, to start with, the process of comparison between a known standard and a questioned or unknown standard?
Sure. So first, I did the analysis on the question items. I did the 4 steps. I analyzed the profiles that were generated. I then interpreted and make sure that I could determine the number of contributors. And once that was completed, I then used the standard that was available to and compared them to all the profiles that were suitable for comparison.
Now, sir, starting with item 3-1.1, what was that a sample from?
That was a sample from taillight passenger.
And from a specific vehicle, is that correct?
Correct.
And what, if any, information were you given as to that vehicle that the swab from the taillight was from?
Do you mean like the license plate?
Yes.
Could I refer to my notes?
Yes.
Thank you.
Your Honor, with the course permissions, this is a little detail as far as the testimony goes.
I don't have a problem. Does the defense object?
I do not object.
Okay,
Your Honor.
thank you.
Thank you,
Sounds
Your
like Yanetti.
So the license plate was 3G6684. Wait, I'm sorry, 3GC684.
Now, with reference to the swab from the taillight, were you able to generate a DNA profile from that item?
I was.
And from your comparative analysis from that question item to that of the known standard of John O'Keefe, what did you conclude?
So the DNA profile was interpreted as a mixture of 3 contributors, including male DNA. And the DNA profile from this item is at least, so sorry.
Start over.
So the DNA profile was interpreted as a mixture of 3 contributors, including male
3.
DNA. And the DNA profile from this item is at least 510 non-alien times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals. This provides support for an inclusion.
Now, sir, what does that mean?
So an inclusion is basically when I look at the question DNA profile that was generated, and I compare it to the known DNA profile. And if the characteristics of the known profile are consistent with the characteristics observed in the question DNA profile, that's an inclusion.
Now, as far as that number, 510 non-alien, how many zeros in that number?
So a non-alien is a 1 followed by 30 zeros.
Now, that profile, in addition to Mr. O'Keefe's profile, also had 2 unknown contributors, correct?
Correct.
Now, was that item also submitted to an outside vendor named Bodhi Technologies for further analysis?
Correct.
And with reference to your comparative analysis from the profile from this item to Mr. O'Keefe profile, if you could again just expound upon what does inclusion mean?
Yeah, so an inclusion, I compared the known standard that I had available for use from John O'Keefe to the DNA profile generated from the taillight, and the DNA profile was consistent with the DNA profile that I observed in the questioned item, and that's what an inclusion means.
Now, regarding item 3-6, what is the description of that item?
Yeah, so 3-6 is a root end of hair from exterior passenger side rear panel.
And is that the same vehicle as far as the taillight sample?
Correct.
Now, with respect to hair in general, there's a root end and a shaft end, correct?
Correct.
And what limitations does your lab have with regard to DNA testing of hair?
So when we test hair, we're actually, the root end of the hair, we're looking at any potential skin cells that might be attached to the root end. So that's where the DNA that we're looking for is coming from. And if there's not too many, yeah.
Now, are you familiar with the term based on your training experience known as autosomal DNA?
Yes.
And can you describe for the jury what your understanding of that term is?
Yeah, so autosomal DNA is DNA that's located in the nucleus of the cell, and that's the DNA that we inherit from both mom and dad.
Now, are you also familiar, based on your training experience, with a term known as mitochondrial DNA?
Yes.
And can you please explain to the jury what your understanding of the term mitochondrial DNA is?
Yeah, so mitochondrial DNA is DNA that's found in the mitochondria of a cell, and we inherit that from the mother.
It may be somewhat evident, but could you please explain to the jury sort of the difference between autosomal DNA on the one hand and mitochondrial DNA on the other?
Yeah, so like I said, the autosomal DNA is the one that we have two copies of, where we inherit one from mom and one from dad. And then the mitochondrial DNA is a circular DNA that we just inherit from mom.
Now, is the Massachusetts State Police Crime Lab equipped to perform mitochondrial DNA testing?
No, we're not.
Now, was the DNA extract from the hair also sent to that external vendor, Bodie Technologies in Lorton, Virginia?
I'm not sure if the extract was sent, but I know that the shaft of the hair was sent to Bodie.
Now, what testing did you perform on the hair?
I did the regular DNA analysis process on the root end of the hair.
And that was done prior to it being shipped to that external vendor, is that correct?
Correct.
And what conclusions were you able to draw from the testing that you did on the hair?
Yeah, so there was no human DNA detected, and STR analysis was not performed.
Now, what does that mean, sir?
Yeah, so it means that I didn't detect any human DNA. So there might be DNA on there, but it was below what our instrumentation could detect.
Everybody's got their verbal tics. That's
Now,
this, guys.
Turning your attention to item 3-2.1.1. What is the description related to that item, sir?
It's a sample from the exterior of broken drinking glass.
And is there any further indication as far as the broken drinking glass, as far as where it was recovered?
Oh, yeah, 34 Fairview Road.
And were you able to generate a DNA profile from this item, the drinking glass?
Yes, I was.
And from your comparative analysis from this question item to that of the known standard of John O'Keefe, what did you conclude?
Yeah, so the DNA profile was interpreted as a mixture of 3 contributors, including male DNA. The DNA profile from this item is at least 530 non-million times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals. This supports an inclusion.
This is the last time I'll ask you this, but just if you could reiterate to the jury, what does an inclusion mean?
Yep, so an inclusion is when I compared the known standard to the question item, and if the profile in the known standard is consistent with the profile in the question profile, that's an inclusion.
And that number again, as far as 530 non-alien, how many zeros again in that number?
That's a 1 followed by 30 zeros.
Now, sir, if I could turn your attention to another item, 7-1.2.1. What is the description related to that item?
Sample from stain A on upper right leg of jeans.
And is there any further indication as to whom those jeans belong to?
John O'Keefe.
Now, were you also able to generate a DNA profile from this item, the stain A on the upper right leg of Mr. O'Keefe's jeans?
Yes, I was.
And from your comparative analysis from the question item to that of the known standard of John O'Keefe, what did you conclude with reference to that item?
The DNA profile was interpreted as a mixture of 3 contributors, including male DNA. Contributor 1 is suitable for comparison, and due to limited information, contributors 2 and 3 are not suitable for comparison. The DNA profile from this item is at least 570 non-alien times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals. This provides support for an inclusion.
Thank you, sir. Now turning your attention to item 7-1.3.1, what is the description related to that item?
Sample from stain B on upper right leg of jeans.
And same jeans as the previous item?
Yes.
Now, were you able to generate a DNA profile from this item, stain B, on the upper right leg of the jeans of Mr. O'Keefe?
Yes, I was.
And from your comparative analysis from this questioned item to that of the known standard of John O'Keefe,
Great
what did you
question.
conclude?
Yep, so the DNA profile was interpreted as a mixture of 3 contributors, including male DNA. The DNA profile from this item is at least 660 non-alien times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals. This provides support for an inclusion.
Now, sir, with reference to item 7-1.4.1, and again, these items with the dash and the point, is that what you're referring to earlier as the parent-child relationship between items?
Yes.
And what is the description for 7-1.4.1?
Sample from stain C on upper right leg of jeans.
Now, were you able to generate a DNA profile from this item from stain C on the upper right leg of Mr. O'Keefe's jeans?
Yes, I was.
And from your comparative analysis of this question item stain C to that of the known standard of John O'Keefe, what did you conclude?
The DNA profile is a mixture of at least 2 contributors, including male DNA. Contributor 1 is suitable for comparison. Due to limited information, contributor 2 is not suitable for comparison. The DNA profile was interpreted as a mixture of 2 contributors. The DNA profile from this item is at least 830 non-alien times more likely if it originated from John O'Keefe and an unknown individual than if it originated from 2 unknown, unrelated individuals. This provides support for an inclusion.
Now, sir, with reference to item 7-1.5.1, what was the description of that?
Sample from stain D on upper right leg of jeans.
Now, were you able to generate a DNA profile from this item from stain D on the upper right leg of Mr. O'Keefe's jeans?
Yes, I was.
And from your comparative analysis from this item to the known standard of John O'Keefe, what did you conclude?
The DNA profile was interpreted as a mixture of 3 contributors, including male DNA. The DNA profile from this item is at least 670 non-alien times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals. This provides support for an inclusion.
Now, sir, did you also do some testing on an item 7-1.6.1?
Yes, I did.
And what was the description associated with that item?
Sample from stain E on upper right leg of jeans.
And were you able to generate a DNA profile from that item, stain E, on the upper right leg of Mr. O'Keefe's jeans?
Yes, I was.
And from your comparative analysis from that question item to the known standard of John O'Keefe, what did you conclude?
The DNA profile was interpreted as a mixture of 2 contributors, including male DNA. Contributor 1 is suitable for comparison. Due to limited information, contributor 2 is not suitable for comparison. The DNA profile from this item is at least 1.0 decillion times more likely if it originated from John O'Keefe and an unknown individual than if it originated from 2 unknown, unrelated individuals. This provides a support for an inclusion.
I used a different number there as far as a decillion. How many zeros is a decillion?
Yeah, a decillion is a 1 followed by 33 zeros.
Now, with each of those items that you just testified about as far as the jeans, the question items from the stains on Mr. O'Keefe's jeans, those were each located on the right leg, correct?
Correct.
Now, did you also perform some analysis on item 7-1.7.1?
I did.
And what is the description associated with that item number?
Sample from unstained areas of the exterior of jeans.
Now, were you able to generate a DNA profile from that item from the unstained areas of the exterior of Mr. O'Keefe's jeans?
I was.
And from your comparative analysis from this question item to the known standard of John O'Keefe, what did you conclude?
The DNA profile was interpreted as a mixture of 4 contributors, including male DNA. The DNA profile from this item is at least 53 septillion times more likely if it originated from John O'Keefe and 3 unknown individuals than if it originated from 4 unknown, unrelated individuals. This provides support for an inclusion.
And again, sir, with that number, as far as 53 septillion times more likely, how many zeros in a septillion?
A septillion is a 1 followed by 24 zeros.
Now, sir, if I could turn your attention to what's listed as number 12 in your report, but item 7-18.4.1. Did you do some testing on that item as well?
Yes.
And what was the description associated with that?
Sample from stain C on top front of Gray's long sleeve shirt.
And the gray long sleeve shirt, is that attributed as belonging to a specific person?
Yes, John O'Keefe.
And were you able to generate a DNA profile from that item, specifically sample from stain C on the top front of the gray long sleeve shirt of Mr. O'Keefe?
I was.
And from your comparative analysis from that questioned item from the shirt to the known standard of John O'Keefe, what did you conclude?
So the male DNA profile was interpreted as originated from a single contributor. The DNA profile from this item is at least 58 octillion times more likely if it originated from John O'Keefe than if it originated from an unknown, unrelated individual. This provides support for an inclusion.
And again, sir, that number, as far as 58 octillion times more likely, how many zeros in an octillion?
So an octillion is a 1 followed by 27 zeros.
Now, sir, if I could take you down to listed as 15 in your report, but did you do some testing on item 7-18.14.1?
I did.
And what was the description associated with that item?
So sample from stain L on back bottom right of gray long sleeve shirt.
And were you able to generate a DNA profile from that item?
I was.
And from your comparative analysis with reference to that item, the sample from stain L on the back bottom right of the gray long sleeve shirt, in comparison to the DNA profile from the known standard of John O'Keefe, what did you conclude?
So the DNA profile was interpreted as a mixture of 2 contributors, including male DNA. The DNA profile from this item is at least 1.0 decillion times more likely if it originated from John O'Keefe and an unknown individual than if it originated from 2 unknown, unrelated individuals. This provides support for an inclusion.
Now, sir, did you also perform some analysis on an item numbered 7-18.17.1?
I did.
And what was the description associated with that item, sir?
Sample from unstained areas of exterior of gray long sleeve shirt.
And similarly, were you able to generate a DNA profile from that item, the sample from the unstained areas of the exterior of the gray long sleeve shirt of Mr. O'Keefe?
I was.
And from your comparative analysis from that question item to that of the known standard of John O'Keefe, what did you conclude?
The DNA profile was interpreted as a mixture of 2 contributors, including male DNA. Contributor 1 is suitable for comparison, and due to limited information, contributor 2 is not suitable for comparison. The DNA profile from this item is at least 960 nonillion times more likely if it originated from John O'Keefe and an unknown individual than if it originated from 2 unknown, unrelated individuals. This provides support for an inclusion.
Thank you, sir. I'm going to group a couple, 4 separate items from your report, starting with what's listed in your report as number 9 is item 7-3.1, correct?
Correct.
And what is the description associated with that item, sir?
Sample from stain D on right instep of sneaker.
And 11 from your report, you also did some analysis on item 7-18.3.1, is that correct?
Correct.
And what was the description associated with that?
Sample from stain B on top front of gray long sleeve shirt.
And item 7-18.7.1, do you see that as well?
Yes.
And what was the description associated with that item?
Sample from stain F on top front of gray long sleeve shirt.
And lastly, in this group, item 7-18.8.1, what was the description associated with that?
Sample from stain G on back left sleeve of gray long sleeve shirt.
And with respect to each of those last 4 samples from those items, were you able to generate a DNA profile with respect to each of those 4?
Profiles were generated from them.
And what did you conclude based on the generation of those profiles with those 4 items?
Yeah, so the profiles that were generated were not suitable for comparison.
And if you could explain briefly to the jury, when you say not suitable for comparison, what do you mean by that?
Yeah, so 47-3.1, it was a mixture of at least 5 contributors. And at the DNA unit, we validated, basically we tested and make sure that our protocols were we can only interpret mixtures of up to 4 contributors. So I determined that there were 5 contributors, so that makes it too complex for us to do comparisons to it. So it's not suitable for comparison for that reason. And the other 3 items, due to the quality of the profile, they were not suitable for comparison. And basically what that means is that there were such low amounts of DNA that was in the sample that there was a lack of information from the profiles themselves, so they weren't really suitable for comparisons.
And just to be clear, the item that you're referring to with the 5 possible contributors, that's a shoe, correct?
Mm-hmm.
Correct.
Now, if I
Instep
can turn
of
your
the
attention
shoe?
in your
Yes,
report
indeed
to
it
what
is.
you have listed as number 10, there are a number of different items listed there, correct?
Correct.
And starting with item 7-17.2.1, what is the description associated with that?
Sample from stain A on top front left of orange t-shirt.
And 7-17.3, what is the description associated with that?
Sample from stain B on top of front left of orange t-shirt.
And item 7-17.4.1, what is the description associated with that?
Sample from stain C on top front left of orange t-shirt.
And item 7-17.5.1, what is the description associated with that item number?
Sample from stain D on front bottom right of orange t-shirt.
And item 7-17.6.1, what is the description associated with that?
Sample from stain E on back left shoulder of orange t-shirt.
And so each of those respectively were samples taken from stains on the orange t-shirt of Mr. O'Keefe, correct?
Correct.
Now turning your attention to item 7-18.2.1, what is the description associated with that?
Sample from stain A on right sleeve of gray long sleeve shirt.
And item 7-18.5.1, what is the description associated with that?
Sample from stain D on center front of gray long sleeve shirt.
And item 7-18.6.1, what is the description associated with that?
Sample from stain E on center front of gray long sleeve shirt.
And item 7-18.9.1, did you generate a profile from that item as well?
Yes.
And what is the description associated with that?
Sample from stain H1 on back left of back left of gray long sleeve shirt.
And item 7-18.10.1, what is the description associated with that?
Sample from stain H2 on back left of gray long sleeve shirt.
And item 7-18.11.1, what is the description associated with that?
Sample from stain I on back right shoulder of gray long sleeve shirt.
And item 7-18.12.1, what is the description associated with that?
Sample from stain J on back bottom right of gray long sleeve shirt.
And lastly, with this group search, item 7-18.13.1, what is the description associated with that?
Sample from stain K on back bottom right of gray long sleeve shirt.
And so each of those items beginning with 7-18 were associated with various stains taken from various areas on the gray long sleeve shirt of Mr. O'Keefe, correct?
Correct.
And with respect to each of those areas of the orange t-shirt and the gray long sleeve shirt, were you able to generate a DNA profile from those items?
I was.
And from your comparative analysis of each of the DNA profiles from those items to the known standard of John O'Keefe, what did you conclude?
So the male DNA profile was interpreted as originating from a single contributor. The DNA profile from these items is at least 490 octillion times more likely if it originated from John O'Keefe than if it originated from an unknown, unrelated individual. This provides support for an inclusion.
Now, again, if you could just remind the jury, when you say single source contributor, what does that mean?
Yeah, so a single source profile is a profile that has one contributor to it. So like one person contributed DNA to that profile.
And with respect to the number as far as 490 octillion times more likely, how many zeros are in that number?
So an octillion is a 1 followed by 27 zeros.
Oh, we'll talk
Now,
about
lastly,
this.
sir, did you perform any analysis with reference to items numbered 8-2 and 8-3?
I did.
And what were the descriptions respectively for items 8-2 and 8-3?
So item 8-2 was right hand fingernail clippings from John O'Keefe, and item 8-3 were left hand fingernail clippings from John O'Keefe.
So fingernail clippings from both the right and left hand of Mr. O'Keefe.
Correct.
And were you able to generate a DNA profile from those item numbers, the right and left hand fingernail clippings of Mr. O'Keefe?
I was.
And based on, from your comparative analysis of the DNA profile from the right and left hand fingernail clippings, both of Mr. O'Keefe, taken in conjunction with the known standard of John O'Keefe, what did you conclude?
Yeah, so the male DNA profile was interpreted as originated from a single contributor, and the DNA profile from these items is at least 490 octillion times more likely if it originated from John O'Keefe than if it originated from an unknown, unrelated individual. This provides support for an inclusion.
So with respect to each the right and left hand fingernail clippings of Mr. O'Keefe, both of those were identified by you or your analysis as a single source contributor, correct?
Correct.
And they were each 490 octillion times more likely to have originated from John O'Keefe than from an unknown, unrelated individual. Is that correct?
Correct.
Thank you. Thank you, sir. I have nothing further on.
May I, Your Honor?
Yes.
Mr. Yanetti.
Good morning, sir.
Good morning.
Mr. Porto, I would like to start by asking you about item 3-1.1, which you've identified as a sample from the passenger side taillight of the vehicle. Can you orient yourself in your report to that item?
Yes.
And that, of course, was the passenger side taillight that was attached to the vehicle, correct?
Correct.
You were never asked to do any DNA comparison on any pieces of taillight connected with this case, correct?
Let me check my other report.
Oh, I suspect he knows the answer to that.
For taillight, there was another item that was item 3-3.1, which is sample from apparent glass on rear bumper, if that's what you're referencing.
Okay, so if I suggested to you that the taillight was plastic, that glass wouldn't have been the taillight, correct?
I don't have, that's beyond my scope of testing.
Gotcha. Okay. With regard to the passenger side taillight, you found that there were 3 contributors of DNA to that taillight attached to the vehicle, correct?
Correct.
One of those contributors appeared to be John O'Keefe. Is that fair to say?
He was included into the profile.
With regard to the other 2 contributors, who were they?
They could be anybody.
Were you ever asked to compare DNA samples from either Canton Police Detective Kevin Albert or Canton Police Chief Kenneth Berkowitz to the DNA profile that you analyzed from that passenger side taillight?
I was not.
Now, with regard to the broken drinking glass, which is item 3-2.1.1, do you see that in your report?
I do.
With regard to that, you came up with a DNA profile that also had 3 contributors, correct?
Correct.
One of those contributors appeared to be John O'Keefe, correct?
He was included, correct.
Who were the other 2 contributors?
I don't know. They could be anybody.
Were you ever asked with regard to that broken drinking glass to compare the DNA profile that you analyzed with the DNA of either Boston Police Sergeant Brian Albert or ATF agent Brian Higgins?
I was not.
Now, with regard to 7.1.2.1, or maybe it's 7-1.2.1, that's the stain A from the upper right leg of the jeans?
Correct.
All right. And you were aware, you were told that those were the jeans that John O'Keefe was wearing on the morning in question when he was found?
Based on the sample description, that's what it seems.
All right. And it turned out that his DNA was on his own jeans, correct?
He was included in the profile.
All
from
right,
that
and that was unsurprising to you, correct? And with regard to that item, you found that there were 3 contributors of DNA, correct?
Correct.
With John O'Keefe being one of them.
He was included in the profile, yes.
And who were the other 2?
I don't know. They could be anybody.
Let's move on to stain B, also from the upper right leg of the jeans. That is 7-1.3.1. You see that in your report.
I do.
When you found a DNA profile, how many contributors of DNA were there?
3 contributors.
All right, and again, this was John O'Keefe's genes, correct?
Based on the description, yes.
So he was one of the 3 contributors.
He was included in the profile, yeah.
Who were the other 2?
I don't know. They could be anybody.
Moving on to stain C from the upper right leg of the jeans, 7-1.4.1. You see that in your report?
I do.
With regard to the DNA profile that you analyzed there, how many contributors of DNA were there to that profile?
At least 2, and it was interpreted as 2 contributors.
And again, this is the same pair of jeans that he was found in, correct?
Based on the description, yes.
And you said at least 2 contributors. It actually could have been more than 2.
Based on our protocols, I had to call it 2, and we determined it as 2, but it could be more than 2, yes.
Okay. Well, let's pay attention to the one that was not John O'Keefe, at least that one. Who contributed that DNA to his pants?
I don't know. It could be anybody.
Moving on to stain D, which is 7-1.5.1. And if I can just put my glasses on to make sure I've read my own writing correctly. Actually, is it 7-15-1? Did I get that wrong the first time?
D?
I'm sorry?
Do you mean
Stain D? Stain D.
Stain D is 7-1.5.1.
Oh, I had it right the first time. Okay. With regard to that stain, you also got a DNA profile. And how many contributors were there to that DNA profile?
I interpret it as 3 contributors.
And again, this is John O'Keefe's genes, correct?
Correct.
He was one of the contributors to his own genes, correct?
He was included in the profile.
And with regard to that stain on the upper right leg of his jeans, who contributed the DNA to who are the other 2 contributors of DNA to that stain?
I don't know. They could be anybody.
And then finally, with regard to that upper right leg of the jeans, there was also a stain E, correct?
Correct.
How many contributors did you find to that DNA profile?
2 contributors.
One of which was John O'Keefe to his own genes, correct?
He was included, yes.
And who was the other contributor to that stain on the jeans?
It could be anybody. I don't know.
And by the way, just for the record, that was 7.1.6.1?
7-1.61.
7-1.6.1. Thank you, sir. Okay, now, with regard to the unstained area of the exterior of the jeans, do you see item 7-1.7.1?
Yes.
You found a DNA profile with regard to that unstained area as well, correct?
Correct.
How many contributors of DNA were there to that unstained area of the jeans?
I interpret it as 4 contributors.
And John O'Keefe was one of those, correct?
He was included in the profile.
His own genes.
Based on the description, yes.
Who were the other 3 contributors to that DNA profile?
I don't know. It could be anybody.
And before we move on to the sneaker, I just wanted to ask you a question about the passenger side taillight that I neglected to ask you. That was the one where there were 3 contributors, correct? And again, I'm going back to 3-1.1.
Correct.
Sorry to skip around, sir.
Okay.
I'm not trying to make this
all
any
right.
more confusing than it is. With regard to the passenger side taillight and that DNA profile, are you able to determine when that DNA was deposited on the passenger side taillight that was attached to the vehicle?
No, I'm not.
Are you able to testify with any certainty that it was deposited there, say, on January 28th or 29th of 2022?
No, I can't.
So consistent with your analysis of it, are you able to say whether it occurred prior to January 28th of 2022?
No, I can't.
Were you aware that that vehicle was John O'Keefe's girlfriend's vehicle?
I was not.
Were you provided any information about just how often he had been in and around that vehicle prior to January 28th of 2022? So moving on to 7-3.1, which was the right instep of the sneaker, correct? You see that in your report?
Yep.
With regard to that particular stain, you noted how many contributors of DNA?
Yeah, it was interpreted as at least 5 contributors.
And when you have interpreted as at least 5 contributors, what does that do to your ability to find out who contributed that DNA?
So based on our protocols, we're not able to do any comparisons to any mixtures that are 5 or more contributors. So it's not suitable for comparisons.
Okay, which means that with regard to the sneaker, at least, you couldn't even say whether John O'Keefe's DNA was on it, correct?
Correct.
And with regard to all 5, do you have any idea who contributed the DNA to that sneaker?
No, I don't.
Now, moving on to, I just have a couple more for you, sir. Moving on to what is labeled as stain L, which is 7-18.14.1, I believe. Do you see that in your report?
I do.
And that was a stain on the back bottom of his long sleeve shirt, correct?
Correct.
And were you told that the long sleeve shirt was his outer clothing when he was found?
I don't believe so.
How many contributors to that stain on the back bottom of his long sleeve shirt did you find in that DNA profile?
I interpreted it as 2 contributors.
And did you make any match with regard to either of those contributors or both?
I did comparisons, and John O'Keefe was included as one of the contributors.
Okay, so John O'Keefe was a contributor of DNA to his own long sleeve shirt, correct?
Based on the descriptions, correct.
All right, and whose other DNA was on that shirt?
I don't know.
And then finally, with regard to 7-18.17.1, that was an unstained area of the exterior of that shirt, correct? That same long sleeve shirt.
Correct.
And you tested that and got a DNA profile, correct?
Correct.
How many contributors were there to that DNA profile?
I interpreted it as 2 contributors.
Was John O'Keefe one of them?
He was included as one of the contributors.
Okay, so his DNA was found on his own shirt, correct?
Based on the description, correct.
And who contributed the other DNA profile to John O'Keefe's sweatshirt?
I don't know.
With regard to any of the stains on the upper right leg of the jeans, I counted 1, 2, 3, 4, 5 that you've discussed here today. Were you ever asked to compare the DNA profile with the DNA profiles of either Brian Higgins or Brian Albert?
I was not.
Oh,
sorry.
And your answer was you were not?
I was not.
Did anybody ever provide you with DNA profiles of Brian Higgins or Brian Albert?
sustain to that.
If I may have one moment, Judge?
Yes.
Well, we've just emphasized all the DNA on John's clothing that doesn't belong there, haven't we?
I just have one more question for you, Mr. Porto, and I do want to thank you for answering all my questions here today. You wrote reports on your analysis of all the items and the work that you did on this case?
I did.
And you are directed pursuant to protocol to address those reports to somebody, correct?
Correct.
Who was it that you sent the reports to in this case?
Michael Proctor?
I'm sustaining the objection.
Did you send those reports to Michael Proctor?
Sustained. Jurors, strike the question.
I have nothing further. Thank you, sir.
Yes.
Why? Why are we not asking that?
Mr. Porto, based on your training and experience in years of doing DNA testing at the lab, when it comes to samples from items of clothing, is it uncommon or common to have multiple contributors?
That depends. It can happen, but it's possible, yes.
Is it something that's a complete anomaly?
I wouldn't say so, no.
Now, turning your attention back to item 3-1.1, that's the sample from the passenger side taillight of the defendant's vehicle, correct?
Correct.
And Mr. O'Keefe was found to, his known DNA profile was found to be an inclusion for the DNA profile from the swab from the defendant's passenger side taillight, correct?
He was included in the profile, yes.
And to what statistical, what is the number
This is
associated
just
with that
repeating the
inclusion?
direct exam.
The DNA
not
profile for this
redirect.
item is 510 non-alien times more likely to have originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown unrelated individuals.
Now, Mr. Porter, if I could turn you back to number 10 in your report, there's a number of different items listed there, correct?
Correct.
And as far as the items listed associated with various stains on various areas of Mr. O'Keefe's orange T-shirt and gray long sleeve shirt, there's about 13 different DNA profiles that you generated in reference to those items, correct?
Correct.
And from those 13
Would you
different
just
items,
repeat
they're
what you
all
said on
from a
direct?
single contributor, is that correct?
Correct. They were interpreted as originated from a single contributor.
And as far as the DNA profile, your comparison of each of those 13 different stains on the orange T-shirt and the gray long sleeve shirt, what were your conclusions again as your comparison with the known standard of John O'Keefe?
Yeah, so the profile was interpreted as originated from a single contributor, and the DNA profile from these items is at least 490 octillion times more likely if it originated from John O'Keefe than if it originated from an unknown, unrelated individual. This provides support for an inclusion.
And lastly, with reference to the fingernail clippings from both the right hand and the left hand of Mr. O'Keefe, those were also, your analysis provided for inclusion of Mr. O'Keefe's known DNA standard, correct?
He was included in the profile, correct.
And again, the profile from both the right hand and the left hand fingernail clippings was a single source contributor, correct?
Sustained.
How many sources were associated with those?
Objection.
Sustained.
Nothing further.
Okay. You all set, Mr. Yanetti?
Yes, Your Honor, thank you.
You are all set, Mr. Porto. Thank you very much.
All set. And then we get Bodie now.
Your Honor, the Commonwealth will call Ashley Vallier to stand.
Oh no, the taillight reconstruction. She put all the pieces of the taillight back together, except for those ones that they were never able to find. Oh, we're going to have so much to talk about with this, guys. Yeah, lots of other people's DNA all over John, all over his clothing. What do you think of that? Was that particularly helpful for the Commonwealth?
You solemnly swear the evidence given to the court and jury in the case down here is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Yep.
All right, Mr. Lally, whenever you're ready.
Thank you, Your Honor. Good morning, Ms. Vallier.
Good morning.
Could you please introduce yourself to the jury, spelling your last name for the court?
My name is Ash Vallier, spelled Vallier.
And where do you work?
I work at the Massachusetts State Police Crime Laboratory.
And where did you go to school?
I got my bachelor degree in biochemistry and cell biology from UC San Diego and a master's degree in biomedical forensic sciences from Boston University.
You thought Andre Porto
Now,
spoke quickly.
following your
Now meet
education,
Ashley.
where did you go to work from there?
Directly after I got my degree at Boston University, I worked at the Broad Institute.
And what did you do at the Broad Institute?
I did quality control checks of items that potentially could be tested for pharmaceutical use.
Now, how long have you worked at the Massachusetts State Police Crime Laboratory?
A little over 6 years.
Now, is the state lab accredited?
It is.
And by whom?
ANAB.
Make sure we
What does
repeat it.
ANAB stand for?
You're repeating
It
this
stands for
by every
ANSI, National
single
Accreditation Board.
forensic expert.
And the ANSI within the ANAB, what does that stand for?
That is another acronym that I don't recall right now.
Now, as part of that accreditation process, do you undergo any sort of type of proficiency testing?
I do.
And can you explain to the jury what that proficiency testing process consists of?
A proficiency test is a test that is given from an outside agency in the discipline that you do casework in, that you would work through like a normal case, but it has an end expected result at the end.
And how often do you undergo proficiency testing?
Every year.
In what areas do you specifically undergo proficiency testing in?
I've done proficiency tests in gunshot primer residue and physical match analysis.
And have you successfully completed each of those proficiency tests that you've taken?
I have.
Now, when you initially joined the State Police Lab, what was your position and title that you were hired for?
I was hired as a forensic scientist 1.
Now, can you please explain to the jury what your duties and responsibilities were as a forensic scientist 1?
So a forensic scientist 1 is the introductory level. It's when you start your training in whatever discipline you're going to be trained in and quality control checks. After you've been at the laboratory for over a year and you're signed off to do casework, you become a forensic scientist 2.
And you're currently a forensic scientist 2, is that correct?
Yes.
What is the difference between a forensic scientist 1 and a forensic scientist 2 at the Massachusetts State Police Crime Laboratory?
A forensic scientist 2 has been at the lab for over a year and can do casework.
Now, just in general terms, what does the trace unit do or examine within the State Police Crime Laboratory?
I'm a part of the trace, arson, and explosives unit. So we analyze a wide range of pieces of evidence. So trace covers a lot of small things. So paint, fibers, glass, gunshot primer residue, physical matches. Arson covers fire debris evidence, and explosives covers explosives.
Now, specifically with reference to physical match analysis, can you explain to the jury, just in general terms at first, how is that analysis performed?
So physical match analysis is piecing broken things together to see if they were at once a single item. Generally, you look at the questioned item first, the item that you don't know specifically where it came from. Look at that, and then you would look at the known item, which is an item with a known source, like specifically like this window or like this vehicle. They're analyzed at separate times. And then if it looks like there could potentially be a physical match, you would analyze them together and see if they have a mechanical fit.
Now, when you retrieve items just in general to do some sort of physical match analysis, where do you get those items from?
We have evidence storage locations at the laboratory.
And how are they typically packaged when you receive them?
They can be packaged in cardboard boxes, brown paper bags, heat sealed plastic bags. It depends on the individual items.
And when you're doing this analysis as far as the physical match analysis, what do you do to your bench between your examination of separately packaged items?
Before I do any analysis, I bleach my bench, clean my tools, and then put down a fresh sheet of butcher paper.
And why do you do that?
To make sure everything's clean.
Now, again, speaking more in general terms, on what types of evidence can you perform a physical match analysis?
Sorry, can you repeat the question?
Sure. in general terms, with your work within the lab, on what types of items can you perform a physical match analysis?
A lot. Anything that has a broken or irregular edge.
Would that include glass?
Yes.
Would that include plastic?
Yes.
What are some of the other things that would also include?
Any sort of like polymer, metals.
And when you're doing a physical match analysis, what instruments do you utilize in the course of that analysis?
Generally, I'll use a stereo zoom microscope. Depending on the size of the items compared, I can use other microscopes as well.
Now, what is a stereo zoom microscope?
A stereo zoom microscope is a microscope that's mounted on a stand, so it gives a wider range of view that you can look at larger items.
And how are you using that specifically in your physical match analysis of, let's say, items of plastic?
I'll use it to look at the edges and see if there's any like defining characteristics along those broken edges.
Now, as you're going through your analysis, do you document your work as you go?
I do.
And how do you do that?
With handwritten notes and with photos.
Now, at some point, were you assigned to perform some work on lab case number 22-02184 pertaining to this defendant, Karen Reed?
Yes.
And what type of work were you assigned to do in this case?
I was asked to do physical match analysis, and then later on I was asked to look at, do some trace recovery, look at some debris.
So starting with the physical match analysis, how many different items approximately were you asked to look at?
Over 10.
Several, fair to say?
Yes.
Okay. And how were each of those items packaged when you received them?
So the questioned items were packaged first in a large paper bag, and then each item was individually packaged in a smaller brown paper bag within that container.
Now, again, just in general terms, because you've used it a couple times, when you say questioned item versus known item, as it pertains to this analysis in this case, what were the questioned items generally, and what was the known item?
The question items were items labeled as coming from a road, and the known item was labeled as coming from a taillight from a vehicle.
Now, in this case, did you perform your physical match analysis in the same manner that you've previously described based on your education, training, and experience within the lab?
Yes.
Now, initially, you had examined some various plastic and glass items, and there was a drinking straw in there as well, correct?
Yes.
And specifically, as far as the item numbers that you looked at in this physical match analysis, could you provide the jury with the list of just the item numbers first to start with?
May
Your
I?
Honor.
You have your report with you, Ms. Vallier?
I do.
Okay. Is there any objections to me using the report?
No objection at all.
So feel free to use it.
Thank you. Your
Will
Honor.
be Yanetti again.
So the questioned items labeled as coming from the road were item 7-5, item 7-6, 7-8, 7-9, 7-10, 7-11, 7-12, 7-13, 7-14, 7-15, 7-16, and 7-19. And the known item labeled coming from the passenger side taillight is item 3-1.
Now, Ms. Vallier, within those specific item numbers of how things are labeled at your lab, if there are different pieces associated with the same item, how is it that you label those specifically in this physical match analysis here?
So some of the items had multiple pieces within that item. So I labeled them A, B, C, etc., depending on how many pieces there were.
Now, if you could, please explain to the jury just, again, the process that you followed in your examination of each of those items.
So first I looked at the questioned items, the items labeled as coming from the road. I looked at, I documented the overall package because they were all packaged in the same container, the same brown paper bag. Documented that individually inside of it, there were a bunch of individual brown paper bags. Documented that, and I went one at a time through them, opening each paper bag, taking written notes, taking photos of the items inside. Within each item, I looked to see if any of those pieces fit together. And I cleaned my bench in between the items.
Your Honor, may I approach?
Yes.
And Your Honor, so the court, so I've shown Mr. Yanetti all the photos in advance.
Okay. Is there an objection to any of them,
There is
Mr.
no
Mayor?
objection, Your Honor.
All right, so why don't we just go ahead and mark them all as evidence?
Your Honor, if I could, I was going to take them item by item.
Okay, that's fine. Okay.
Next, Vallier, I'm showing you 4 photographs. You recognize those?
I do.
What do you recognize those to be?
These are photos that I took of item 3-1.
And again, what was the description associated with item 3-1?
Passenger side taillight.
And was that description further give sort of a specific vehicle or a license plate associated with the vehicle that the taillight came?
It does. Massachusetts 3GC684.
Your Honor, the Commonwealth will seek to introduce in a minute the next exhibit A through D.
Right, those are cool. That's why I wanted to just mark them all because they're all cool, right?
That's fine. If the court prefers, I can provide them.
All right.
Exhibits 170A through 170D.
May I approach with the remainder, Your Honor?
Yes. If you have them in sections, we can do that.
This way, I'm showing you 2 more photographs. Just ask if you recognize those.
I do.
And what do you recognize those?
Photos I took of item 7-5.
And again, from your report, what was the description in reference to item 7-1?
Yeah.
Thank you. You're fine. It's just loud. Yes.
Okay. Piece of plastic red recovered from 34 Fairview Road.
And Your Honor, the Commonwealth seek to introduce in a minute the next exhibit A and B.
Okay.
There'd be a whole stack of them.
My apologies, Your Honor. With the court's permission, may I publish some of those?
Yes.
photos to the jury?
Let's just make it messy. Why not? Why not make it messy?
Ms. Gilman, if I could first ask for photograph 2122. And Ms. Vallier, what's up on the screen, that is the bag associated with the passenger side taillight or the known item, correct?
Correct.
And Ms. Gilman, if I could have photograph 2125. And Ms. Gilman, if you could just enlarge a little bit towards the bottom where the ruler is. Now, Ms. Vallier, what's up on the screen now as far as the sort of notations there? Who made those?
I did.
And how do you know that you were the one who made those?
That's my handwriting, and those are my initials.
So the AMV is for your name, correct?
Yes.
And with respect to each of the items that you photographed, you had photographs that were taken of sort of what was in the evidence bag in total, displayed on your table that you would clean with the solution and everything else, correct?
Yes.
Okay. And Ms. Gilman, if you could just zoom out a little bit to show the item. And again, what's up on the screen, that is item 3-1, the known item as far as the tail light from the defendant's vehicle.
Yes.
And Ms. Gilman, if I could have 2126. And Ms. Vallier, if you could just describe for the jury, what are we looking at in this photograph?
Those are those same items, just turned over.
And lastly, for this set, Ms. Gilman, if I could have 2135. And again, same item as far as 3-1, the tail light taken from the defendant's vehicle.
Yes.
Ms. Gilman, if I could ask for photograph 1905. And Ms. Vallier, as far as with each of these items, you take photographs when they're inside the bag and then once you take them out of the bag, correct?
Yes.
Okay. And Ms. Gilman, if I could have photograph 1908. And what are we looking at in this photograph?
The contents of item 7-5.
May I approach again, Your Honor?
Yes.
We'll need two more photographs. Do you recognize those?
It's going to be a long morning.
And what do you
Looking
recognize
at
those?
pieces.
Photos of item 7-6.
That's one of the bag and then one when the item is taken out of the bag. Is that correct?
Yes.
And what was the description for item 7-6?
Piece of plastic, clear, recovered from 34 Fairview Road.
And which of those? Your Honor, Commonwealth will seek to introduce in the minutes the next exhibit, A and B.
172 A and B.
With the court's permission, may I publish those to the jury?
Yes.
Ms. Gilman, if I could have photograph 1921. And then photograph 1924. And what's depicted up on the screen is that what you just have before you as the photograph that you took of item 7-6 recovered from 34 Fairview Road.
Yes.
Thank you.
Couple
May I approach
pieces
the
of
witness again, Your
diffuser
Honor?
right
Yes.
there.
Other photographs, you review those? Do you recognize those?
I do.
What do you recognize as?
Photos I took of item 7-8.
And one of the bag and then one of the items removed from the bag, is that correct?
Yes.
And what is the description associated with item 7-8?
Piece of plastic, red and clear, recovered from 34 Fairview Road.
Commonwealth seek to introduce in the minutes the next exhibit, A and B. And Your Honor, with the court's permission, if I could publish those to the jury.
Yes.
Exhibits 173 A and B.
Ms. Gilman, if I could have photograph 1931 and then 1934. And Ms. Gilman, if you could zoom in just a little on those items, please.
There's the bucket piece. Remember that?
And Ms. Vallier, again, what are we looking at in this photograph of item 7-? What are we looking at again in this photograph? Excuse me.
Photos of item 7-8.
May I approach the witness again, Your Honor?
Yes.
So what was found when you asked? When all of this is initialed by Trooper DeChico as of February the 4th?
And you recognize
Great
those?
question.
I do.
And what do you recognize those?
Photos of item 7-9 and 7-19.
And as far as the first photograph, as far as the bag, and then the second with the items taken out of the bag, is that correct?
Yes,
So 7-9 and 7-19 were contained in the same bag.
they were. I then separated them into two separate packages.
And as far as 7-9 and 7-19, respectively, if you could tell the jury what was the description for each of those items.
Item 7-9 was pieces of glass recovered from 34 Fairview Road. Item 7-19 is trace item, black straw, recovered from 34 Fairview Road.
Your Honor, Commonwealth seek to introduce in the minutes the next exhibit, A and B. May I publish, Your Honor?
Hold on.
Oh, forgive me.
174A and 174B.
Now you can publish.
My apologies. Ms. Gilman, if I could have 1958, please.
More
And then
DeChico.
1962. And again, Ms. Vallier, what are we looking at in this photograph?
The contents of that bag, item 7-9 and item 7-19.
So what is this and where did this come from?
Two other photographs, do you recognize those?
I do.
What do you recognize as?
Photos of item 7-10.
And again, one of the bag and one of the contents of the bag, is that correct?
Yes.
And if you could, please tell the jury what was the description for item 7-10.
Piece of plastic, red, recovered from 34 Fairview Road.
I want to introduce in a minute the next exhibit, A and B.
Exhibits 175A and B.
May I publish that for the jury on?
Yes.
Ms. Gilman, if I could have 1952.
Still Trooper DeChico.
And 1956. And again, Ms. Vallier, what are we looking at in this photograph?
Photo of item 7-10.
Thank you. Gilman, you can take that down. May I approach the witness, Your Honor?
Yes.
Two other photographs, do you recognize those?
I do.
And what do you recognize those?
Photos of item 7-11.
Again, one photo of the bag and one photo of the items outside the bag.
Yes.
And again, if you could, please tell the jury what the description is associated with item 7-11.
Piece of plastic, 6, red, clear, and black, recovered from 34 Fairview Road.
The Commonwealth is introducing the minute as the next exhibit, A and B.
Exhibits 176A and B.
And may I publish, Your Honor?
Yes.
Ms. Gilman, 1979 and 1982.
Oh, we don't get to see the label on that one, and we just rush right through it, huh?
Again, Ms. Vallier, I'm sorry, Ms. Gilman, if you could zoom in just a little on the items themselves.
Another little piece of diffuser, it looks
And
like.
Ms. Vallier, what are we looking at in this photograph?
Photo of item 7-11.
These are photos, again, that you took in the lab during the course of your comparative or physical match analysis, correct?
Yes.
May I approach again, Your Honor?
Yes.
Guys, we still got 12, 13, 14, 15, 16, and 19 to get through. Oh, no, wait, they already did 19. So get comfortable. Put your feet up.
Do you recognize those?
I do.
And what do you recognize those?
Photos I took of item 7-12.
And
Don't worry, I'm taking the notes. You can snooze if you want. We'll recap it.
Yes.
If you could, please tell the jury what's the description of item 7-12.
Trace item, 14 glass and clear plastic, recovered from 34 Fairview Road.
Now the Commonwealth will seek to introduce in the minutes the next exhibit, A and B.
Exhibits 177A and 177B.
Your Honor, may I publish?
Yes.
Ms. Gilman, if I could have photograph 2015 and 2018. And again, Ms. Gilman, if you could just zoom in a little on the items. Thank you. And Ms. Vallier, again, can you describe what's depicted up on the screen?
It's a photo I took of item 7-12.
Your Honor, may I approach?
Yes.
Two other photographs. Do you recognize those?
I do.
And what do you recognize those?
Photos I took of item 7-13.
And again, one of the bag and then one with the items removed from the bag.
Yes.
And if you could, please tell the jury what is the description for item 7-13.
Piece of plastic, red and black, recovered from 34 Fairview Road.
I'd love to see you introduce in the next exhibit, A and B.
Exhibit 178A and 178B.
Your Honor, may I publish?
Yes.
Ms. Gilman, 1997.
Proctor bag
And
for February
2000.
8th.
And again, Ms. Gilman, if you could, please zoom in on the items. Thank you. And Ms. Vallier, directing your attention to the screen, can you describe for the jury what is depicted on the screen now?
A photo I took of item 7-13.
May I approach the witness, Your Honor?
Yes.
And 2 other photos. Do you recognize those?
I do.
And what do you recognize that?
Photos I took of item 7-14.
And again, one of the bag and one of the item removed from the bag.
Yes.
And again, can you please tell the jury what the description is associated with item 7-14?
Pieces of glass recovered from 34 Fairview Road.
I want to seek to introduce the next exhibit, A and B.
Exhibits 179A and B.
May I publish, Your Honor? And 2012. And again, Ms. Gilman, if you could zoom in on the item. And Ms. Vallier, as far as what's depicted on the screen, again, if you could describe for the jury what that is.
A photo of item 7-14.
May I approach the witness again, Your Honor?
Yes.
Other photographs, if you could recognize those.
I do.
And what do you recognize as?
Photos of item 7-15.
And again, one of the bag and one of the items taken from the bag, correct?
Yes.
And if you could, please tell the jury what is the description associated with item 7-15.
Piece of plastic, 3 clear and 5 red, recovered from 34 Fairview Road.
The Commonwealth seeks to introduce and admit as the next exhibit, A and B.
180A and 180B.
May I publish, Your Honor?
Yes.
Ms. Gilman, if I could have 2072.
The last exhibit that we're
Yes.
Yes.
And 2077, please. Again,
More
if you could zoom
diffuser?
just a little as far as the items are concerned. And Ms. Vallier, what are we looking at in this photograph?
Item 7-15.
May I approach again, Your Honor?
Yes.
Other photographs, do you recognize that?
I do.
What do you recognize that?
Photos I took of item 7-16.
And again, one of the bag and then one of the contents from the bag, is that correct?
Yes.
And if you could, please tell the jury what was the description associated with item 7-16.
Piece of plastic, red and clear, recovered from 34 Fairview Road.
I'm also seeking to introduce the minutes of the next exhibit, A and B.
Exhibit 181A and B.
May I publish, Your Honor?
Yes.
Ms. Gilman, if I could have 2036 and 2040. And Ms. Gilman, if you could zoom in just a little. Thank you very much. And Ms. Vallier, if you could, please describe for the jury what we're looking at in this particular photograph.
This is item 7-16.
Ms. Gilman, you can take that down. Now, with respect to each of these items that you examined in your physical match analysis, again, as far as the process is concerned, with the questioned items, what are you doing with reference to each of those questioned items first?
First, I document them as you've seen. I'll see if any of those within the item have a physical match with each other. And then I'll package that away and look at all the questioned items before I compare inter-questioned items to see if there are any physical matches in between all of the 7 items.
And as far as your notes are concerned, what is it that you're noting in reference to each of those items as far as what characteristics of the item are you taking note of?
I'll note the size, the color, and the material.
And what, if any, measurements do you take of each of those respective items as well?
I'll take the length and width of each item.
Now, with respect, starting with item 3-1, the passenger side taillight from the defendant's vehicle, sort of internally within that item 3-1, what did you conclude as far as your physical match analysis within that item alone?
Within item 3-1, I believe 4 of the pieces fit together.
And, Your Honor, if the witness may refer to her notes as to, thank you.
Does she not remember? She testified it was 4.
Yes, four of the pieces fit together within item 3-1.
And which 4 of the pieces?
Pieces A, B, D, and F.
And as far as the labeling of those pieces of an individual item, let's just start with item 3-1. A, B, D, and F, how are they labeled and how do you sort of physically label those items?
We have a label maker in the lab, so I'll print out the case number, the item number, and then A, B, C, and my initials, and that goes physically on each of those items, or all of those pieces.
So if any of those items had a sticker on it with a letter or something associated with that, that would be something that you did during the course of your physical match analysis, correct?
Yes.
Now, if I could turn your attention to item 7-5, piece of plastic red recovered from 34 Fairview Road. What did you conclude as far as your physical match analysis just within that single item?
There was no physical match noted among those 3 pieces of apparent plastic.
And when you say no physical match found from the different pieces within that item, what does that mean?
The broken edges of each piece did not align.
So the broken edges of the individual pieces within item 7-5 did not fit together with the broken edges of pieces within item 7-5, correct?
Yes.
Okay. Now, with respect to item 7-6, a clear piece of plastic recovered from 34 Fairview Road, what did you conclude based on your physical match analysis just pertaining to that item 7-6?
So this item was 2 pieces of colorless apparent plastic, and there was no physical match noted between those two pieces.
Now, with reference to item 7-8, red and clear plastic recovered from 34 Fairview Road, what did you conclude in regard to your physical match analysis just with the pieces contained within item 7-8?
So there were 14 pieces. Pieces C and D fit together, and pieces E and F fit together.
And when you say fit together, is there a term of art used within your field called a mechanical fit?
Yes.
And can you explain to the jury what you understand that term to mean as far as what is a mechanical fit?
So mechanical fit and a physical match are the same thing. It's when the broken edges align together to show that they were once a single item.
Now, if I could turn your attention to item 7-9, pieces of glass recovered from 34 Fairview Road. What were you able to conclude from your physical match analysis of just the individual pieces contained within item 7-9?
So this item had 3 pieces, and no physical match was found between those.
Turning your attention to item 7-10, red pieces of plastic recovered from 34 Fairview Road. What were you able, that is a single item, is that correct?
Correct.
So no physical match because there's nothing to match, it's just one piece, correct?
Correct.
And turning your attention to item 7-11, identified as 6 red, clear, and black pieces of plastic recovered from 34 Fairview Road. What did you conclude in regard to your physical match analysis just within those pieces contained within 7-11?
So that item had 6 pieces, and there was no physical match noted among those 6.
Now, turning your attention to item 7-12, which was identified as 14 pieces of glass and clear plastic recovered from 34 Fairview Road. Again, what did you conclude from your physical match analysis just from the various pieces contained within item 7-12?
So there were 14 pieces overall. Pieces B, C, D, F, and K fit together mechanically as one unit. And then pieces E and I fit together mechanically as one unit. And pieces M and N fit together mechanically as one unit.
Now, through your examination of these pieces in particular and other pieces as well, did you note any debris contained on the pieces that you located?
Yes.
And can you say anything as far as what that debris was, or was there any analysis done of that debris specifically?
I just note that there was debris present, and I package it into a tin that's retained with the original packaging.
Now, turning your attention to item 7-13, that was a piece of plastic, red and black, recovered from 34 Fairview Road. Is that correct?
Yes.
And again, just with respect to your physical match analysis of the various pieces of 7-13, what did you conclude?
So that item had 3 pieces, and there was no physical match noted among those 3.
And again, with reference to item 7-14, piece of glass recovered from 34 Fairview Road, that was again a single item, correct?
A single piece, yes.
So I'll turn your attention to item 7-15, 3 clear and 5 red pieces of plastic recovered from 34 Fairview Road. Is that correct?
Yes.
And what were you able to conclude from your physical match analysis, again, just from the various pieces contained within item 7-15?
So there were 8 pieces in this one. Pieces F and H fit together mechanically.
Turning your attention to, lastly for this purpose, item 7-16, piece of plastic, red and clear, recovered from 34 Fairview Road. What were you able to conclude from your physical match analysis just contained within the pieces of that single item 7-16?
So that item had 7 pieces. Pieces A, C, and D fit together mechanically.
Now, Ms. Vallier, once you had examined each of those pieces individually, what did you do next in your analysis?
Next, I compared all of the inter-questioned, these items 7-5 to 7-16. I compared them to see if there was a mechanical fit amongst those, between those items.
Mr. Lally, is this a good place for our break?
That's perfect. Yes, Your Honor.
All right, jurors, we'll take our morning break. We'll see you back here in about 15, 20 minutes. Thanks for waiting.
Wakey, wakey.
Just rise for the jury.
Wakey, wakey,
Can I see
everyone.
counsel for a minute, please?
She's going to see counsel for a minute. Well, so what all do we have today? We started off with that advisement from the judge to the jury. It's important for everyone to be able to hear and understand and evaluate the evidence. So don't make comments. Don't make facial expressions. What was all that about? There's a comment from Sue O'Connell, who's been in the courtroom this week. She says, regarding this morning's statement to the jury, while this is a very stoic jury, most of them are, you usually get a lot of poker faces, with the majority taking consistent notes, there have been 2 episodes of giggling during a sidebar by the same 3 jurors. A court officer stood in front of them last time it happened. One juror has what could be described as, quote, resting smirk face, unquote. And although he occasionally has a reaction, it doesn't appear to me to be disruptive or on purpose. There is always a court officer stationed behind the officers, and at least four, often six more stationed around the courtroom. So, I don't know. Somebody is not happy, I guess, with the jurors' reactions, jurors making visible reactions to stuff. So she's telling them, sit tight like quiet little church mouses. Don't have a reaction to anything. Somebody complained, guys. Don't know who. Then we got the stipulation by Hank Brennan that the two people that were present at the autopsy, the two troopers, were Connor Keefe and Trooper Watson. Don't know that we've heard Trooper Watson's name before. If any of you guys out there know who Trooper Watson is, do let us know. Is he in Connor Keefe's unit? What unit is he from? Wonder why on earth he's there if he's got nothing to do with this investigation. It was not Proctor. There's a stipulation to that. So the defense is agreeing it was not Proctor. Guess they have a reason to think that. And then that clip was played that, Karen's describing John was laying there. I approached from the left. He had a piece of glass that was perched on his nose. It was like a splinter. So she pulled it and it gushed blood down his face. That clip. Does that seem helpful to the Commonwealth? Blood gushing down John's face at the time that he is discovered, supposedly 6 hours after he was left out in the snowbank. Of course, it's not a snowbank. It's a cat's track worth of snow, but isn't all the blood supposed to be congealed or frozen by now? Don't know how this is helpful. So we get the DNA evidence from Andre Porto. Oh, I was looking forward to this because I remember this very clearly from the first trial. And to nobody's surprise, John's DNA is all over his own clothing and his own biological samples, like his fingernails. But the issue here is all of the unknown DNA that is all over him. It is all over his sweatshirt. It is on his shoes, all over his jeans, all of these stains that are mixtures of stuff. So mixture of 3, let's just go through it all. So start with the tail light. Remember, she swabbed all those outside pieces of the tail light, and she gets a mixture of 3 people. Including male, including John. Let's talk about what the mixture means real quick. How did they do it? How are they identifying it? When you say it includes a male, what that means is that, wait, we got something going on.
All right, Mr. Alessi, I'll hear you.
Oh,
you are
now
unmuted.
We're going to deal with the late discovery.
Thank you, Your Honor. Yesterday, Your Honor discussed with the parties, and parties were heard with regard to the issues we have raised with regard to the timing of the May 8th report from Mr. Burgess that the defense received on May 11th. And what I wanted to do, Your Honor, is briefly provide the information Your Honor asked for yesterday, which was how much time we might need under various circumstances. Okay. And so I wanted to take a few moments to put that in context. It will only take me a brief amount of time to do so. So, Your Honor, there is a timing issue, but there's most importantly a substantive issue. I will not, of course, go into the detail of yesterday, but the timing really is informed by the substantive issue. And so, with regard to the matter, we went back and we looked at more deeply the effect of this timing and this movement of the what has been referred to as clock drift in Mr. Burgess's report that we got on May 11th. I spoke of the significance yesterday, and here's what I would like to add as is relevant to the time we're going to need. I again urge the court to reject it substantively, because what we did was we went and we looked at matters such as the cross-examination of a key witness in this case, Jennifer McCabe. She testified with regard to observing a vehicle at 12:45 a.m. And that's a significant point. I know I don't need to elucidate for Your Honor. All of this is going in significant part, if not total part, to what has been as alleged a collision here, which we vigorously contest. It just no collision ever occurred. But the timing of it, the timing of what's alleged by the Commonwealth is very important. The seconds are important. Literally 1 second can turn not only the Commonwealth's theory completely around in circles and debunk it, but also the jury's analysis of it. And this is the point I wanted to elucidate today, is that the jurors have been provided information, and the defense has aimed its defense on this claim based upon, in large part, timing. So now what we have is on May 11th, Mr. Burgess changing the timing. So what does it affect? Not only witnesses like Jennifer McCabe, who we crossed, we strategized with regard to, but also my decision to not even cross Trooper Garino, because Trooper Garino had testimony with regard to when Ms. Reed connected with the Wi-Fi at One Meadows, and there's a certain time associated with that. We have Mr. Whiffen, who went through, the Commonwealth went through a timeline, and we believe they went through a timeline for the theory that they had, and I cross-examined Mr. Whiffen extensively with regard to that timeline. There were several defense strategies and effectuations of strategies based upon that timing. So with regard to the substance, Your Honor, and there's more, but I think that's a fair representation. It innervates our entire defense. The question now of Your Honor of how much time it will take the defense to react to Mr. Burgess, I wanted to say it's not only a reaction, but it's a substantive defense analysis, and 3/4 of the effectuation of that has already occurred through our presentation in terms of cross-examination. So we would have to, and we're still evaluating that, revisit all of that. And secondly, we would have to put that into the calculation of all of our witnesses that we've already prepared that are based upon that timeline. So it is a very significant point. And to the extent that the Commonwealth tries to argue, well, we never really committed that much to a certain time period. I again urge the court to look at the report of Dr. Judson Welcher, where he has 1162-2 with a specific range, 1238 to 43. And even in their range, it's a very small time, which further supports how each second matters in this regard. Now to the answer to the question Your Honor asked yesterday. Again, I urge that it just be rejected and we keep this trial moving in its current pace. To the extent that that does not occur, and again, we urge that it be rejected, the report, because it's a Rule 14 violation, there is no remedy for the defense. However, to the extent, and given Your Honor nonetheless asked me for an answer in time, we would need 4 days to be able to address it. We will not ever be able to recover strategically or substantively from it, given all that's been presented to the jury. And it will be very difficult to figure out how we're going to go present a defense after we've already presented to the jury our defense in our cross-examination. It's not really structurally possible to simply take 4 days and address Mr. Burgess, because we can't go back to all the witnesses I just mentioned and others and start crossing them in eliciting testimony with this new time period in mind. But I wanted to answer the question, Your Honor, respectfully. It would be 4 days for us to even go from where we are now and then try to alter not only witnesses such as Arca, but DeSogra and Gaffney and other types of witnesses that we have in that regard. So, Your Honor, respectfully, that is my response.
All right. Does the Commonwealth want to be heard?
Yeah.
Okay.
Respectfully, Your Honor, the defense is very confused. They attempt to confuse the issue. They attempt to confuse Your Honor about what the impact will be. This has never been a change. The government is not changing their timeline. The Commonwealth is not changing any information. The Commonwealth is not offering anything that affects in any way the testimony of witnesses. It's notable in the argument there is no relationship to the facts or the actual report that was provided. The Commonwealth has always provided the data, which they have, and they hadn't a chance to analyze. And the interpretation of the data has been different between the parties. We have been clear from the beginning at the time in which the infotainment system shows that there was a collision. We've been clear. And the data has been clear. That has never changed. That data in the telestream system is based on a clock in the Lexus, which both sides know full well is different than a clock in an iPhone. You can see all the productions of Dr. Welcher's PowerPoint presentation where it shows that time, 12:31:43, has never changed. Also, it has been clear that both sides appreciate that
But
there's
you're
a
changing it
variance
now.
between the clock in the Lexus, which leads to that system information, and a clock in an iPhone. In fact, the defense was so aware of it, they hired an expert, Mr. DeSorga, who gave his opinions about that variance. We have never suggested there was not a variance in this case. In fact, we have highlighted the variance. When their expert, Mr. DeSorga, provided a report, we believed that his analysis was wrong. And so we looked at the variance and the data that was available from the telestream system and John O'Keefe's Waze data that was on his phone that was always available to all of the experts in both sides. And when Mr. Burgess looked at the variance at the time of a three-point turn about 7 minutes before the collision, he simply matched the Waze information on Mr. O'Keefe's phone to that of the information from the telestream and saw that it was a 21 to 29 second variance. All that data was available to the defense because their expert made an improper conclusion is not our fault. This does not change the testimony of anybody. They point to Jen McCabe's text message where she said she thought she saw a motor vehicle out front that evening at 12:45. That is not consistent with the Commonwealth's timeline, but that doesn't change. That favors the defense. It does not change anything to do with ARCA. ARCA has not, as far as I've seen in any reports, ever talked about the variance, just Mr. DeSorga. And so because this is inconvenient for the defense, and because it further focuses the variance that we already discussed and provided, isn't a reason to exclude it. It's not late discovery. It's not a Rule 14 violation. It is further analysis of information that was already provided, opinions that were already provided, and it is in response to their experts' mistake about that variance. There's nothing new here. Nothing has changed.
Okay. Go right ahead, Mr. Alessi. The only question I had for you yesterday, for you to respond to today, was the time, so I gave you more leeway.
And you're giving me more leeway, and I appreciate it.
Go right ahead.
So 2 items, Your Honor. As I alluded to yesterday, and it's been a point that Mr. Brennan just made. we believe strongly, Your Honor, that at a minimum, there needs to be a voir dire of Mr. Burgess. And we believe strongly there needs to be a voir dire because we have a serious concern that the sequestration order has been violated. He has changed a very key aspect of this matter after the testimony of Mr. Whiffen, after Mr. Whiffen presenting a timeline. In his report, Mr. Burgess, his new purported report of May 8th, he references to align it with Mr. O'Keefe's cell phone. That is the essence of Mr. Whiffen's report. It is anchoring in his timeline. He did a whole timeline on Mr. O'Keefe's report. And conveniently, the proposed alteration by Mr. Burgess in his report of this clock drift now makes it very, very close to fitting within Mr. Whiffen's timeline and the theory of the prosecution. At a minimum, we need a voir dire to ask Mr. Burgess, why did he do what he did? Another reason for the voir dire. Mr. Brennan yesterday said, we were surprised to get the report. That further makes great concern as to why Mr. Burgess did what he did. Lastly, Your Honor, with regard to Mr. Brennan's point, and he made it yesterday and I corrected it, he said it again today, that supposedly our witness, Mr. DeSogra, made an error and that we're trying to correct an error of Mr. DeSogra. That is incorrect, Your Honor. Again, Mr. DeSogra was responding to Mr. Burgess's report. Mr. DeSogra's report is entirely saying, okay, Mr. Burgess says this, and therefore the defense says this. Now Mr. Burgess is changing what he is saying. So it is completely incorrect to say that Mr. DeSogra is trying to correct an error. That would require, again, Mr. DeSogra to change what he has done. Final point is this. There was also an issue, Your Honor, and this is extremely important with regard to burden shifting. There's not only the question of should this be allowed at all, there's not only the question of how much time the defense will need, but there's a third and important issue, and that's burden shifting. What Mr. Brennan proposed yesterday was a very irregular process where essentially the Commonwealth gets 3 bites at the apple for a problem that they caused. The problem we're talking about is Mr. Burgess changing a significant part of a timeline. Yes, there was a variance that he had, but he picked a range of the variance. He's now changing the variance. So what the Commonwealth is proposing is that our witnesses go forward, the aperture gets to wait, they come on, and then the aperture gets to come on yet again.
I did not understand the Commonwealth asking me that. Are you asking me to do that, Mr. Brennan?
That's what he said.
I'm not sure what he's saying, so.
It sounds like DeBrosia or whatever.
His name is DeSogra, yes.
DeSoder, you're suggesting that the Commonwealth suggested yesterday that
they
he
did.
testifies first and then the aperture witnesses?
That's exactly what they
What
said.
I understood
Rebuttal.
was going to happen is Mr. Brennan said yesterday that Dr. Welcher cannot come in until after.
No, I didn't understand that. I understood Dr. Welcher, Shannon Burgess, and then Dr. Welcher for everything that you folks received prior, that January 31st, or whatever the date was. And then potentially for all the new ARCA information that came in May 7th, that portion, Dr. Welcher returning on rebuttal for. Not that they were holding back Dr. Welcher completely. Is that correct, Mr. Brennan?
That's the conversation I had. That conversation I wasn't part of.
Yeah, I think you misunderstood that, Mr. Alessi.
So just so I'm clear, what is it that the
Mr. Brennan, all right, this is separate, and I'd really like to give everybody a break here. What is it the Commonwealth is asking to do regarding that?
Regarding Mr. Burgess or Mr. Welcher?
Which, Dr. Welcher?
Dr. Welcher should come in and testify to his PowerPoint, all of his opinions, which address all of the prior representations and opinions of ARCA, although we still don't have any raw information, but we're ready to move forward. Regarding any new opinions, which there is over a dozen new opinions that includes testing, video, experiments, Dr. Welcher should have enough time to review, conduct his own testing, turn it over, and then in rebuttal, address limited to the new issues raised by ARCA.
That's how I understood it, Mr. Alessi.
And that's how I did also, but the question is now with the Burgess changing of the clock drift, how many times is the Commonwealth proposing that Dr. Welcher gets to come in and talk about that? Is he just going to come in and talk about it?
So you talk with Mr. Brennan about that. All right, so I'm all set for this.
There are no changes. There is no changes in the timeline. He keeps trying to portray this as something has changed. Nothing has changed. It's the exact same. He's always said there's a variance. He's been looking into the variance for a long time, and now he has found a method to show the exact variance. It's not changing. There's nothing in the report that changes as far as the timeline. That's just an attempt to cause fear. There's nothing that has changed. We can look at the reports. It's all the same, always has been, other than now he's identified the mistake of their expert, and that led him to be able to identify the variance, which is helpful and new. And the suggestion that there's been some violation of an order, no good faith basis whatsoever.
Does the Commonwealth oppose a voir dire just on that one issue?
Yes, because it's suggesting that there's a good faith basis for it. Nothing has changed. Ian Whiffin's report was available to the defense and our experts months and months and months ago. The issue of variance has been an ongoing issue for months. There's nothing that triggers a change in the testimony to adopt or adapt to it. Our timeline has been the same since when we turned it over at the beginning. They cannot point to one thing that has changed between Dr. Welcher, Ian Whiffen, Jessica Hyde, or Shannon Burgess.
The time that they say things happen?
Saying things without a good faith basis. In the reports, show us where something has changed.
Your Honor, to inform you, Your Honor, we would like to print the page in the clock adjustment because what Mr. Brennan says is
Yes,
correct.
and I'm happy to any information. All
Change.
20 minutes.
No.
right, thank you.
All rise to the court, please.
So there we saw once again Hank Brennan taking control of the courtroom and Judge Cannone doing absolutely nothing to to indicate that she's the one in charge in there. He just hops himself right up to didn't we talk before about how we weren't going to impugn, throw personal attacks at the other side? It's not necessary to argue that they're, making stuff up, but now we're going to go on a whole soliloquy about all that. Between these two people, you guys in the chat, who do you think is more likely to have it right, Mr. Alessi or Mr. Brennan? Who do you trust to be accurately representing to you what the facts of the situation are? I know what my answer to that is. And he's going to print the pages. He's going to print the pages to show it. So she's all set. Okay. So are you going to rule then? Does that mean you're going to rule? Oppose a voir dire. He's going to... I think Hank is going to obstruct himself out of getting what he wants. This is where you see the different strategy between the sides. Hank is going to concede nothing, give no inch, no matter how reasonable it sounds. The defense is trying to be reasonable, and so that means they make concessions, even though there's no possible way we can fix our defense to be able to review everything and reevaluate. Take us at least 4 days. The more you concede, the more likely the judge is going to be to give you the middle ground. That's why Hank doesn't concede anything. No middle ground, not acceptable. It's good, no good faith basis for them to argue that there's a change here or nothing. If there's no change, why is there a new report? If there's no change, why is there a new report? Can you answer me that? Why would there be a new report if there's no change? Of course there's a change. It's facially absurd. Of course there's a change. There's a new report. Well, guys, frustrating her. we were talking about DNA mixtures before we broke back into that court session. So let's go ahead and get back to that. Let's go ahead and get back to that recap. We were talking about what they found. So starting with the taillight, the passenger taillight, mixture of 3 people, including male DNA. So what they're looking for to be able to identify male DNA in any profile is they're looking for a Y chromosome. They can identify, because everybody has X, right? Men and women have X, but if a Y shows up, that means there's a male contributor. So when they say it includes a male, it does not mean it doesn't include females. It just means they found Y chromosomes, so they know there's at least one male in there. Mixture of 3, how do they identify the mixture? Everybody has two copies of the genetic information from each parent. So each allele that they're looking at for these short tandem repeats, which is just the sections of the gene that they look at for identification. These are parts of the gene that don't contain coding information. They don't tell anything about like what protein is going to be produced or, what trait you're going to have or anything like that. What it is it's just parts on the genome where there will be random numbers of repetitions. And so I don't even know like how to explain this because it's super technical and maybe it gets into more detail than is helpful here. But like, okay, so at a genome, you have A, T, C, and G, right? Adenosine, guanine, thymine, I forget, A, T, C, G. And so let's say you have at this spot, you have an A from dad and a G from mom. And so at this spot, this particular allele will contain a number of repetitions of that, and it will be random. And it could be AG, 3 repetitions. It could be 8 repetitions, AG. And so what they do is they look at the different numbers of those repetitions because it's highly variable. It mutates very quickly, so it's good for individualizing who the DNA is from. You don't inherit the same number of repeats from your parents necessarily, so just helps be able to use that for identification. It's like a super 10,000 foot view of the STR. So each allele, you have a certain number of repeats. And each person is going to have, one piece of genetic information from the mother, one piece of genetic information from the father. So at each location that they're looking at for these STRs, each individual is going to have 2. So if they spot three areas of this DNA, they know it's got to come from more than one person, because each person can only contribute 2. So if they find 3, that means there's at least one more person. If they find 5, that means you've got at least 3. You've got at least 3 because each person can only contribute 2. So you got 2 of 2 plus 1 extra. You've got at least 3. So that's how they're identifying a mixture, and that's how they're identifying if one is male. Does not mean there's no females in that DNA. It just means that the male is easy for them to identify. Another question that comes up a lot: what do they do with these unknown samples, these unknown contributors? Interpreting mixed genetic profiles gets extremely complicated because it depends on how much information you have about each separate profile. And that can depend on what's the quality of DNA that's being contributed in here. If a person has just shed a skin cell and it's a partial DNA profile, very limited information, might only have 1 or 2 alleles. But it could be enough to show you that person contributed because it just happens to be the allele that's in addition to the primary contributor. So it's enough for us to see that there's 3 people, but there's not enough information to be able to distinguish, that profile for meaningful purposes. Sharing 2 alleles is going to be far, far, far more common than sharing 13 or 20 now is the number of points that they look at on the genome for comparison purposes. So it's less likely to be meaningful. It's also can be very difficult to sort out which profile is even what. What we have is we have a graph that shows us at each allele what kind of signal strength are we getting from each one. And so we can identify, okay, there's more than one contributor at this particular allele, but we don't know necessarily how to sort out what the rest of them are, like which came from which contributor. So it can all get very, very complicated interpreting mixtures. It's very statistical. So that's like an inherent problem in evaluating mixtures. Then as far as like, why don't common question, okay, you have taillight passenger DNA with unknown contributors and you have shirt DNA with unknown contributors. Why don't you compare those two against each other? The lab won't do that. They won't compare two unknown samples to each other. They will only compare a sample, including a mixture of a sample, a mixed source sample against a known profile. So might make sense to be able to say, hey, is the DNA in this mixture the same as the DNA in this other mixture? Or that would tend to indicate these are the same contributors to both mixtures, right? They won't do that. They will only compare to a known profile. So only if you get, for example, Brian Higgins's DNA or Brian Albert's DNA, will that then be compared potentially to the unknown contributors on the mixed profile. Broad overview of all that. So taillight passenger, we had a mixture of 3. He did not get any DNA from the root end of the hair. Okay, this speaks to, remember, skin cells or what's in the root end of the hair. That's why they look for that. This speaks to the weak signal strength that comes from skin cells. If you only have a few, you're not necessarily getting a lot of DNA. This is why touch DNA, like a term that I hate, is not necessarily helpful a lot of the time. I've talked about this before, the difference in signal strength between blood and trace DNA. Blood, if you have a drop of blood, that drop of blood is absolutely full of cells, and it's full of cells that contain DNA. The white DNA, white blood cells contain a massive amount of DNA, in that volume of blood. Relative to if I go by and touch something, I go by and I touch something, even if the whole surface area of my skin touches and sheds every single skin cell, it may not still be enough as that entire volume of blood. And the reality is it doesn't shed that much. You might shed, a couple few skin cells. It's going to depend, shutter status is an important part of evaluating trace DNA and the sourcing and so forth. But so you're generally going to be talking about, if you have touch DNA versus blood DNA, you're talking about a very, very rich source of DNA in the blood that's going to give you a lot of information, a very strong signal, versus maybe a few cells, extremely weak signal. And so that's why I'm very, very skeptical. And this was discussed at the Delphi trial by, the state's own experts. When DNA suits them, it's very useful. When it doesn't, it's not. Suddenly there's all kinds of problems with it. This was discussed by the expert in the Delphi trial. If you have blood, the signal is so strong that it's very likely to drown out the very weak comparative signal that you're getting from a little bit of trace DNA. So that tends to suggest if you find a mixture in blood, it's not likely to be blood and a few skin cells. It's got to be something else with a relatively comparative signal strength. So other blood, other saliva, semen. These are very strong biological sources of DNA that a few skin cells are not. So no DNA from the root hair, despite it being skin cells. So they sent it off to Bodie. Exterior of the broken drinking glass, mixture of 3, including male, including John. then all of the stains on his jeans, mixture of 3, mixture of 3, mixture of at least 2, mixture of 3, mixture of 2, mixture of 4, all on the jeans. John being on his own jeans, no shocking to anybody, but 3 to 4 other people on the jeans? What's all that about? What's all that about? Because we're talking about blood, this is where I think it's significant. They're swabbing the stains. All the stains tested presumptive positive for blood. That's what Maureen Hartnett has testified to. I don't remember if she did in this trial, but she did in the first trial, certainly. So if police, law enforcement, prosecutors want to discount somebody's DNA being on an item of clothing, what they can point to is there are studies that show trace DNA can be passed through the laundry. You can, washing clothes together or going to the laundromat, for example. This can be a source of other people's DNA on your stuff. So when they don't want the DNA on your stuff to be significant, they can point to things like that. Oh, well, somebody's DNA can end up on the laundry, or you're out walking around in the community and it's out there in the environment. It could end up anywhere. Maybe if we were just talking about trace DNA and trace DNA, I'm not sure that I buy that explanation when it comes to blood as a source of DNA, and then some other contributors. But this is just, how they will try to seek it out, have it both ways. The issue with DNA right now and the trace DNA technology is that it's so good, it's almost become meaningless. You can pick up so much information. The detection is so sensitive to be able to detect DNA that it's detecting stuff that may not have anything to do with direct contact, direct deposition. We are learning more and more all the time about how much DNA is just out in the environment, how it passes between people and between items. We used to have this, clear, black and white, easy, simple worldview of, an item will not contain your DNA on it unless you touch it or you, bleed on it or something. And we know now that is simply not the case. You can have a conversation with somebody in a room and never touch them, and your DNA will end up all over each other. The reality is much more like Pigpen in the Peanuts comment. That is what we are like with our DNA. So that's the story of the jeans. From all these stains that were taken from, also the unstained areas, by the way. But the stains and then the unstained areas, yeah, lots of contributors on those that are not John O'Keefe. Then we get to the sweatshirt. First one is a single contributor, that's John. Next is a mixture of 2. Then a mixture of 2 in the unstained areas. So multiple people again on John's sweatshirt. John's own DNA being in his own blood on his own sweatshirt. Not a surprise to anybody. But what's the explanation for the other DNA? Sample from stain on the right instep of his shoe developed a profile of at least 5, mixture of at least 5 on the stain from the instep from John's shoe. The rest, not suitable for comparison. They can't interpret more than 4 contributors to a mixture because at that point there's too much noise. You can't sort out who contributed what. It's too statistically complicated. You can't get anything that is more likely basically than other potential scenarios there. So that's why they can't even say if John's DNA is included. There's too much DNA here. It's too complex of a mixture. So they're not able to analyze that. They'll only interpret up to 4. There are some private labs that will purport to analyze more complex mixtures. They'll have different methods to be able to do that. Don't know if we'll see any of that from the defense or anything like that, but that's why no confirmation of John's DNA on his own shoe. But At least 5 people. Then we have the profiles developed from his t-shirt and other profiles developed from his sweatshirt, from the stains that are just John. Again, not surprising that John's blood is on John's clothes. Still not entirely sure why we're talking about blood being on John's t-shirt at all, when there was no blood on the inside of John's sweatshirt, so it did not seep through onto the t-shirt. So when was his t-shirt exposed to blood spatter? When did that happen? Then the fingernails, both of the fingernail samples were John. You know, shocker. John's DNA is there on his own hands. So cross-examination, you know, it's good, gets right to the point. You don't know who the other people are. The other people, let's go through each of these items. Those other contributors, what's his answer? It could be anybody. It could be anybody. You have no idea who it is. It could be anybody. And you never compared any of this to Brian Albert or Brian Higgins. Then at the end, that question, you never even got their samples. Objection to that. That's sustained. Why? Why? You were never asked. You were never asked to do that comparison. You were never provided with the samples to be able to do that. That seems perfectly legitimate. Goes to Bowden. Failure to investigate alternative theories. And then the report sent to who? That's objected to and sustained. Michael Proctor objected to and sustained. I mean, I don't know who can make sense out of this. I really don't. If anybody can make sense out of this ruling and why they're not allowed to ask who requested this analysis and how that does not go straight to Bowden and the quality of the investigation, I don't know. Really don't know. Thank you for the clarification. Adenosine, guanine, cytosine, thymine. It's been a long time since AP Bio. Didn't necessarily remember them all off the top of my head, but yeah. ACTG, those are the amino acids that make up the genetic code. Then we started with Ashley Vallier. And she's the one who matched all the pieces of the taillight together, took those photographs. It was excruciating. Yes, indeed it was. So I did my best to take notes of what we had. The very interesting thing I thought was how the first one... Not including the taillight. The taillight we know was taken by Maureen Hartnett, but 7.5 or 7-5, 7-6, 7-8, 7-9, 7-10. These are all items that are dated February 4th, 2022 and initialed by DMD, Trooper DeChico, whom we've heard absolutely nothing from, hasn't been called as a witness, hasn't been identified as being at any of these searches as far as we know. Maybe he was at the dig out one. Was he at the dig out, the planned excavation that Buchanan talked about? Trooper DeChico's hands are on this, so we don't know of these first items. We don't know who collected what when. This is encompassing presumably the cert stuff, the Berkowitz piece, various items that were found in the following days. And it's a total of what? 1, 2, 3. I didn't catch the number of pieces in bag 7.8, but it was a few. Let's call it 5. It's more than that, but let's call it 5. So now we're at 8 total. 6-inch. I don't know. I'm gonna have to go through and try to reconstruct some of that, I guess. But we got a whole bunch of numbers, different pieces of plastic, and it's all just kind of mixed together by Trooper DeChico, Who knows what is what, because it hasn't been kept separate and handled and identified clearly what the source was and when it was obtained and where and so forth. So she's gone through then all of these individual items, and only a few of them match internally. But the closer we get toward the end, the more of them start fitting each other, which I find very interesting. So starting with bag 7-12, which is the one that Buchanan went and collected, one of those, I think February 4th or thereabouts. That's about when things start to match. There was one earlier from bag 7-8, which was just a, David DeChico, Trooper DeChico, February 4th. No idea when or, what the provenance of those pieces are. Had two C&D and E&F fits in there in those pieces. But otherwise, it's not till we get to Buchanan that pieces start fitting together, and then there's a few fits. Then there's a few fits. So make of that what you will. And when we get back to Ms. Vallier, we will be talking about, after trying to piece these individual items together from each bag and finding out what fits and what doesn't, now she's going to compare them all to each other and do the reconstruction of the taillight that we have seen before. And then, then we got the arguments. So frustrating. Defense is very confused. Didn't you, or haven't you told them to cool it off multiple times? Knock that shit off. It's not necessary, not helpful. But, here's Bev not taking control of her courtroom when the Commonwealth wants to do what they want to do. Not the first time we've seen that. 1231.43 has never changed. That literally came out of his mouth. 1231.43 has never changed. It sounds like you're changing it. Sounds like from what you said yesterday, you're changing it. And it's now 1232 something. 21 or 29 seconds later. Now it's 1232 something. So saying it isn't a change when it's a change, this is, they think we're stupid. They think we're stupid. It's Ipsy Dixit. We have to accept it because he says it. He says there's no change from 1231.43, even though apparently the report's now going to say 1232 something, and that's the whole point. That's the whole point. And of course, it's the defense's fault. All of this is their fault because their expert made a mistake. That's for the jury to decide. It's for the jury to decide if their expert made a mistake. But you got their expert's report. You got their expert's report in time, in compliance with with the discovery requirements and deadlines. So why is this coming up on May 7th? Yeah. I'm sure everybody would like to know that. When was the discovery deadline for the defense, by the way? Wasn't it like back in March? So the voir dire that's now been suggested by Alessi, that's going to be it's a potential way for Judge Cannone to weave a path through, want to give the Commonwealth what they want, but also kind of want to make it look like we're taking the defense seriously, want to make it look even-handed. We can have a voir dire and then not find no problem. But that could be risky because it sure does sound like, this change happened because they realized, oh shit, there's a conflict with what Ian Whiffen says and the timeline that he's generated. So sounds like the problem is Ian Whiffen's mistake, if anybody's, doesn't it? If you Commonwealth are saying your timeline is your new timeline now, you figured it out. It's 1232, not 1231, and that's not a change, even though it is. That's somehow Mr. DeSogre's fault. Sounds more like it's Ian Whiffin's fault, doesn't it? Because that's what you're trying to reconcile now. Trying to reconcile his timeline with Burgess's timeline. Was Burgess the guy who didn't know the difference between the what was it, gigabytes, and I don't even remember now. He didn't know what the quantity, the measurement was for the digital information. Filed a very embarrassing pleading where the defense had to come in and correct that. I think you have a little speaking of fundamental misunderstandings and confusion. Was that this guy, or was that I think it was. Yeah, bits and bytes. He confused bits and bytes of data. And so imagine that there was like thousands of times more data available on this thing than in fact that there were. So if anybody generated this problem for the Commonwealth, kind of seems like it's Whiffen, isn't it? Because that's the problem that he's addressing. That's the problem that was called out on cross-examination. And that's why you're struggling to go, oh shit, better fix that problem. Because yeah, anybody with a thinking brain can see it's a problem if you're trying to say Karen's car hit John O'Keefe and then he went and locked his phone. That is going to be a problem. But that's giving her a little bit of a pathway. Yeah, at a bare minimum, there should be a voir dire. And you know what else at a bare minimum there should be? If she is going to let this in, and she's going to look for every reason she could to possibly allow it. Bare minimum, if she does that, they get to cross on everything. They get to cross on all of it. They should absolutely get to cross on how many times the theory has changed. Here we are now, 3.5 years in, almost at the conclusion of the Commonwealth's case, 4 weeks into trial, and they are still only just making up their minds about what they think happened when. That they proceeded with a different theory in the first trial. Then they hired a whole new people, because that one didn't work. That one was so ridiculous that they hired a whole new set of people for trial number 2 who came up with a theory. And then we started cross-examining their witnesses and exposing how their theory is trash. And so here they are changing it yet again. That's the timeline. Bare minimum, yeah, they should be able to cross on all of that. Lay all of that out for the jury. That's their case. That's how many times they've changed their mind. That's how much they have to dance to try to force this evidence to fit their theory. And in spite of that, every change they make, every adjustment, they come through and try to force that square peg into that round hole. Just creates another problem for them, doesn't it? They can't come up with a cohesive theory because there was no fucking collision. Now you want to bump it back to 1232? Now you got a problem with the connection to the Wi-Fi. So yeah, we're getting Guarino back up. No question about that. That's allowed. Because we have a different timeline problem in that case. We have a timeline problem no matter what. So pick your poison, Commonwealth. You want the timeline problem of, the accident preceding the lock button? Or you want the timeline problem of Karen needing warp mode on her SUV to make it back to One Meadows Avenue at 12:36. Well, we know which one they want. They're like, well, we'll take that second one. Why? Because the second one, can we show that it's inconsistent with the medical evidence and the laws of physics? Oh no, I'm sure they can come up with some excuse. Oh, she drove like a maniac. Somehow nobody saw this, not captured on video anywhere. Seen their ability to go in and canvass this entire town. They had her car on video. How many different locations the next morning? when they're trying to trace her, trying to suggest she went back to 34 Fairview before she went to Jen McCabe's house. Never able to substantiate that at all. But it doesn't stop them from trying to put that implication out there. They got video from all over this town with her car going by so that they could try to make that case. Where is it of her going home, going back to One Meadows Avenue that night? Where is any of that? When in normal driving conditions on a normal day, 4 minutes would be probably an unrealistic drive time to get back to One Meadows Ave. Now we're going to do it in a blizzard. We're going to do it in this whiteout condition, the snow falling, starting to get heavy, starting to accumulate. Right when it starts to accumulate, that is the worst time to drive because you have the layer on the ground, the layer on the road. It's like, even if the road's been retreated or if it hasn't, the road is a little bit warm. The first little bit of snow falls, it hits it and melts. It melts and then it freezes and you start getting the slush. And that's when things are extremely slick. Once you get a nice accumulation of snow, you can get fairly decent traction on snow, at least until it gets real compacted and then it becomes real icy. But that first little initial bit, when you have all the grease on the road, the grime on the road, it's mixing with that liquid, it's extremely slippery. So that time frame, Karen's going to have to drive at warp speed, below red lights, whatever, to get back to One Meadows Avenue in that time frame. Seems pretty unrealistic, but maybe that's a lesser evil to he got hit by a car and then checked his text from Jen McCabe and locked the phone. So it's a pick their poison. They're scrambling and, yeah, they should get the voir dire at a bare minimum. They should get the voir dire whether she allows this testimony or not, because they should be allowed to explore. Are we sitting over here violating the sequestration order? If experts, as the Commonwealth wanted, are not exempt from the sequestration order, then he should have no idea what Mr. Whiffen has testified to. And his timing, his inclination to go through and make that correction when he made that decision to do so, we should be able to lay that out. And there should be a perfectly innocent explanation as to why Ian Whiffen's timeline that has been in his report since December of 2024 suddenly needs to be addressed now, nearly at the end of the Commonwealth's case. There should be a perfectly innocent explanation for that, and a good one justifying that delay. Unless, of course, he was listening to the testimony and only then realized, oh shit, we have a problem. Yeah, because the defense is putting on a defense based on the position you committed to prior to trial. Bev's all set, but we have no ruling. Let's get back to...
All right, so Mix Vallier, I'm going to ask you that you speak right into your microphone when you answer, if you could, please.
Okay.
Thank you. All right, Mr. Lally, go right ahead.
Thank you, Your Honor. Now, Mix Vallier, we talked about sort of the physical match or mechanical fit analysis that you did with regard to each of the items individually, correct?
Yes.
And can you explain for the jury the process that you undertook in your physical match analysis between different item numbers?
So between different items, amongst the questioned ones, I only compared the pieces that were large enough to have a label on them. Some pieces were quite small. I utilized several benches and divided them up into sections for each item, and individually pulled out all of those pieces. And then I had another bench where I did the actual comparison. I started with all the pieces of the same color and looked to see if any of those had potential edges that could match.
Now, with respect to items 715 and 716, did you do a physical match analysis between those two separate items?
May I look at my notes?
Yes.
Okay. Yes.
And what, if any, conclusions did you come to in relation to your physical match analysis between item 715 and item 716?
Two pieces from item 7-15, F and H, fit mechanically with two pieces from item 7-16, F and G.
And what, if any, conclusion were you able to draw with reference to the physical match between pieces from item 715 and pieces from item 716?
Those four pieces were at one time together as part of a larger unit.
Now, Ms. Vallier, what physical match analysis did you do with reference to items 7-6 and 7-11?
So one piece from item 7-6, piece B, fit mechanically with one piece from item 7-11, piece D. So those two pieces were at one time together as a larger unit.
And Ms. Vallier, with reference to items 7-8, 7-9, and 7-16, what, if any, conclusions were you able to draw from any physical match analysis you did between pieces from those three items?
So two pieces from item 7-8, pieces C and D, one piece from item 7-9, piece A, and one piece from 7-16, piece E were found to have a mechanical fit. So those pieces were at one time together as a larger unit.
Lastly, for this section, at some point did you do a physical match analysis for the glass pieces in items 7-12 and 7-14?
Yes.
And what conclusions were you able to draw from your physical match analysis between 7-12 and 7-14?
There was no physical match between the glass pieces from, or parent glass pieces from 7-12 and the glass piece from item 7-14.
Now, Ms. Vallier, are you aware that there was an additional analysis that was done with respect to glass pieces and other glass pieces that you didn't examine in your analysis at your lab?
I know that there was other trace work done. I'm not sure exactly what the work was.
Okay. And do you know who performed that additional trace work?
Christina Hanley.
And who is she to you as far as in reference to your work at the lab?
She's my supervisor.
Now, with regard to each of these items individually, they came as labeled in individual bags as we demonstrated on the screen, correct?
Yes.
Okay. And with respect to those bags, did you note any particular date associated on the front of those bags?
That's documented in my photos.
And all I'm asking here is that with respect to each of those bags of items, whether they be 3-1, 7-4, 7-5 or 6 or 8, many of those bags had different dates on them, correct?
Yes.
Okay. And when you received
And
those
many
items
had the
in
same
that
dates.
bag, you essentially removed the items from those individual bags, placed them on the table, and examined them, correct?
Yes.
And that examination included a microscopic examination?
Yes.
Now, with respect to any of those items, there were some items that pieces within the same bag that had the same date on that bag did not fit together mechanically, correct?
Yes.
However, there were items from one bag collected on one date that did fit mechanically with items from another bag collected on another date. Is that correct?
Yes.
Now, if I could turn your attention to item 3-1. Again, for the jury, what is the physical description associated with item 3-1?
Item passenger side taillight, Massachusetts 3GC 684.
Now, did you perform a physical match analysis with pieces from item 3-1, 7-5, 7-6, 7-8, 7-10, 7-11, 7-12, 7-13, 7-14, 7-15, and 7-16?
I compared them, yes.
And what, if any, conclusions did you come to from your analysis, your physical match analysis between item 3-1 and all of the items beginning with the number 7?
There was a physical match with, do you want me to list?
If you
all
could,
of them?
please.
Okay. So 2 pieces from item 7-5, 4 pieces from item 7-8, 1 piece from item 7-10, 4 pieces from item 7-11, 2 pieces from item 7-12, 2 pieces from item 7-13, 4 pieces from item 7-15, and 4 pieces from item 7-16 were found to fit mechanically with item 3-1.
And what, if any, conclusions
So
were
that
you
means
then
there's
able to
leftover
draw from your
plastic?
physical match analysis between item 3-1 and each of those respective items beginning with the number 7?
Those pieces were once together as part of a larger unit.
May I approach, Your Honor?
Yes.
Where I'm showing you 3 additional photographs. You recognize what's depicted in those?
I do.
And what do you recognize those?
This is a comparison between item 3-1 and those pieces from all of the other pieces.
7-15, for example, is 8 pieces.
Introduce and admit as the next exhibit.
Only 4 of them were found to
Any
match.
objections, Yanetti?
No objection, Your Honor. Thank you.
It's 182A and C.
And may I publish, Your Honor?
Yes.
Ms. Gilman, if I could have photograph 2096. And Ms. Gilman, yes, if you could even zoom in just a little bit more on the item itself. Ms. Vallier, what are we looking at in this photograph?
So those pieces that I labeled from item 7 all of those, they all fit together mechanically into this piece.
And as far as earlier, you were testifying as far as the label maker and the different various pieces that you would label throughout the process of your physical match analysis. Do you see these in this photograph as well?
I do.
And where are they located with reference to the
I see 12 total
reconstructed piece
labels.
above?
They're those little white rectangles on the piece.
And so what's depicted here is the mechanical fit between items 7-5, 7-6, 7-8, 7-10, 7-11, 7-12, 7-13, 7-14, 7-15, and 7-16, correct?
Not items 7-8 and 7-14, but the other ones, yes.
And why not those 2?
They didn't fit mechanically with the other pieces.
Ms. Gilman, if I could have 2150. And again, if you could just zoom in a little. And Ms. Vallier, what are we looking at in this photograph?
So on the right side was that piece that was just shown. And on the left side is item 3-1.
And lastly, Ms. Gilman, if we could have 2151. Again, if you could zoom in on that item, Ms. Order. And Ms. Vallier, what are we looking at in this photograph?
So that's that right piece on top of the tail light from the previous photo.
And is this the mechanical fit that you were testifying about earlier with reference to item 3-1, the tail light housing, and all of the various pieces that were found in 34 Fairview, starting with the number 7?
Yes.
Isn't that interesting?
Thank you. Ms. Gilman, you can take that down.
708 and 714 didn't fit mechanically. 78 fit mechanically to
Ms.
itself.
Vallier, lastly, in
Several
reference,
pieces.
did you also receive some debris from John O'Keefe's clothing?
Yes.
And Mr. Officer, we can have the lights back on. Thank you very much. And what did you find contained within that debris from John O'Keefe's clothing?
So there's 5 different items. So it was debris collected from, labeled as coming from the clothing. There was mostly debris, some apparent fibers.
Were there any pieces of apparent plastic contained within the debris?
Yes.
Was there dirt contained within the debris?
Yes.
And that debris was labeled as an item 17-18.18, is that correct?
I believe so.
And what is it that you did with the debris from the gray long sleeve shirt and the orange t-shirt?
So those are all packaged in like glassine folds. And I looked through it and documented it.
When you say you documented it, did you look at it under a microscope?
Yes.
So you did an examination under a microscope, is that correct?
Yes.
And did you measure some of those items contained within the debris?
Yes.
Specifically, did you measure items of apparent clear plastic contained within the debris?
Yes.
And what did you measure those items to be?
The piece of clear apparent plastic was approximately 1/8 inch by 1/16 inch.
And once you had conducted your preliminary analysis of those items, where did those items go?
I did no further examination on this myself. Christina Hanley might have examined some of these further.
Thank you. I have nothing further.
Okay, Mr. Yanetti?
Thank you very much. Good afternoon.
Good afternoon.
I'd like to first talk fairly briefly about your reconstruction of the taillight to which you've testified. At the outset, by the way, that was item 7-3.1, am I correct?
Sorry, for which one?
That's the taillight, this 7-3.1, am I correct?
3-1, I believe.
7-3-1?
There's no 7 on it.
The taillight is item 3-1.
Oh, 3-1. I'm so sorry. Okay. With regard to that particular item, your lab has different departments, correct? Criminalists who do different things, correct?
Yes.
You are aware that there are scientists within your lab who do DNA analysis, for instance, correct?
Yeah. Yes.
And with regard to the order of processing items, is the DNA analysis done before or after you get the item?
It's usually before.
Okay. In this case, it was before. Am I correct?
I believe so.
Were you made aware that there were 3 contributors of DNA to that taillight, 3-1?
How long were you made aware of that?
No.
Once you reconstructed the taillight, you'll agree with me that it was missing a piece, correct, or pieces?
There was an empty spot on the overall reconstruction, yes.
Were you ever provided with any pieces of taillight that would have filled in that missing spot?
No.
Were you ever provided or told about any pieces recovered from 1 Meadows Ave in Canton?
No.
Were you ever told about a collision at 1 Meadows Ave in Canton?
Sustained.
In any case, you'll agree with me, there was no glass in that taillight at all, correct?
Within the taillight, I classified them as apparent plastic pieces.
There's no glass as part of the taillight, correct?
I mean, it depends on what you call, like, the bulbs usually have glass as far as I'm aware.
Those are very, very thin glass though, correct, those bulbs?
Yes.
All right. Now, your lab received clothing in connection with this case. You've testified to that, correct?
I received the debris labeled as coming from the clothing. I never saw the clothing at all.
Right, but you're aware that your lab received clothing before the debris got to you, correct?
Yes.
And your understanding was that that was John O'Keefe's clothing in which he was found on January 29th of 2022, correct?
It's labeled as coming from him. I'm not sure of the date that it was found.
Okay. You understand the procedure of that goes on at your lab when it receives evidence?
Yes.
And you know that once clothing is brought to your lab, it's given evidence numbers, correct?
Yes.
And then one of your colleagues at the lab handled the clothing and or examined it, correct, before it came to you?
Yes.
And your understanding is that one of your colleagues retrieved debris from those items of clothing and then packaged it in a fold before it got to you, correct?
Yes.
You then open up the fold and you look at the debris, correct?
Yes.
You never saw that debris inside the clothing, correct?
Correct.
And the pieces of clothing that come in are given evidence numbers when your lab receives them, correct?
Yes.
For instance, the orange t-shirt was given or was named item number 7-17.
Yes.
And the gray long sleeve shirt was item 7-18, correct?
Yes.
And your lab is accredited, correct?
Yes.
There is a complete chain of custody from the moment the clothing was brought to the lab to when the debris was removed from the clothing, ultimately to when you're in court today handling the items, correct?
Yes, our in-lab chain of custody extends from when we receive it to when the submitting agent, it is returned to the submitting agency.
Okay. And you have complete confidence that the chain of custody at your lab is effective at making sure that the evidence does not get lost or mixed up or contaminated, right?
I mean, the chain of custody is meant to track where a piece of evidence is. The evidence unit also does inventories and audits to make sure that things are where they're supposed to be.
And you have confidence in your lab's chain of custody policies and procedures, correct?
Yes.
But you'll agree that your lab cannot control who handled the clothing before it arrived at your lab, correct?
Yes.
There are times in which crime scene technicians or criminalists from your lab actually participate in the search for evidence at a crime scene, do they not?
Some of the people at the lab are crime scene responders, yes.
There are times when they actually take custody of evidence. Again, I'm talking about people from your lab, professionals. They take custody right from the crime scene and transport that evidence to your lab, correct?
Yes.
In those circumstances, your lab would have a complete chain of custody from discovery to seizure to testing or whatever comparison you're doing until you release the items, correct?
Yes, but the electronic chain of custody doesn't start until that item is entered into our LIMS system at the lab.
Right, but when it's entered in, it would be entered in as having been seized by somebody from your lab, correct? In the hypothetical that I'm giving you.
Yeah, there's an evidence submission form that says that this crime scene responder submitted it to the laboratory.
There are other cases, however, when the evidence is brought to your lab by the police, correct?
Yes.
Local departments have access to your lab?
For evidence drop-off, yes.
The state police have access to your lab for evidence drop-off?
Yes.
And in this case, it was not a criminalist or other professional from your lab who seized the clothing and brought it to your lab, correct?
I'm not sure.
Do you have a record of that in your report in terms of who it was that brought the material to your lab?
I could look at the evidence submission form to see who.
With the court's permission?
Yes. Okay.
Oh, let me guess. He wants to approach because it was Michael Proctor. We're not going to be allowed. Not going to be allowed to identify Michael Proctor's hands all over everything yet again. Maybe what date that was. Is this the March 14th, March 9th, something like that? Some stuff came in March 9th. Other stuff didn't come in until March 14th. Quite intriguing that seems like there is in fact quite a bit of plastic recovered that doesn't fit the taillight. 4, 8, 10, 12, 16, 18, 22, 23 pieces. She went through and identified 2 pieces from 7.5, 4 from 7.8, 1 from 7.10, etc. I wrote all that down. 7, 11, 14, 16, 20, 24. 24 pieces out of, what do we have in total? 46, 47?
All right, go ahead, Mr. Yanetti.
Having reviewed your reports, can you testify to the jury about who it was that brought this evidence into the lab?
So you can tell us.
Okay. So submission 7, all the items that are 7- was submitted by Trooper Michael Proctor.
Were you aware of the date of the incident that gave rise to this case?
Yes.
And what was that date?
January 29th, 2022.
Were you aware that the clothing that you received was seized from the Good Samaritan Hospital that very day?
No.
What date was the clothing brought to your lab?
March 14th, 2022.
So that means that your chain of custody at the lab began on March 14th of 2022, correct?
Yes.
And would you agree with me that was about 6 weeks after the date of the incident, January 29th of 2022?
Yes.
And of course, you can't speak to the chain of custody from January 29th to March 14th of 2022, correct?
Correct.
And you have no information and do not know why Michael Proctor waited 6 weeks to bring this clothing to your lab, do you?
Sustained.
Do you know where Michael Proctor stored this clothing during that 6-week period?
No.
Do you know how often he was alone with access to the clothing during that 6-week period?
Sustained.
Do you know if he had access to pieces of red or clear taillight during that 6-week period?
Objection, strike.
Sustained. Move on, Mr. Yanetti.
You were not present when the clothing was seized, correct?
Correct.
You did not have custody of this clothing from January 29th of 2022 to March 14th of 2022, correct?
Correct.
You do not know what was done with the clothing before it arrived at your lab, correct?
You've covered this, Mr. Yanetti. Move on, please.
One last question.
Okay.
You cannot vouch for how the clothing or taillight pieces were handled before they got to your lab, correct?
I cannot.
Anything further, Mr. Lally, or are you all set? I'm not curbing it.
No. Very good.
Got to get something in. Repeat something from your direct examination, please.
Mr. Lear, there is a
really a
separate
redirect.
evidence unit contained within the Massachusetts State Police Crime Laboratory, correct?
Correct.
And fair to say you have absolutely nothing to do with that, correct?
I'm not a part of that unit.
And so your responsibility as far as chain of custody is concerned is from when you retrieve the item during your analysis and then when you return the item to the evidence unit, correct?
Correct.
And from that analysis that you performed, you found that there were 10 different items, starting with the number 7, that were a mechanical fit to 3-1, the taillight housing from the defendant's vehicle, correct?
If it's 10 items, I don't have.
Less than I counted from the labels.
As far as all those items beginning with 7 that you went through or elucidated on your direct examination, each of those were a mechanical fit to each other and then to the taillight housing in 3-1.
The pieces that were previously stated, yes.
Nothing further.
All right.
Which I got is 23 of the 47 or whatever. Interesting. A lot of unaccounted for plastic there.
All right, so jurors, that is it for today. I am told when I spoke with counsel earlier that we are still on track.
Still on track.
I have to tell you those same cautions. Please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. Be extra careful with your social media use. And also, I just want to remind you, next week, Thursday is a half day and Friday is a day off. All right, so we'll see you on Monday.
Please rise for the jury.
Thursday next week is a half day and Friday off.
Yeah.
So we knew this was going to be the most brutal of the weeks. And even still, we got no court on Wednesday, half a day unexpectedly today. What a schedule in this courtroom. So what does that mean? It means that there's probably nobody left that the Commonwealth intends to call besides the aperture people, the one that we're arguing about.
Okay. So before we recess, I appreciate that counsel provided me with the information. Mr. Alessi, I got the 2 reports that you had that were incorporated in what the Commonwealth had given me a few minutes before, but I appreciate that it was pointed out here. We've had full argument on this yesterday and today. My findings for the record are that the defendant has not persuaded me of undue surprise or unfair prejudice by this information, and I don't find that there's delayed disclosure. Of course, all of this is ample game for cross-examination, certainly as to what Mr. Burgess knew, what he looked at, why he looked at it, when he looked at it, why he changed his report, and violation of the sequestration order is all for cross-examination, and I will give you a lot of leeway with that, Mr. Alessi, but I'm not having a voir dire on that. Mr. Alessi, I can tell you, obviously, you've got a great facility for cross-examining on the underlying information here. You've done fulsome cross-examinations. I have every confidence you can do it here again. But if after the direct you demonstrate that you need further time, I'll certainly hear you on that. And more importantly, perhaps, if you feel that the testimony of Jen McCabe and the others that you've mentioned is critical and that you need to recall them, I'll hear you on that as well. So regarding Dr. Welcher, as my understanding, the request yesterday was for, and it's been a request, I think, a few days. We've addressed it at Sidebar, and I found that it wasn't the right time. Let's see how much Dr. Welcher could go through. I understand Dr. Welcher will testify in the Commonwealth's case in chief next week or so, Mr. Brennan.
Hopefully next week, if not
All right.
the day after the holiday.
And that will be for all of the material that was provided to the defendant initially, right, by the Commonwealth's discovery deadline?
Correct.
And what you're asking for is that after ARCA testifies the new information, you're asking for rebuttal, right?
Yes, limited to the new information.
All right, so I would allow under these circumstances a limited rebuttal, and we can define the scope after we hear the testimony of ARCA. So those are my rulings. Your objections were noted. I'll see everybody on Monday.
All rise for the court, please.
What do we say? What did we say? She's going to look for every reason, not even going to find a violation on it. Nope. Nope. No undue surprise. No discovery violation. It's a brand new report. Brand new report with a new time. But that's the court we're in, guys. That's the court we're in. No grave concerns about any of this. No grave concerns about possible violation of the sequestration order. Oh no, you can cross-examine on it, Mr. Alessi. You're fully competent to do that. No, hey, Mr. Brennan, you can cross-examine ARCA all you want. Cross-examine them all you want about the time frame, communications, payments, etc. No, we're gonna have our dear ARCA voir dire twice. Between last trial and this trial. But no, we're not going to make Welcher come in and the Commonwealth bear the expense of that extra process resulting from producing a report on the 4th week of trial. 3rd week of trial. Guess they technically produced it in the 3rd week of trial. Yeah, guys, are we shocked? Are we shocked? No, of course we're not. Of course we're not shocked. We knew she was going to do that. We knew she was going to give Mr. Brennan whatever advantage he wants to try to get for himself. She's going to give him both. Yep, you can absolutely, by all means, change your theory 4 weeks into the trial after the defense has already relied on your timeline that you'd established. And you can go ahead and have extra rebuttal too. Why not? Why not? Under these circumstances, why not? We'll just go ahead and bend the rules. Make sure you get every possible advantage you can try to get, because we're conducting this trial like it's really just like the same kind of puzzle Ashley Vallier was putting together, trying to fit all these pieces into a taillight. Well, we're trying to fit all this information into Karen going to prison. That's how this trial is being conducted, as if the trial process is merely a formality to put somebody in prison. So we just got to find the right way to make that happen. Just got to find the right way to make it happen. So, yeah, not a whole lot there after the break, other than sure seems like from that testimony, there's an awful lot of plastic recovered from all over that lawn on 34 Fairview that doesn't match the taillight. I wrote down 2 from 7-5, 4 from 7-8, 1 from 7-10, 4 from 7-11, 2 from 7-12, 2 from 7-13, 4 from 7-15, and 4 from 7-16. These are all the pieces that she found physically matched with 3-1. We saw the taillight as it's reconstructed. Not a whole lot of extra stuff there. Just that one little square section at the top that sure looks an awful lot like where there might have been an issue in that dash cam photo. Where the problem seems to be in that dash cam photo. So that's what I wrote down from her testimony. When I add those up, 4 plus 4 is 8, plus 2 is 10, plus 2 is 12, plus 4 is 16, plus 1 is 17, plus 4 is 21, plus 2 is 23. 23 pieces of plastic out of the 46 or 47 or whatever the total was is all that matched, according to her testimony. A lot of leftover plastic. Weird that that would be all over the yard, isn't it? Weird that there would be mystery plastic from some unknown source. Somehow they're revealing itself as the snow melted all over the yard. Intermixed with the pieces of taillight from Karen's SUV. How peculiar. What a strange and unusual set of circumstances. I was dying to know that at the first trial. I was dying to know what was there any leftover plastic? It was not laid out this clearly and this systematically last time. A little more all over the place. This makes it much easier for me to follow. 23 of the pieces of plastic matched to the taillight. The rest did not. What about all those great big pieces? How many of those great big pieces fit the taillight? Sure would love to know. What's interesting, let's go back here because kind of caught this before when I was looking at the notes. Let me just flip back through real quick. So bag 7.6, 7-6, which was the one that, it was one of the ones that DeChico had initialed on the bag, dated 2/4/22 on the evidence tag. It had the two clear pieces of what looked like the diffuser. None of that matched to the taillight. None of that matched to the taillight. Yeah, but then, you know, little bits and pieces from everything else. But approximately half the plastic collected, half the number of pieces collected, did not apparently fit into the taillight. Very peculiar. And of course, it's all intermixed. So found on different times and different locations. It's not like everything that they found on those later searches all fit the taillight. So mix of things all over the yard as the snow reveals itself. Some of it's matched to a taillight, and some of it is a mystery taillight, apparently. Huh. Does this support my theory that CERT just needed to find something? They didn't need to find her taillight. They just needed to find something. There at that scene that had been unsecured all day, any taillight would work. Any taillight would work. It doesn't have to be. We don't have to worry about. We don't have to worry about the timing of how do you get Karen's taillight from the Canton PD Sallyport over to the over to 34 Fairview before CERT team starts showing up. It can be any taillight. There just needed to be some taillight there in the road for them to find. Right there in that little 1 square foot area. That's all they needed to find. It could be any taillight. The plot thickens, guys. The plot thickens. I guess I always forget my banner. I guess we're done with the case now. Well, you know, hey, we got a short day. Let's start going through what you guys have thought for the day. Yeah, we're done for the day. Don't ask me why. Cannone Rue Court has gifted 10 memberships. Well, thank you for that. Appreciate the support for this channel. We're not a Rue Court over here. Cannone Rue Court. Your commentary plus Alessi's formidable precision makes my brain sparkle. Well, we like to share that joyful feeling you get when you know something, you learn something. You put pieces of information together and it makes sense. It's part of what we're trying to do here. So thank you so much for that nice comment. Summertime, treat yourself to something yummy this weekend. You deserve it. Thanks for sharing your knowledge with us and for dedicating so much of your time to us, helping us to understand law and how it all works. Appreciate you. Well, thank you so much, Summertime. It's very sweet of you. I appreciate you guys too. Very much appreciate your support. You guys, I got to tell you, the yummiest stuff I get is when I get Jeff able to spend some time in the kitchen. Like I'm kind of spoiled for treats outside the house now. It's it's a serious first world problem to have a husband who makes really, really good food. I can't eat a Caesar salad in a restaurant anymore, guys. Once you've made it at home, and then you've got a husband who's just got it nailed. Oh, it's so good. You can't eat that terrible Caesar salad in the restaurant anymore. But I'll tell you what, summertime, you know what I do need? You know what I do need? I need some new hand wraps, for boxing. I could use a little punching some stuff out. Wasn't able to make it in this week, just not enough time, too many other things going on. So I'm going to be going in tomorrow and getting myself a little punching therapy. So if that's all right with you, I'll wait for Jeff to have time to make me something yummy, and I'll make sure my hands are protected so I can go punch it out. Melissa Garcia, I listened to Jackson's closing to go to sleep. That monotonic time is ingrained into my brain. This defense team is amazing. Good morning, Andrea and Jeff. Yeah, I remember that issue with the monotonic clock. This is no surprise. This did not come up with the new trial. They have known this since before. Richard Green brought it up in his testimony. If it's in his testimony, that means it was in his report that was turned over before the last trial. So none of this is new. None of this is the defense's fault. We're being asked to just accept his word for it. Forget your own memory. Forget what you saw and watched the first time. Mr. Brennan says there's been no change. So that means 1231 to 1232 is in fact the same thing. Adam K., the defense said yesterday they plan to take only 1.5 weeks. Does that leave enough time for Proctor, Alberts, and experts? I think if they're tight, yeah, it should. That would be 6, 7, 8 days if they can get 2, 3 witnesses in per day. It's quite a few witnesses they could call. So yes, it varies. How much time each one takes, but 1.5 weeks should give them a fair amount of time. Now, granted, we're already past the Commonwealth's estimate, right? Commonwealth estimated 3 to 4 weeks. Here we are at the end of week 4. They still haven't rested. And not only are they now talking about we might call the Aperture folks next week, we might actually not call them till after the holiday. So we might be talking about week 6 that the Commonwealth is still presenting their case. So doesn't really sound very on track to me. But I suppose if the Commonwealth takes 6 weeks and then the defense gets their 1.5 weeks, we're still within the 6 to 8 that was estimated. They should have a fair amount of time, and frankly, if it takes them more time, they should get as much time as they need, because they have not driven the train as far as where we're at right now. What I don't like about that is all this advisement during the Commonwealth's case. It's fine, guys, we're on track, even though we are technically now not on track. We are now past their time estimate. So if the jury goes late, they've been told all this time, it's fine, guys, we're right on schedule. But then if we go long, they're going to blame the defense for that? That's a little bit of a problem with the commentary. Jennifer Devine, do you think the jury will catch on the Bev? Don't know. I mean, you have to wonder if the jury is noticing. Like, hello, we already know about Michael Proctor, and why don't you want us to hear that Michael Proctor is the one who submitted this evidence to the lab? He's the one that got the report. Why don't you want us to hear that? Surely they're wondering that. Oh, they'll be instructed. You can't draw any inference from it. You can't consider any of that as part of your deliberations, but we're human. Surely we're going to wonder, what's with not being able to ask these questions that seem pretty logical? I have to wonder if they're catching on to that. All this stuff that's happening with ARCA and Welcher and all of these motions and stuff, the jury knows nothing about this. This is happening outside their presence. They're being told, don't read the news, don't, read about the case in the social media. So if they're following that, they should not know anything about any of that. So there's nothing there to catch her on, to figure her out. It would have to be just based on what's happening in the courtroom. We might have to wait until it's the defense case and then, get a chance to compare what's she letting them do versus what she letting the Commonwealth do. How's the objections being handled in that context? Might take that for them to, if they get a sense of things being maybe a little bit off kilter, a little bit off balance with the treatment, it might take us getting to the defense case and saying, gosh, they're not allowed to present this stuff. Weren't allowed to ask questions when the Commonwealth was putting on their case. Now on theirs, they're not able to put stuff on. But jurors tend to think very highly of the judge. We heard it from Juror Ronnie, guys. We heard it from Juror Ronnie. Even that jury that, according to many of the members, was going to find Karen Reed not guilty on counts 1 and counts 3, so didn't buy the Commonwealth's case. They still thought very highly of Judge Bev. Enormous respect for her. So I got to tell you, I'm skeptical. I'm skeptical that they will. They just don't typically have the background in the legal system to be watching this and recognizing that there's any kind of problem here. They assume it's her courtroom. She's in charge. She's doing a good job. So if there's a problem with the way the parties are behaving, it's the parties. The parties are causing the problem. Reality check. If both sides choose to call proctor, can defense call corporal to testify regarding firing and get the rest of text messages in? They'll be able to get the rest of the text messages in if they call proctor. The corporal, I don't think is going to be a pathway in because it's hearsay, with respect to him. With proctor, it's impeachment. It goes to his bias. So I don't think that's necessarily a backdoor way to get it in. But if anybody calls proctor, then it's going to come in. The issue, I think, has to do with authentication and then the hearsay exception. What's it being used for? So if it's being offered to show his bias, his chats with his buddies, then that is going to be a permissible impeachment. That's a non-hearsay purpose, not offered for the truth. So I think that makes sense to me as the step that they would likely take. TCP, how does it work on the remedy of keeping the old position? Wouldn't sticking to the old position result in stating things you think are wrong? You're stuck with the position you took. That's the bottom line. You get to testify about the position that you took in your report. This is the result of what you did. You reported it. You reported it. So that is going to be, surely, now that we know it's going to be allowed, it's going to be cross-examined on. Here's the difference between the first report and this report. So you were wrong when you reached that conclusion because now you have a new theory. Now you have a new time. Alyssa Ramirez, I learned that when the sirens pass by, the stenographer does not go wee 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 into the mask. They write parentheses siren heard and said like the stream. They do. Sometimes you'll have the little parenthetical. Often it's inaudible. When they can't hear something, they'll just put in inaudible. Rarely happens when they're live transcribing because they'll just ask them to repeat or ask them to slow down like they have been doing. People talk over each other. It happens a lot when they're transcribing from a recording. If you have the FTR system they have in this court, it's, picks up the mic feeds, and sometimes people just make transcripts from that. very common in that situation to have sections that are inaudible because they don't use audio engineers to set up their sound systems in courtrooms, and people don't always have good mic discipline. They wander far away from the microphone, sound echoes through the courtroom, et cetera, et cetera. So very common in recorded to get the little parenthetical inaudible. But you'll also sometimes get little parentheticals if, other things are happening. So yeah, siren heard. That would, not going to try to get that down verbatim. But they may very well note that that is happening and that's why they're pausing. Ian Kelly, remember, a defendant's right to a fair trial is paramount to everything. Bev, yeah, that's pretty much what she said, isn't it? It's paramount. It's paramount. Unless we're 3/4 of the way through and we're not sure if she's going to go to prison yet. We got to make sure she's fairly sent to prison. That seems to be Bev's thought process. Isabel Park, how many witnesses does the defense have? We don't know how many they're going to call, but they had, let me see, I can go ahead and pull it up and count. They had 57 on their own list plus 37 in common with the 60 on their own list plus 31 in common with the Commonwealth. So 91 total witnesses on their list. But very unlikely that they're calling all of those. Just like with the Commonwealth, a lot of these they're just preserving the right to call them if something comes up, or if you need to shift strategy midstream, for example. Keeping the option open. So most of those, they probably, weren't intending to call as frontline people. Don't know how many they will actually call, but we can anticipate certainly plenty of experts. I'm definitely anticipating Proctor, anticipating Higgins too at this point. I think the defense is very likely to call both of those. The ghost of Brian Higgins' SIM card. And now a word from our sponsor. You guys, I don't know if this is a YouTube ad reference, but I don't control the ads on YouTube. YouTube runs ads whether I monetize the stream or not. They run ads on their content. So the way around that is the YouTube Premium. That's just the system that we have. Hypnotizes lobsters. Is Bev saying a juror made the A comment? Oh, I don't know. I don't know if that's the implication that it was a juror that got picked up with the asshole. Try not to call people assholes in court. Comment on it. Could be implied. She didn't come out and say that, but that might be implied. Lizard of Oz, from what I gather, Trooper Watson is actually Trooper Tully. Yeah, I don't know. There's so many bald heads in the MSP. I in my mind's eye, I confuse Tully and O'Hara all the time. They're both like these little Irish bald thumbs. They look like the same guy. And that's part of why in my mind, I have a little bit of trouble sometimes sorting out what Tully testified to, because Tully was also the head of the CERT team, right? But it's been O'Hara that's testified about the CERT team search. Get a lot of that confused in my mind because these guys look like an amoeba that split. A cool breeze. Commonwealth goes from anti-science solo cups collection to full-on science DNA analysis like the two aren't incompatible. I would be insulted as a juror. Well, it's just whatever suits them at the moment, right? The science is good when it helps your case. It's bad when it doesn't. DNA evidence is really critically important when you want to use it to suggest it means something, but when applying that interpretation would undermine your theory of the case, now the DNA is meaningless. So it's all contextual and self-serving, guys. And that's part of why, given that this is an adversarial system, okay, you got two sides trying to win within the rules of the game, right? Within the Marquess of Queensberry rules, so to speak. You got both sides trying to win, putting on their best position, their best interpretation of the evidence. That's why nobody has a monopoly on facts or truth or who's right or who's wrong. You commit to a position, you present that position to a jury, and the jury decides what the truth is. The jury decides based on your position that you've committed to. That's how the system works. So that's why it's such an issue to not have to commit to a position. Just be able to go ahead and revise things pretty much at the end of the road. That's why that's a problem. Stormy, if the defense watches, I would suggest to them to make sure jury knows body won't bleed if dead for a period of time in cold. Most don't know that. Yeah, I would hope that this kind of thing would come out from the defense's forensic pathologist. You know, all of the critique of the versions of events and so forth. Just the very fact that Karen ended up with blood all over her face from doing the CPR on John. Shouldn't be bleeding, shouldn't have blood. Should be congealed or frozen. No longer actively bleeding, certainly. So I would like this kind of detail to be followed up on as well. Tracy Chappelle, do they have all police officers' DNA on file? I don't know if they do. It's not uncommon. Certainly in a lab, they typically will have all of the lab personnel's DNA on file. And that's because if they get an unexpected result, the first thing they'll do is go and check, hey, did we get contamination from somebody in the lab? Because it's, despite all this testimony about, oh, we change gloves and we clean the bench and we only have one item out at a time and so forth. Nevertheless, DNA technology is so sensitive. It doesn't take much. Not hard to do. Not hard to contaminate a piece of evidence. And so it does happen. Not uncommon. Not really, that infrequently. So they'll run it against the people in their lab to check for contamination. Whether or not they have the police officer's DNA on file, it's probably just going to vary. Where are you? What's the policy? Sounds like in this case they don't, because they went and specifically got the swabs from Proctor and Buchanan. And they didn't testify about it, but we know from the first trial that's because they compared it against the taillight. Tried to see if they could match either of them to the taillight. Did not match. Summertime, Andre Porto, the fast talker, best witness ever. He's extremely helpful for the defense, isn't he? Extremely helpful for the defense. Established that there is a bunch of unknown DNA, potentially male, all over these stains on John's clothes, all over the blood on his clothes, on his shoe, also on the taillight. I don't know how you get to, place significance on John's DNA being on the taillight. That must mean he got hit by the taillight. But pay no attention to these other two unknown profiles. Why are they there? How are they there? How do you distort logic in your own mind to think that's a good position? That's what I'm going to do. I'm going to just ignore this other unknown evidence, and I'm going to attribute John's DNA being there because I say there's a collision. Even though there's no blood or tissue or anything on any of it, anywhere. It's really nuts. Trump him. So now the other contributors are not male or female contributors like in the first trial. Well, more cheating. I'd have to go back and look specifically at the first trial. But typically they are identifying the presence of males just based on the Y chromosome. X's, males or females can have them. You don't know. You don't know who the contributor is. So if you have only X's, it's female. But if there's a Y in there, you have at least one male. So Jen's Nefarious 507 called to Coco. From memory, the defense were not allowed to test the items. Can they legally challenge that? I think they should do MVAC testing to see if they can get better results. Could they? I don't recall that they requested it. Normally being able to do independent testing of items for DNA is routine. It's routinely allowed. It can be a little bit logistically challenging because you have to coordinate, who's got custody, where is it going? Is anybody accompanying it? Is anybody watching the testing while the defense is doing it? prosecutors get their panties all up in a wad about, the chain of custody. We can't let it outside of our chain of custody. That would be quite ironic in a case like this, wouldn't it? Once again, the chain of custody only matters when you want it to matter. So I don't recall anything specific about the defense trying to do this, trying to do independent DNA testing. In fact, if I remember, there was some issue about just what, the defense has limited resources, especially for experts and stuff like that. DNA testing can be extremely expensive. Reprocessing evidence can be extremely expensive. I kind of vaguely remember a comment from somewhere about not doing DNA testing because of the cost. Oh, it was the carpet. Karen, I don't even remember where this information came from. Supposedly Karen has some of the carpet from the basement at 34 Fairview. I don't know what the provenance of that information is or if it's valid or not. But supposedly no testing because just they can't afford it at this point. Yeah, if anybody remembers what that's all about, let me know. I have no idea if that's something that's just, a rumor that floated around the internet or, what the source is. So my recollection is I don't remember defense trying to do this. They should be allowed if they did try to do that. Ethan Morgan, 3 individuals, you say? Anyone else ruled out? No, they did no other comparisons. No other comparisons. Interestingly, too, that is another area. They say this other stuff is not, these other contributors are not suitable for comparison. Only the main one that we can identify as being John. Private labs, there's a lot of different ways to not just analyze the results of the evidence, but to, I don't want to say tweak because it sounds like you're distorting it. It's just that there's a lot more subjectivity that goes into DNA testing than people necessarily realize. So some of this, for example, the amplification process, how much of this DNA are you copying? And then if your issue is I don't have enough quantity of these other individuals to be able to make that determination, that can be fixed. You can just amplify more of it. Now you have enough. Now you can use it for comparison. If the problem is you don't have enough alleles, then that's going to present a different issue. But sometimes there is room for labs with different parameters for how they do this type of testing to get different results, do different analysis. So once again, defense potentially, if they had the resources, to be able to exhaust every avenue of investigation, could have had these mixed profiles looked at. Potentially go and, do a little trash pilfer like the police do. Go, pull Brian Albert's drink cup out of the trash that he leaves it in. I wonder if he's leaving his drink cup in public trash these days. Wonder about that. All on the table, potentially available, but of course you got to have the resources to be able to do that. Ask your mom as a YouTube member. Hey, welcome. You're gonna find this a familiar and comfortable surrounding. Welcome to the channel. Kevin Eldridge, somebody gifted me a membership yesterday. Thanks for that. Thanks for your work, Andrea. Thank you, Kevin. And yeah, we appreciate everybody who gifts those memberships. It's so generous. It does nothing but just benefit the other people in the chat, turns the whole chat green. Very grateful for your support. It makes it fun and exciting for everybody. Oh, and then you get the emojis. You get to use that bonsai emoji. Fun stuff, guys. BB McD, it could be worse, guys. We could be enduring the financial info from the Murdoch trial. Yeah, I didn't watch the Murdoch trial. This sounds like it was probably excruciating. There's almost always stuff like this in a trial. The technical stuff. A lot of times it just makes people's eyes roll back in the back of their head. This takes me back to Delphi when they were doing the ballistics, right? The quote unquote ballistics, where they're comparing the unfired but cycled shell cartridge that they found in the dirt at the murder scene, at the crime scene where the bodies were found, to the fired spent shell casing from Richard Allen's gun. And they did this on, I think it was a Saturday. It was one of the Saturday half days or something, I think, if I remember correctly. Anyway, everybody was like dozing off. Not me. I'm like there. I'm taking my pages and pages of notes. I love the technical stuff. But I do recognize it can be a little bit dry. And if you're not super into it, it can put you in a bit of a lull. The rural juror, I feel like PC for a warrant for the DNA of the people in the house would be easier after the DNA results came back for multiple contributors. Maybe. I mean, once again, if the lab is taking the position that none of these other contributors, those profiles are not suitable for comparison, then you're going to have the extra step of the defense being able to establish, well, we have some other methodology or some other additional testing that could then make it suitable for comparison. Because if they don't have anything to compare it to, don't know that you really have a basis to go and get their DNA. But I agree with you in the general principle, especially if you can get an expert to be like, yeah, there's no way if you're taking swabs from a blood stain on a shirt that this is picking up like trace from the laundry. Seems highly unlikely. The rural juror, why is Yanetti not allowed to ask about profiles not tested or compared? Isn't this the kind of foundation they have to lay for Bowden? It is, in fact, Bowden. What police did not do, what investigators did not do, that's the Bowden defense. That's the Bowden defense. Why are they not being allowed to ask questions to establish a Bowden defense? Your theory is as good as mine on that one. Because yes, it seems like they should be able to ask about leads that could have been followed up on and were not. And the standard in Judge Bev's courtroom seems to be, unless it's on some inverted video somewhere showing Brian Albert and Brian Higgins beating up John O'Keefe and throwing him into the front lawn, that you can't infer that from the evidence you have of stuff like John's location showing him going by the house, the problems with the timeline on the phone, John's injuries, the Ford Edge being parked out front. Can't make that inferential leap. That's not enough to put suspicion on them. That seems to be the standard in her court. Unless it's captured on an inverted video that's provided, after long after the discovery deadline, then it doesn't count. Yeah, they should be allowed to do this. This is Bowden. Honey Kid, why no female DNA? Guessing Karen touched her car. It is not ruling out female DNA. It is only ruling in male DNA, just based on the presence or absence of the Y chromosome. So that's really all it's saying. It's not saying no females. Skippy 1, no DNA from left shoe. Are the shoes actually his? It was the right instep, right? So only the right shoe. I don't know if they even tested the left shoe for DNA. Forget which one was which now. Which one was at the hospital? Which one was at 34 Fairview? That got all confusing because Buchanan was confused about it. I know it's out there. And, that was circling for a little bit. I forget which one was which. But what I remember from the first trial is that the testing, the swabbing for DNA all pretty much originated from stains. And so with the clothing, they also swabbed the unstained areas, the main pieces of clothing. But the shoes, I don't recall any indication that they did that. They just looked for stains and then swabbed those. And that was kind of what drove their decision to do DNA analysis of the different items. So with the shoe, this was the stain that I think it was Maureen Hartnett had found. She didn't get asked about it in this trial, but it was from a stain that she had found. So perhaps the other shoe was not stained. I don't know. I don't have an answer for this. What they decided to test and why, I don't have an answer for that. Honey Kid zoning out. Did a juror call Bev an asshole? That was what I thought the first time I heard it. Love all you do. Need tree pics, no nudes. Oh, yeah, definitely. Well, the trees are going to be a little nude. Trees go through a nude state every year. In fact, the deciduous, you're really supposed to show them in their nude state. If you go down the rabbit hole of like getting super into bonsai, okay, and you start looking at like the Japanese competitions, the shows, the formal shows and stuff like that. The biggest one is the Kokofu Tien. It's typically in January in Tokyo. This is like the biggest one. It's old. It's like the emperor will have his trees in this show. Really amazing trees in the show, but it's in January. Another big one is the Taikon Tien. That's in November. This one is known as a little bit more of the practitioners, the bonsai professionals will kind of put their trees into this. So they might be doing experimental things with techniques and new shapes and designs and stuff like that. That's what the Taikon Tien tends to be known for. That one is in Kyoto in November. We're talking about the season when the leaves are off the tree, and that's the most common way to see the bonsai. It's like the conventional way to show. Even the deciduous bonsai, they don't have any leaves on them, but that's the whole point, to be able to see the branch structure and see how this tree has been miniaturized is really the goal. You get the proportions of it. It's intended to look like a full-grown tree, preferably like a full-grown ancient tree with lots of character that has been miniaturized and shrunk down into this pot. So conventionally, look at the bonsai trees nude. So, but I don't have nude trees right now. The trees are all fully leafed out. I'll take some and share some, get some of that out. I'm behind, guys. They need work. It's just sort of a constant. I don't know if the juror called Bev an asshole. I really hadn't considered that possibility. I know somebody mentioned it. Maybe it was a juror. But it seems like the juror wouldn't. It just seems like the jurors are so far from the mic. Like, how would a juror whisper be picked up by a mic? I don't know. Maybe it's possible. It seemed likely to me it was the prosecutor, because she's probably sitting there at a table near a microphone. Just easier to have that hot mic moment. The mics should be pretty far away from the jurors, so you have to whisper that asshole pretty loud for that to get picked up. But I can't say it wasn't. I don't know. Cafe Ol J. Can the defense do DNA test for people that were at the house? They would have to get the source of the DNA. They would, they would have to get everybody at the house, get a DNA sample from them. If you're going to do that through the discovery process, you're going to go through that, special Massachusetts rule where you have to get authority from the judge to do third-party DNA. I don't think Judge Bev is going to let them do that. Right? She's not going to let them do that. She's going to say, no, there's no nexus to these third-party culprits, and it's private information and intrusive and medical and so forth. So she's not going to let them do that officially. So now you're in a pilfering their trash type of situation. Yeah, you can. The feds get to do it. Local law enforcement gets to do it. You throw something in the trash, you are considered to have abandoned it, and they can follow you around and pick it up and test it for DNA. And use that for their sample. It's one of the things they did with the Long Island serial killer. They followed him through Midtown Manhattan, watched him throw away, I think, a piece of pizza crust. DNA tested that, and that's part of what broke the case open. So they'd have to do something like that, independently get the samples. Then they'd have to file their motion to get access to the evidence, submit it to their own lab, do their own independent DNA testing, and so forth. Is Bev even going to let them do that comparison? I don't know. I'm skeptical. I tend to doubt it. So much of this process is within the authority of the judge. And if she doesn't want those answers to be explored and evaluated, then it's not going to happen. See the catch-22? You have to have a case in order to be able to investigate whether you have a case. You catch the problem there? You got to be able to prove already these people were involved in order to have the right to get the evidence that proves that they were involved. In order to ask the questions in trial about whether they were involved, you have to already be able to prove that they were involved. That's the catch-22 with how this third-party culprit stuff gets evaluated. My Mini 67, the heroic hare. So there's a platoon of troopers marching over the path and lawn, and none of the recovered lens pieces are dirty, muddy, or grassy. She noted dirt on like some of them, right? Like one package. Where did that come up? Where did that come up in the analysis? There was one thing like that had dirt on it. (7-12). 14 pieces of glass and plastic. She noticed there was some debris on the items and she put it in a 10. So specifically called out item 7-12, 14 pieces of glass and plastic. What's that? Interesting. That's the bag that Sergeant Buchanan has his name on. Bunch of pieces of glass and plastic. Debris on it. So there's no noting of debris on any of these other items. Can we infer that? If she called it out on this one, does that mean the absence of calling it out on the others means it's not there? It would seem to. Is that not logical? I think we can infer that. Yeah. 46 pieces, and at best, from 7-12, I don't know how much is glass and how much is plastic because that item is mixed, but 14, at best 14 of them, of 43 or 46, 47. I don't even know what the final count is. At best, 13 of those, 14 of those have some dirt on them. Seems pretty improbable, doesn't it? Mike, laborious testimony, but reminds me in the first trial how the witnesses kept saying the cocktail glass had dimples. They didn't realize it was actually the diffuser. They went all in on the frame job. Yeah, lots of pieces of diffuser I saw this time. Now that we know what that is, thanks to Be in Trouble 31, who I saw was showing up in the chat earlier today. Thanks to Be in Trouble 31 and doing all these fantastic videos about the taillight. We know now what the diffuser is and what it looks like and those little dimple pieces. Now we know. I didn't know. We didn't learn that from the first trial. We learned nothing in the first trial about how that diffuser serves to actually move the light, like establish where the light is going to shine in that taillight, and therefore what that taillight would look like if those diffuser pieces were missing. Be in Trouble 31 taught us all that. So now we know how to identify the diffuser and what it means. Yeah, it looked like there were quite a few diffuser pieces. Saw some in bag 7-6. Saw some in bag 7-15. Those dimpled clear pieces of plastic. Yeah, they were not glass. They were not the cocktail glass. Who? I mean, okay, I guess I can envision a dimpled cocktail glass, but not really at one of these bars. Maybe at like some snooty Vegas special old-fashioned bar or something like that. You know, maybe you'd have some funky shaped, funky textured cocktail glasses. No, the Waterfall and CF McCarthy's pretty sure they're just going to have boring, smooth glass tumblers. But yeah, what do I know? Yeah, they didn't know it was the diffuser, and they didn't know what that meant. That they didn't know what the significance of that was. And I only learned it because of Be in Trouble 31. So big shout out to him for that. I'd change my name to Cora too. What number were the items MH found the other day? Maureen Hartnett. Boy, what were her item numbers? I don't remember that I wrote all of them down because it became very clear that we were not going to be going through like everything that she had and everything that she did. So let's see what I got in my notes. Okay, Maureen Hartnett. Let's look here for item numbers. Item 3-3 is the glass, the piece of tumbler, the broken piece of tumbler. What else do we have? The hair on the Lexus is just designated as A. So I don't know what that's about. That seems to be a different numbering convention or something. What else? We know the taillight is 3-1. Item 7-17 is the orange t-shirt. Item 7-1 is the jeans. She did not specifically tell us what item number the sweatshirt was, but the derivative items all come from 7-18. So I think we can infer the sweatshirt is 7-18. And so then what they do, if they swab from it or scrape it or whatever, then they have that point whatever number. So 7-18.1, 7-18.2, etc. are things derived from 7-18, which is the sweatshirt. Those are all the item numbers she gave us in her direct. So not very many. Definitely not compared to these items. Ryan Bibbs, any attempt by the Commonwealth to change their timeline theory mid-trial is an attempt to deny Karen Reed her constitutional right to put on a defense. I couldn't agree more. We're playing by ambush, and we're trying to present them with a gotcha at the last moment that they won't have a reasonable opportunity to be able to respond to, when they've already relied on the position the Commonwealth has assumed and committed to in accordance with their discovery obligations and the timelines for disclosure ahead of trial. That's what you get to rely on when you're preparing your defense. So when they walk in at the last minute, oh, hey, this is totally different. By the way, we're gonna change all this up. Yeah, that is. It's trying to sandbag. You're trying to get an advantage by bringing up something they don't have an opportunity to be able to respond to. Michelle J., sorry if this was discussed, but do we know why, after the first trial, the unknown male DNA profiles weren't compared to Brian Higgins or Brian Albert's DNA for trial 2? So we've talked about it a little bit. It's procedurally complicated. There's costs involved in doing that. It would probably require them to go pilfer the DNA from Brian Albert and Brian Higgins, which probably means you have an investigator following them around, waiting for them to throw away their drink in the trash, stuff like that. Waiting for trash day at the Albert house, going out and going through it, taking some items, it can be a bit laborious. So, procedurally, and then the cost associated with it. We don't know for sure that they haven't, but it doesn't seem likely that they have. And that's on top of, we don't even know, we have the lab telling us these other profiles aren't suitable for comparison, meaning you wouldn't be able to get any meaningful information from it anyway. Possible that other labs and other methods might be able to get more information, might be able to do more analysis with it, but don't know. You'd have to hire somebody to go through and review exactly what the state crime lab did and see if it's something that there's a feasible way to develop it further. Ethan Morgan, Brennan says there is nothing new from the Commonwealth, so they should not need to admit anything new. They can use what they already had. Judge should exclude. If there's nothing new, why is there a report? Of course there's something new. There's a new report. Of course there's something new. They think we're stupid, guys. They think we're stupid. Jay Coop, Andrea, this is so bad they can't just change their theory. This could hurt Karen. The defense needs to put their foot down. When you have a judge that wants to do whatever she wants to do when she's drunk on her own authority, I still can't get over when she had those ARCA witnesses on the stand, when she had Dr. Wolf on the stand, Could you get your report done sooner? If I ordered you. She's absolutely drunk on her own authority. If I ordered you. She just loves that idea of ordering little Dr. Wolf to do what she wants. When you have that judge, there's only so much the defense can do. There's really only so much they can do. And otherwise, they got to just do their best to win the trial. And if they don't win the trial, they get to bring it up on appeal. That's how the system is set up. That's why rogue judges are such a problem. That's why it would be so nice if it was rare, few and far between, that, judges were prosecutors in robes sitting on the bench. It'd be great if that was really uncommon. Yeah, this is not particularly unusual, guys. Been saying that many times. This is not particularly unusual. Prosecutors routinely show up the day of trial with a new witness, a new police report, a new lab report, a new analysis. Routinely. And the remedy the judge gives for that? Well, defense, you can go ask during a break in the trial. You can deal with it during a break in the trial. It's routine. Ed 2276, why would Alessi not just demand exclusion, mistrial, or dismissal as the sole options he would accept if Bev then allows the new report and forces defense to go forward, preserves reversible error? They're trying to be reasonable. They're trying to be the reasonable person in the room and maintain that position. It's not helping with Bev. It hasn't helped with Bev for a long time. So the only reason you're doing this now is for purposes of appeal. Being reasonable is not going to influence the judge at all. So I've commented before, I think before we even got to trial. I wouldn't mind seeing him take the gloves off a little more. Stop being so deferential. Stop trying to make her like you. She's not going to like you. So make your record. Make your record of the problem and why this is not a viable solution. Now, I think Mr. Alessi did that. He made a really good record of what the problem is and how this impedes the defense. So there's nothing that asking for a mistrial that she's not going to grant at this point is going to do. There's nothing that would do. She's going to let it in. There's nothing asking for a mistrial is going to do, because she's just going to deny that. It doesn't preserve your request anymore. It doesn't make it more or less of an error. So I think they have their record, but just in terms of how they frame their argument, maybe you need to not concede. Look at Hank Brennan, not conceding any reasonable point whatsoever, and she's giving him what he wants. Maybe there is no benefit to trying to be the reasonable person in the room. Just a possibility. Just a possibility. WW, if the time of last interaction is even later now, this is really bad for the Commonwealth. It's a 6.5-minute drive from 34 Fairview to 1 Meadows in good conditions. To be back at Meadows at 12:36, she would have had to leave before 12:30. I mean, that's the irony of all of this, isn't it? That's what we've been saying. The Commonwealth can struggle as much as they want to try to make this evidence look like a collision. But if the evidence doesn't establish a collision, then it's just going to create a problem somewhere else. So yeah, you can fix this problem with your timeline, but it's just going to create another one. Now you've shortened the time between that connection with the Wi-Fi back at 1 Meadows Ave. And now you got to explain, how did Karen manage to get there in this unrealistic amount of time undetected during the beginning of the worst blizzard in January in Massachusetts state history? Exactly how did that happen? So yeah, that's the irony of all of this. You know, we're letting the Commonwealth sandbag. We're letting them play dirty. We're letting them try to get every advantage that they can get And for what? It still doesn't give them a case. Still doesn't give them a technical case here that this is what happened. Oh, I can't wait to see how we have times associated with the trigger events now. We didn't have any of that at the first trial. We had the key cycles. And the problem with the key cycles is that the key cycle they've identified, 1162, I think it is, it doesn't fit. If you count back from the known one, which is when Trooper Paul did his testing, you count back, you don't get the time Karen turned the key at the waterfall and then drove to 34 Fairview. It's not the key cycle you get. So I don't know how they're gonna shave off all these edges of the square peg to try to fit it into the round hole. I have no idea. But the more they struggle, the more problems it creates. And here she is going to bend over backwards to make the trial unfair, give them every possible advantage. And what's it going to do? It's just going to create a different timeline problem. Carla Alejandra Cordova just had a baby, so I'm very lost. How's trial going? I mean, I think about what you'd expect. The Commonwealth still doesn't have a case, a good case, that Karen Reed hit John O'Keefe with the car. We just heard from the medical examiner yesterday about how John has none of the injuries that she looks for in a pedestrian motor vehicle collision. He has absolutely none of those. He does have an injury that's consistent with being punched. We got that yesterday. Pretty much every witness that's testified, the defense has been able to neutralize, either with credibility issues or just by, association with Proctor and the investigation. Strongest piece of evidence is and remains the timing of that cert search. Kind of always has been. Well, how did they find tail light from January 29th out there at 34 Fairview? First they tried to, distance how far the car was, Karen's car, from Canton when the search started. Oh, they got caught on that. Now it's within the time frame, but it's still pretty close, right? And they got cert people at the scene before the car even shows up in the Sally Port. Still their strongest issue. Well, except maybe until today when we learned that only maybe half of the taillight pieces that they recovered altogether over this entire course of recovering taillight from 34 Fairview, only about half of those pieces actually matched Karen's taillight. And the rest of them didn't fit. So where are they from? I don't know. I would love a visual on that. Wouldn't you love a visual on which pieces didn't fit? Could you imagine like big, massive pieces of taillight right there on the grass? They didn't fit. They're not even from her taillight. Oof. And Bev, of course, is still putting her thumb on the scale, doing everything she can to ensure the Commonwealth gets a fair chance to send Karen to prison. That's apparently how she views the trial process. Certainly how she is directing it in this case. Summertime, where do we think the jury is at as of now? As of now, I think the jury is no longer in the courtroom, and that's the only guesswork I'm really ever going to do about the jury. I don't know. I don't know. We have no idea, and you can just you can really set yourself up for disappointment, surprise, shock, trying to read the jury's mind, trying to guess what matters to the jury, trying to guess what's landed, what their reactions mean. We have no idea. Greg S. Personally, I would prefer not to be hit by a 7,000-pound vehicle doing 25 miles an hour. That would be ideal if we could avoid that. But apparently, if it's a side swipe, it won't even bruise you. It's fine. It might kill you, through some other way. But if it's a side swipe, you won't even get a bruise. So maybe that'll be okay. And Cat 100, Andrea, appreciation for your solid commentary. I do know a lot re DNA, the types, etc. Couldn't describe as succinctly as you. Serious respect. Thanks. Well, thank you for that. I know about DNA just, I like I said, it's been a long time since AP Bio, so I remember a lot of the fundamentals from back then. But most of what I've learned about DNA since then has just been learning through casework. It's very common in the cases now, and you really need to understand it as a defense lawyer. So many tricks that they like to play with DNA. One of the biggest ones, and people make the mistake all the time. People don't understand these statistics that we just heard. People don't know what that means. What did he say, for example? Just at random, 7-18.17.1. This was a sample from the unstained areas of the gray sweatshirt. It showed a mixture of two profiles, including a male. The second one was not suitable for comparison. The first one, it was more likely by 960 nonillion times more likely that the mixture consisted of John O'Keefe plus an unknown unrelated contributor compared to two unknown unrelated contributors. Nobody explains what that means. And the DNA statistics they sound really significant, right? 960 nonillion, it's a massive number. It's a huge number. And a lot of people, including attorneys in court, think that means 1 in 960 nonillion people would contribute this DNA. And that's not what it means at all. That's not what it means at all. What they're doing is how do you even explain this? Pretend that the human genome is like a bingo. It's like a bingo wheel, and you go in, and maybe we're looking at 20 different sites, the STR sites on the genome for purposes of identification for this STR analysis. So we have 20 bingo wheels, and each bingo wheel has the variants of the allele that can be present at that point. And so you go through and pull out of the bingo wheel one allele from each one. What are the odds that would be the one that you have in this sample? They're getting at the comparison between, if you have a 1 in 500 chance of having this allele at this point, and then a 1 in 800 chance of having this allele at this second point, and go on down the line 20 times, and you combine all of those likelihoods, that's how you end up with a number like 960 nonillion, is because you're comparing in a vacuum, what is the likelihood that if we just, shook up the bingo jars and pulled them out, that this is the one that we'd get. But that's not how human DNA appears on the planet. Human DNA is people who are related to each other, making reproductive decisions and passing on, some or more of those traits to their children. So it never gets explained. There's so much confusion with DNA, and so because of that, a lot of times it does get misrepresented. This came up just recently in Koberger with some of the motions in limine, because apparently in the grand jury, the prosecutor was asking the DNA analyst, so based on these statistics, how many people would be likely to have this DNA profile? And the expert had to be like, that's not what these statistics mean. It doesn't tell you anything about the population of the earth. It tells you nothing about how many other people might share this population, or might share this profile. All it does is tell you that this profile if randomly pulled out of a bingo container, that's the one that you would get. But it doesn't tell you anything about, for example, does this person have a twin who would have the same DNA? It tells you nothing about the population. So anyway, I've had to learn a lot of that stuff. Appreciate your kind words, because I'm definitely, haven't studied this since AP Bio in 10th grade, something like that, 10th, 11th grade. It's been a long time since I got through the basics of genetic stuff in a science class, but you have to learn it as part of the job. So I appreciate your words about it. I may very well get some things wrong or miss some nuance or whatever, but feel free to correct me if I do. I won't take it personally at all. Amanda Capone, did she rule on the defense chalk for the pieces? I don't recall that she has. Right? Wasn't that supposed to be for this witness? I don't recall that we got a ruling. So I guess maybe it's not allowed. I don't know. Wasn't offered. Wasn't offered. Guess no chalk. Deegs, been here quietly since the beginning of trial. Needed to say thanks. Love your perspective and realistic critiques of both sides. I may have missed it, but do we know if ARCA got their report in by the deadline? They did indeed. They were given the May 7th deadline. They filed their report on May 7th, and Hank Brennan was back in court yesterday complaining about getting their report on May 7th, on the deadline. Indeed, they did. I'm not on a side. I just watched this trial before. I know what the evidence is. And it's not my fault if the evidence tends to prove that there was no collision here, that Karen Reed did not hit John O'Keefe with her car. I didn't make that up. I didn't make that up. That has nothing to do with me. So, I'm not here to pick a side. I got no dog in any of this. I'm just trying to call balls and strikes as I see them. Sometimes the defense gets it wrong, and I have called them out for that. And I'm going to do exactly the same thing with Judge Bev in the Commonwealth. It's not my fault that she doesn't apply the same standard to both sides. I didn't make her do that, but I sure am going to call it out when I see it. So I appreciate you being here with us. Appreciate you speaking up, letting us know that you're watching, and happy to be a source of commentary for you. The rural juror, Hank saying this isn't new and it's new in the same argument like 90 seconds apart is maddening. I want Alessi to take gloves off and be a little rude. Yeah, he won't be rude. It's not his style. I think we saw today about as gloves off as Alessi gets. He's clearly frustrated. He's expressing in his tone how ridiculous he finds all this. When Mr. Brennan says XYZ, it's simply not true. That it's a response to Sogra. It's not true. He won't say like Mr. Brennan will get up and be like, oh, the defense has just lost it, man. They're clueless. They're just mistaken. They're dumb. They don't understand their own case. He's not going to do stuff like that. He's just going to say, that's not even true. That's his style. But it is maddening, isn't it? It doesn't matter. It doesn't matter what they say, because none of this is all formal. None of this matters to the decision the judge is going to make. And that became, frankly, crystal clear yesterday afternoon. Just watch her body language on the bench when Mr. Alessi is speaking. She's all leaned back. She's not looking. She's like messing with other stuff. She didn't need to pay attention to Mr. Alessi or care about what he was saying, because what he was saying had nothing to do with whatever she's going to decide to do. It doesn't matter. She's going to make up her own mind, and then she's going to justify it based on whatever, just like she did with that ridiculous ruling where she's like, no, I'm not going to let you present, do the cross-examination of Jessica Hyde because of the construction and purpose rule, how we're supposed to construe the rules. I don't think the purpose is served. That's not what that rule even is. And you had to go back and spend like half an hour coming up with a basis to try to justify what you already wanted to do, and that's all you could come up with. That's the giveaway. To me, as the lawyer, that's the giveaway. When that is all you came up with, that is a post hoc rationalization for what you have already decided you're going to do. So we're not following the law and the facts here to a conclusion. That train left the station in this case long, long ago. We have decisions and then looking for justifications for those decisions. And that just happens to be like the most obvious, from my perspective, example. Zeke, Texas NP. Folks won't like this, and I mean no disrespect to Andrea and all those that work the good side of the law. However, if Karen Reed is convicted, it will show our justice system is no bueno and needs some serious reform. I take nothing disrespectful in this at all. Nothing at all. The system is broken. It has been broken for a long time. It's been broken for a long time. Folks have been trying to raise the alert for a long time. And I have to tell you, that's what's been so, like, for the last 10 years, maybe. It's like the first time it finally starts to feel like, holy cow, do people actually care about this? Are people actually seeing? People actually seeing some of what I see from my perspective here as the defense lawyer? I really don't know if this is a cultural shift that's happening, seems to be happening. People are paying more attention. I don't know if it's just me getting a kind of broader view of the rest of the country and what's going on in other jurisdictions. But it really seems like a recent thing that people are starting to sit up and pay attention and take notice and care. And take it seriously. That when we've been screaming for decades about dishonest police, about junk science, about innocent people, about systems that are skewed to just make the trial process and the criminal justice process a pipeline to imprison whoever the target is that the prosecution has selected, people are finally starting to see that. And so that for me is like, it's just such a shot in the arm. It's so motivating to keep it up. People are actually seeing it now and people are caring about it and realizing, yeah, this needs to change. Because this is not new. This is not new. We've been screaming this from the rooftops for decades. But it seems like finally, like the message is getting through. People are starting to see and they're starting to care and they're starting to take it seriously. And I'm so grateful for that. Lawyer nurse, she set the May 7th date with ARCA at the voir dire and gave Hank Brennan expert 5 to 7 days and asked when Hank Brennan was calling him. And he said at the end, she responded that he should have time then to review ARCA. Why is he now saying he has no time? Because none of the words have anything to do with the outcome. And so if the words don't benefit, if they don't further what goal we're trying to achieve right now, then we will ignore them and pretend they don't exist. All that matters is the moment and the outcome that we are attempting to achieve right now. A record, a prior decision? What's that? Now this is turned into Bev left the door open to do other things. Bev was seriously up there suggesting I might make ARCA do it faster. Even the time they have is not enough, but what if I order you to do it faster? Drop everything, put aside your other work, cancel your vacation. By the way, it's the weekend. We're talking about like a few days now. It includes the weekend. Because I've taken at least one of those days away from you, making you come down here to Canton to testify in this voir dire. But take a few days to get it done. Give up your weekend. Give up whatever other work you had to do. Get it done by 5/7. Mr. Welcher, well, he's very busy. He just can't get to it. And apparently that gets accommodated, not so much as a question asked. His schedule. Nobody gives a shit about his schedule. I don't give a shit about his schedule. If you can make ARCA drop everything, give up their weekend, scramble to satisfy you and your intoxication on your own authority, then you can do the same thing to the Commonwealth's witness. I don't give a shit what other work you have to do. You can drop it and get it done for this. But that's not how Bev applies the rules, does she? KH, nothing better than Andrea speaking uninterrupted truth on a Friday preach. It's been that kind of week, guys. Sometimes you just gotta let it out. Gotta rant. Sometimes we just gotta rant. I appreciate you guys stick around and entertain it. Again, it's a shot in the arm that people actually care about this stuff. I feel like so much of my career was spent with people that just assume the criminal, the accused is always guilty, assume they're shitty, that the trial is a formality. We're just going to show up and take a little nap and then go into the jury room and vote guilty because nobody really cares. And nobody really cares if the police were shady. It doesn't matter. These are bad guys anyway. Like, that's the environment I feel like I've spent most of my career in. And so seeing that seem to change, and having so many of you that care about this stuff, and are like, no, actually, even if the person is guilty, they deserve a fair trial. The fair trial is about us, guys. It's about us. It's about us and our moral standing. That's the whole reason why we're supposed to have a justice system, is because it gives us the moral high ground that we are better than the people that we are judging and punishing. They do bad stuff, but we do not. The criminal justice system, guys, common misconception. The criminal justice system does not exist to protect you and me from criminals. It does not exist to protect you and me from criminals. It's reacting to things that have already happened. There's no protection. It's a done deal. There is no justice once a crime has already been committed, because you can never go back to the way it was before. You can never restore somebody. The criminal justice system is not about protecting you and me from criminals. It's about protecting criminals from us. It's about protecting the criminals from the mob. We give the monopoly on violence, the monopoly on control to the government to do justice for us so that we don't take it into our own hands. And perhaps get a little over exuberant, perhaps overshoot a little bit. What's necessary to, I don't know, make us feel better emotionally, feel like we've gotten our vengeance. We give that monopoly to the state so that they can maintain the high ground, maintain the moral authority, so that we are not all just as bad as the people that we're pointing our fingers at here. Oh, you criminal, you terrible person, you deserve to be in prison. So when we don't live up to that principle, we're no better. We want to punish people for not following the rules, but we're not going to follow the rules ourselves. We're no better. We are no better. So that's why the system is so important. That's why the integrity of it matters so much. And that's why I care. That's why I care about it being good, about it being better than it is. And I think that's what brings a lot of you to the channel, is the fact that you guys care too. So really appreciate that. Sue B, ADHD brain works fast. Can be processing plus nerves. Yeah, I rarely judge, people having nervous tics or things like that. Speaking real fast on the stand, a lot. For most people, for most people, speaking publicly is one of their worst nightmares. You got to get used to it as a lawyer. You're going to be talking to juries. You're going to be standing up in that courtroom. Everybody in the courtroom is staring at you while you talk. You got to get pretty comfortable with that pretty quick. But witnesses, not necessarily. And even folks like crime lab folks who are, in some sense, they're professional witnesses. That's what they do. They testify a lot. But that's not necessarily why they went into this area, because they're dying to be on a stand with, dozens of pairs of eyeballs on them hanging on every word. No, because they're science nerds. They like doing DNA testing and stuff like that. They like working in the lab. I'd expect that's probably more common than somebody's like, ooh, I want to be an expert witness. Therefore, I'm going to go get like a degree in biochemistry and, and so forth. So I tend to not judge that type of thing because I recognize, people can be nervous on the stand. I'm not going to judge that. AKA Trad's photos. Good Lord, can someone throw up a count on the ums from her? He probably could. I guess maybe that bothers other people more than it bothers me. It doesn't tend to bother me, but other people might notice that. Greg S. Enter known facts into Chat GPT. Answers equals you've thrown 300 years of known physics, human physiology out the window. Do you wonder what an AI judge, AI jury would make of this if there is a way to do that? I'm sure there is a way to provide that prompt. It wouldn't surprise me at this point, just AI growing the way that it is. I already get all kinds of ads, emails, solicitations, things like that for different AI tools. And AI tools are being integrated now with attorneys' case management software. So case management software is often just a repository of, you have your police reports in there, your phone calls, your notes, your time, your billing, like all that stuff is just combined in one place. It wouldn't surprise me at all if we don't already have AI scraping tools as part of case management software that can go in and look at what you have been provided in discovery and look at the communications and your notes of your interviews and everything else that you've uploaded into that case management system and give you a theory of the case. Wouldn't surprise me at all if that type of thing is already out there. So I would be interested to see what an AI makes of all of this. Mark Lyon, no bulbs. It's an LED fixture. I'm not aware of LEDs necessarily having glass bulbs. I don't know. They might. I don't know. I got to take this one on faith from people who know more about lighting engineering than I do. Can LED have a bulb? Does LED necessarily have no bulb? I don't know. I mean, all that really matters is this taillight. Shouldn't we know whether this taillight has glass bulbs in it or not? Mark Lyon, defense really needs to have a witness plug a battery into the taillight to show that the LEDs are red, not white. This was part of Be in Trouble 31's demonstration with that taillight that I found so persuasive, so compelling. Just break it like it was in the Sally port and hook it up to a battery and make it light up and see exactly what it looks like, particularly when those diffuser pieces are missing. Because it's not white light shining through. It's not white light shining through where there's no longer a lens cap. That's what an old incandescent bulb taillight might do, because you just have a white bulb inside a red plastic cover. And so when it lights up, it goes through the red plastic cover and it looks red. But if that red is gone, it's just a white incandescent bulb. That's not how taillights are made anymore. So I would love to see ARCA, for example, do this, recreate some of that work that Be in Trouble 31 did, it was extremely compelling. And having a visual like that, surely that's going to land with the jury. I would love to see this too, Mark. Cannone Rue Court. How many jurors are wondering if they are on a hidden camera show? They're waiting for Ashton Kutcher to jump out, yell at them being punked. You've been punked. I don't know. I do. I have concerns. You never know how this stuff lands with the jury. Even in the first trial, they had great respect for Judge Cannone, really looked up to her. I don't think they're seeing what we see, guys. It would be unusual, I think, for that to be the case. I think that would be unusual. We'll never know. I mean, I say never. We won't know unless and until this trial is over and somebody decides to tell us what the jurors are thinking. Anita Whiteclaw. I thought AV was a solid expert witness until she was asked by the Commonwealth if she examined the clothing debris under a microscope. She said yes, but mouthed, "I don't know," and shrugged. It seemed as though she was looking at honk. I didn't see that. She looked at it under a microscope. Okay. Yeah, I don't know what that I don't know what that question was about. You looked at it under a microscope. Is this Lally getting butthurt because he's characterized this previously as microscopic pieces of taillight? 1/8 inch by 1/16 of an inch is not what I would characterize as microscopic. If you can measure it with a ruler, it's not microscopic. If you can see it with your bare eye and see it, fairly clearly, it's not microscopic. So honestly, I really think that might be all Lally is hung up on. It's his own ego from back in the first trial. Took a lot of shit for calling these microscopic pieces of taillight. So she looked at him under a microscope. Why? Because it didn't matter to any of the rest of the testimony. Who cares if she looked at it under a microscope? We didn't learn anything about what that told her. Did that assist in her analysis in any way? She wasn't asked. So looking under a microscope, I don't really have any problem with her as a witness. I do think that she just comes across as somebody who's there with a job to do, did the job to the best of her ability, knows what she knows, doesn't know what she doesn't know. I missed it if she mouthed something during her testimony. Maybe somebody caught a timestamp for that. You guys, we have CH, our fantastic mod CH that goes through and compiles timestamps for us. And so if you catch one that you're like, hey, this is an important moment, do feel free to drop that in the comments of the video. We'll potentially try to pick that up if possible. Everage, some days it's nice to come back from a full day of work and be 2 hours behind, can skip through all the lally lulling and scraping his throat to the interesting parts. It is sometimes nice to not have to suffer through what we have to suffer through, isn't it? We've committed to the live watch here. We're going to take it all in live and in living color. If Lally is going to lull us, we are going to endure it. But hey, feel free to take a nap because I'm going to recap it. Nobody else may be riveted by the technical testimony, but I am. I'm going to do as much as I can to take down as much of it as I can so that we can make sense out of it. I certainly don't expect Mr. Lally to go through and make sense out of it. Otherwise, we might have heard 23, 24 pieces of plastic that were recovered did not fit in Karen Reed's taillight. Why is Mr. Lally telling me this? How's that helpful to the Commonwealth? You tell me. Deep Hat. So if Proctor lost his job, pension, reputation, and may face criminal charges to protect someone, when will he spill the beans? Is he going to just put himself in a worse position now? If he admits to a whole series of criminal activities in this jurisdiction with these folks, with their power to charge, decide who does and who doesn't get held to account for criminal activity. He's still under the same pressure as anybody else who's going to come forward and point the finger at these guys. They're the ones that have the power to decide, oh, I don't know, you dropped a yellow rubber ducky. That's really intimidating to a witness. You're going to have to go to court and answer for that. There's still that whole factor at play here. So barring like a pure revenge motive to try to take them down, he's putting himself in greater jeopardy to do that. So who's going to take them down? Who's going to take them down? Some outside source? Outside investigator? The FBI? But we're hearing the FBI is done. I don't know. I mean, I certainly understand this perspective, but I think he's still up against the same power dynamic that has been the problem in Norfolk County. That's generated all of this protest, all of this concern by the people there, because it's not like it's just this case. They did it in Sandra Birchmore too. And those are just some of the highest profile ones that are out there. Still waiting to hear about that guy that got killed in the MSP Academy. Still waiting to hear anything at all about that. How long has it been now? Has it been a year yet? I don't think it's been a full year. Been pretty close. Yeah, the rot here has not been rooted out. And is Proctor gonna suddenly become a hero? The one that rooted out the rot? If he goes and turns all this, well, maybe he could be, but it depends on who's going to do anything with it. And at this point, do we even know if there's anybody at all interested in addressing the rot in Norfolk County? I don't know, man. High risk. Guys, I am going to pause real quickly because I'm getting low on my tea. We still have quite a few comments over here in the queue, and I do want to give all of them the attention that they deserve. When you guys, I wish I could pay attention to the entire chat. I just can't. But when you guys are going to pay your hard-earned money to, have me see what you have to say, you better believe I'm going to. So I want to be able to give you guys the responses that your thoughtful comments and questions deserve. But I need to have my voice, my hydration to do that. So I'm going to pause for just a minute, go and refill my tea, and then we will get back and pick back up. So do hang tight just a few minutes. Thanks very much. Thank you so much for hanging tight with me. Got my tea refill. Silver white needle, guys. Love it. Such good stuff. Keeps me going throughout the day. Stacy LeBruno. The bias of this judge is infuriating. What happened to I expect counsel to comply with all rulings and rules of the court and professional conduct? No more nonsense. Oh, wait, it only applies to the defense. I forgot. You and I had exactly the same idea about that, right? Wasn't that my first? As soon as Hank Brennan gets up there and starts presenting his argument, like the whole issue here is that the defense is a bunch of drooling morons. Thought we were going to be done with all that. Thought we were going to be done with the finger pointing and so forth. No, of course not. Nobody really believed that, did they? And the reality is, if she's not going to control the courtroom, even if she says that, nobody cares. Nobody cares. Talk is so cheap. Talk is cheap. If she doesn't enforce it, none of it matters. And she's never enforced that. Not a single time. Yeah, it is. It is very infuriating. And it's so obvious. Isn't it so obvious? Charm free. We need Christina Hanley. She's the chemist. Yeah. Interesting that apparently she's not coming today. I wonder if the Commonwealth is planning to call her at all. She is important because she's the one who is like, yeah, the glass doesn't match the glass. The bumper sprinkles. The bumper sprinkles. They don't match the tumbler. They don't match any of the other glass. All matches itself. Doesn't match any of the other glass. So what's it doing on the bumper? Yeah, I think everyone would like to know that. So she is an important witness. I think the defense needs to call her if the Commonwealth doesn't. Amanda Lang, at what point should they appeal to recuse judge? I don't know, guys. We've talked about this a few times. Part of the problem that they have is that it's very difficult to establish bias based on the judge making rulings. You typically have to have something else. You have to have disparagement, snide commentary, things like that. They would have to be tracking that and compiling that and dedicating their energy to policing the judge. And by doing that, they're necessarily taking away from putting that energy into their case. So they could very well have just decided, look, priorities, we got to just win. We got to just focus on winning this trial. It is the most winnable case that you might hope to get in your career as a defense lawyer. It is the most winnable case. So we got to just focus on winning it. We can't get distracted. We can't be worried about an appeal. The appeal is the backup position. Just put our energy into winning the case. I don't know, guys. I really don't. But it's very frustrating, isn't it? Vlad Dracul, should prosecution have a reasonable expense limit? Well, they kind of do. It's up to the taxpayer. How much are you willing to tolerate prosecutors spending on a prosecution? Now, it's not that the taxpayer has a veto. They can go in directly and, say, no, you're not allowed to do that. Maybe by referendum they could. I don't know. Haven't really thought about that. Constitutional limitation if the voters, if you have like direct democracy in your state, not every state does have ballot initiatives and things like that can be initiated by voter petition. No idea if Massachusetts does or not, but I don't know. Could you do a referendum on prosecutors spending money on this prosecution? Maybe. I don't know. But at the very least, you can vote the prosecutor out, right? That's the ultimate recourse for the actions of the elected officials. Doesn't stop this prosecution from happening, but it sure makes them pay a penalty for it. Summertime. Seems Bev and Commonwealth want a mistrial. Thoughts? Mistrial gives them yet another bite and continues to drain Karen's resources. And he continues to hold the door open. If she's not acquitted, then they can continue. If she's acquitted, then it's game over and we're done. And she gets to go and go on with her life. Wouldn't shock me. Wouldn't shock me if another mistrial is I don't know that Bev wants another mistrial. Because I don't think she looks any better the longer this goes on. But the Commonwealth, maybe. If you get a mistrial, you haven't lost. And this is a very losable case for the Commonwealth. Miriam, I am so annoyed. Defense needs to put their foot down. # love ya. It's extremely annoying. And I like seeing Alessi get a little fired up. Make it clear how ridiculous this is. Making his record very emphatically. But wouldn't mind seeing some gloves off. Call out the double standard. Happy to do it when it comes to, hey, now that we no longer have a standard that you have to have a medical degree to give an opinion about injury causation, we understand you'll apply that to Garrett Wing, that kind of thing. Start calling it out with some of these other behaviors, these other decisions that are so clearly one-sided. They get to do this and you don't. But at the same time, none of it's going to matter. She's going to do what she wants to do. She's going to look for the justification after the fact. It really doesn't matter what they say. So it's kind of at the point where just say what makes you feel better, right? Will you get satisfaction out of that? Then maybe just go ahead and say it, because it's not like it's going to matter at this point. But that's the risk that they're in. All they can do is make it worse. They can't make it better, but I bet they could make it worse. It's the most frustrating thing about being in front of a judge like this, a judge who doesn't care about the law, judge who doesn't care about being fair. Because you're fighting them both. Fighting the prosecutor and fighting the judge. It's no fun. Savannah Dreyer, is it possible this judge biased against this defense team based on their previous client list? I have no idea. I don't know. It's almost like she was antagonistic to Mr. Yanetti kind of from the get-go because he's the outsider, right? He's he's the bigwig lawyer from Boston. But then once Mr. Jackson came in, the bigwig lawyer from California, then Mr. Yanetti is like almost better at that point because Mr. Jackson is like so much more of the outsider and the bigwig by comparison. It really reeks of insecurity in so many ways. You know, she's the judge. She's got the authority. She's got the power in the room. These guys coming in with their big reputations and their impressive resumes and so forth. And she's going to show them. Get some of that kind of vibe. Just the flex. The constant need to flex is very telling. Very telling. So I don't know if it's based on their previous client list. I don't know if it's based on who they are. I don't know if it's based on she clearly doesn't like the media strategy that they've pursued. They're allowed to do it. Rules of professional conduct contemplate that they can do stuff like that, and sets what the limits are. There's been no finding that they violated that, but she doesn't like it. Could be pissed off because they dared to move to recuse her before the first trial, embarrassed her like that, called out her relationships, put her under the spotlight. Gonna make them pay for that now. Could be any of those things. Could be something else that we haven't even thought of. Really, I just, don't know. Don't know. Nobody special. Auntie Bev will clean up Brian's little mess, I guess. Well, she's there to clean up the Commonwealth's messes, isn't she? So. Oh, you got your timeline wrong? That's okay. That's okay. You can change it 3 weeks into trial. No problem at all. Clean up in courtroom. I don't know. Is there a courtroom number here? Warrior, is there a pic of the left tail light to do a comparison of both, looking for road, salt, dirt stains? I don't know that there's like an individual close-up photograph, but there are plenty of photographs that show the left tail light. We've seen different orientations of the back of the SUV inside the Sally port, for example. So depending on how high quality those photos are, you might be able to get some detail from those. But I don't believe that we've seen like a close-up of the left tail light, like an actual independent photo that's just a close-up of the left tail light. So I don't know if there's any comparison there. Jessica, so how does the defense adjust to this ruling? They look at everything and refocus their strategy. I mean, I think Alessi has already highlighted that it shifts their approach. They didn't cross Guarino. Now they are going to need to bring him back in to establish the Wi-Fi connection. Establish the problem at the other end of the timeline. If it's not the problem at this end of the timeline, then it's the problem at the other end. So they're still going to focus on the technical issues. They're going to have to go back through and reevaluate. Okay, what is this guy saying? Is he right? Is he wrong? And then what does that mean in terms of the overall timeline? They're going to have to reincorporate, all of that. And then based on that, decide what do we need to elicit? What information do we need in to present our theory and our version? And does that require us to recall any witnesses? Oh, and by the way, yeah, that vigorous cross-examination that Judge Cannone gave him free rein to do. Guess what I'm doing? I'm giving that leash. We're going in through all the changes to your theory. We're going to highlight. Here's your new report from May the 7th. And in this, you came up with this new thing. You had never previously articulated that. And in fact, Ian Whiffen was in here testifying to something completely different just a couple weeks ago. And that's on top of the fact that you had a whole different theory in the first proceeding here with Trooper Paul. Trooper Paul had an entirely different theory. And so the Commonwealth has consistently been unable to present a coherent theory of how all this adds up to a motor vehicle collision. Because it doesn't, and all you need to do is look at John O'Keefe's body to see that. Making that kind of adjustment in my case for sure. We'll see what they do. Track worker, Hank always projects what they are doing onto the defense. Every accusation is a confession, isn't it? They're lying, they're dishonest. They're violating the sequestration order. Oh, really? Oh, really? I'll be intrigued to hear about when and how the problem with Ian Whiffen's timeline was discovered. Do we think Hank has already gone and called this guy to tell him, oh, they're going to ask you about the timing? Yeah, I think a lot of it is projection. Elizabeth Dayton with a super sticker. Thanks so much for that, Elizabeth. Appreciate your support for the channel. Jessica, Be in Trouble is in the chat. Thank you. Yes, thank you, Be in Trouble 31. Awesome videos. Really, really helped us out a lot. I thought they were just fantastic work. Exactly the kind of thing that you want as a demonstrative in a trial. So very, very well done on your part. Appreciate you being here. Veronique Ude. Veronique. Do you think Karen's team has volunteer paralegals monitoring LawTube channels? So much feedback from you all is integrated in cross-examination. I don't know. We did hear early on during the jury selection that they had, what was it, like 9 Harvard students or something like that. They did have a crew of volunteer law students that were helping them with different parts of the process. So it would make sense. Have some folks out there monitoring all the publicity about this case because people have a lot of different insights. Okay, if there's a paralegal out there that's watching the case, feeding information back to the defense, and you haven't seen Be in Trouble 31's videos, you need to run right now and take a look. But that type of thing, it's just such a resource now. This is such a gift in these high-profile cases that never used to be available. You wouldn't get real-time feedback in the days before trials were televised. You just would never have this opportunity. And so it's this vast untapped resources. Very few attorneys, I think, have tuned into that and how much of a benefit it can be to their case. So I hope the team is doing that. I believe that they do have those volunteers on, and not because I'm like, oh, they need to hear what I say. These guys are pros. They know what they're doing. If anything I say is helpful, that's wonderful. But I'm not like here to direct them or what to do. But there's just so many good ideas out there, and people's ability to spot things that could potentially make a really big difference. Little details like that diffuser, those diffuser pieces, and what that's going to look like when a taillight's lit up. God, that's such a good piece of information. The way folks have tracked problems with the timeline and so forth. A lot of that can be very, very helpful. So I hope so, but I don't know. Z, if John O'Keefe did repairs for Karen Reed, his DNA is on the car. So why no DNA in taillight unless not OG? Also, does directed verdict include reasonable doubt? Plausible when? No directed verdict in a criminal case. The only possible outcome in a criminal case is let me take that back. Some people will direct an acquittal. Some people, it will be a dismissal. At the conclusion of the prosecution's case, if they have not met their burden of proof, they haven't presented some proof of each and every element of the charge, then there's no reason to go forward because they can't, as a matter of law, satisfy their burden of proof to the jury. The issue there is that the burden is so low. Does not include reasonable doubt. No, it's looking at, if we look at everything the way the Commonwealth wants us to, we believe all of their witnesses, we resolve all conflicts in the testimony in the Commonwealth's favor, we interpret everything the way that they say, like it means what they say it means, then if we do that, is there enough to clear that hurdle? And the answer is almost always yes. It's almost always yes. You don't get it thrown out at halftime because it's a weak case. You get it thrown out because there's been a total of failure of proof on one or more elements. The jury gets to decide what's reasonable or not when it comes to doubt. So the fact that you and I can see it doesn't matter from a legal standpoint. I think this is a good observation about, she parks her car in his garage. Okay. It's like, it seems very unsurprising that his DNA is on the car. Has he ever opened the lift gate? Then his DNA may very well be on the back of that car. Like this is not extraordinary. And the fact that we're just cherry picking the outside pieces of the taillight, that's the exposed parts, outer parts of the taillight is what we're gonna swab looking for John's DNA. Why don't you go over and swab, I don't know, the lug nuts? Why don't you go over and swab the passenger door handle? Why don't you see if John's DNA is there too? Does that mean she hit him with those if it's present? Of course it doesn't. Just means you'd expect to find his DNA on this car. Car is parked in his garage. I mean, before you even get to, I don't know, maybe he did do work on the car. I don't know if he did work on the car. Seems like a new car, pretty nice car. He wasn't very good at working on the plumbing, was he? Oh, don't worry about your hot water. Just come shack up for the weekend. We could fix it. Well, you haven't, have you? But we could. Cat's pajamas. Totally looks like September from Fringe. That may help you remember what he looks like. I gotta look up September from Fringe. Oh yeah. Oh yeah. He does a little bit. The problem though is that so does O'Hara. O'Hara looks a lot like this too. I swear, guys, they're like how your two thumbs are not quite the same, or your two big toes are not quite the same. Like you can tell they're a big toe, but they're not identical. That's what Tully and O'Hara are like for me. Very hard time visually telling them apart. I did actually what made it a little bit easier for me this time was that O'Hara has that little Joker smile that he does. Very little. I can't even do it. I can't even make that face, but it's that Joker smile. I don't remember ever seeing that from Tully. John Beattybot, if last Commonwealth witness is Aperture, Paul should be number one defense. Trooper Paul. Maybe if we're going to be allowed our full and vigorous cross-examination and to bring out the issues with this particular testimony, then I would expect, the changes in the theory should very well be on the table. Maybe. Jana Bell, would the reconstructionist be the one to have asked if she could tell if the lens was busted from prying out or from impact? Wolf spiders do overwinter. There's a few spiders that overwinter. We have black widow spiders here. They overwinter too. Come out in the spring, leave their nasty little egg sacs. Places where I don't like to find them, like in my irrigation box, or they like very dark, cool places. So the things where you stick your hand where you're not looking, the crawl space. Ugh. Yeah, there's a few spiders that overwinter. Still thinking about those wounds on the back of the hand, huh? Still thinking about that. I'm not any closer to having a good theory, one that I'm happy with. I feel like the spider bite is not bad. It's a very big spider though, and this is winter. I don't know. It's a hard one. If I would expect, it would be Vallier to testify about that stuff because she looked at it under the microscope. Did she not? Was that not part of her testimony? Examined these pieces and looked at them under a microscope. So if you're looking at it under the microscope, would you be able to see tool marks? I don't think we have any foundation for that. She was never asked. Is she qualified to recognize if there are tool marks on a piece of plastic like this, on another material? She does gunshot residue and physical match. So she does puzzles and she swabs things for gunshot residue. That's her job at the lab. Don't know if she would recognize a tool mark. Could have asked her. She seems like the one to ask. Yeah, she does, because she's the one that looked at it under the microscope. Z, juror maybe call Bev asshole for preventing defense questions. Maybe. It did come up in the course of asking for the sidebar, not allowing it, having the objection sustained, finally getting the sidebar, and then the asshole. Could be if the jurors feel like these are good questions and they want answers for them. Don't know who called who an asshole. Sarah Powell, is there anyone from higher courts that can step in? They will not step in. No, there is no authority for another court to step in. Their job is to wait until there is something for them to do. In fact, it's really not appropriate for them to step in because they're supposed to be impartial as well. Their jurisdiction, like for example, the appellate court, is to review what she does, and they will wait until she's done to do that. There's no independent authority for them to come in and say you're doing it wrong. And arguably, it would be kind of improper for them to do that. Mike 67C gifted 20 Andrea Burkhart memberships. You guys, thank you, Mike. That's very generous. Thank you for everybody who got one of those. Let the bonsai emojis fly. Z, LEOs and ADAs can cover up crime, not drunk financier. Yeah, they're in the position to be able to set up a frame job, right? Once again, kind of confession by projection. Karen Reed setting all this stuff up. That's why she left all those voice messages on John's phone. That's why, she did this and that and the other. It's this very confusing theory of why is she like confessing any sort of knowledge at all? If her theory is to avoid detection, why is she calling him at all? If we're trying to pretend she just dropped him off and went home, she's trying to cover up the fact that she hit him. Why would she even call him at all? You wouldn't. Oh, he went inside. And if you call him at all, it's, oh, John, honey, I miss you so much. Can't wait for you to come home. Why would you leave your motive on the voicemail? So it's this bizarre, confession by projection where Karen Reed is the real cover-up. That's the Commonwealth's theory. Karen Reed did it and then tried to cover it up, but her own words give her away. It's like it doesn't even make sense. It's very incomprehensible. It's not logical. And yeah, she's not in a position to control that. If you left evidence, if you're caught on camera, she doesn't know. She doesn't know if there are cameras around that caught anything. She has no idea. But police sure can control if they go and collect camera footage, can't they? They're the ones that are in the position to do a frame job, not her. And yet here we have that Darvoing. That Darvoing. She's the one doing a cover-up, not us. John Beattybot, Karen Reed case order version 2. Higgins, Barros, Lucky, Proctor, Green, ME, Dogbite Duo, ARCA, or Higgins, Proctor, Lucky, Green, Dogbite Duo, ME, ARCA. Either one seems fine to me. Trying to think of who else I might put on this list. If Hanley doesn't get called by the Commonwealth, we might put her on. We want to establish the bumper sprinkles are fake. They don't match anything. They don't belong there. There's no explanation for them being there. Even if the long journey wasn't bad enough, they're not from the cocktail glass. So what the hell are they? Where did they come from? Who else? Anybody else we desperately need? I might put Matt Kelly on the list. Matt Kelly, Seraph, Mulaney, the other first responders at the scene who are implicated in I hit him, so that they can testify. Didn't happen. Didn't hear it. Katie McLaughlin's version. I never said that. Those guys I might have on my list. Calling Brian Albert to get those butt dials in. Is Brian Albert on your list? You just got Higgins. I think I'm calling Brian Albert too. We're getting those butt dials in. The phone, the elimination of the phone. What else? Anybody else that's real critical? Just looking over the witness list real quick. That might be it. That might be it. Sure would, just as a sort of personal preference right now. hold on, I can't remember the guy's name right now off the top of my head. Wouldn't mind hearing from, gosh. Oh, yeah, the Beatties, Tom Beatty. Just out of personal curiosity, because Tom Beatty was on the witness list for the first trial, but he didn't get called. I've heard a lot of things out there about what that might entail. We know he's one of the people that Jen McCabe was calling early in the morning, not getting an answer from. Made several phone calls to Tom Beatty. Maybe just out of curiosity, I'd like to see him. I don't know how necessary he is to the defense case, though. So anyway, those are, I think, the only things I would add to your list. I think they have room. They have room to expand or edit their witness list. Track worker. How many others have been railroaded by Bev in the Commonwealth? Who knows? The funny thing, you can check it out on my Substack. I did this back before the first trial. I looked at Bev's appellate record. Looked at it's just the published cases that I have access to. So I looked at the published cases that she's had that have gone up on appeal and what the outcome was. And she doesn't have a particularly good appeal record, but one of the things I thought was pretty interesting was that by and large, when she was getting reversed, which she has been several times, it's mostly for siding with the defense. That's kind of the irony in all of this. In general, Bev doesn't seem to be anti-defense. It really seems to be this case. And it's not clear why. I don't know why this case is so far out of her normal pattern. But I don't know if she's got a special problem with Karen Reed, with David Yanetti, with whatever she's got a problem with, then I don't know if she's had that same problem in other cases. Decides she doesn't like the defendant, so puts her finger on the scale, gives the Commonwealth every advantage. Maybe. No idea. In Wings, hey, Andrea, infuriating ending today. Concern for Karen Reed defense. How much will this hurt defense case in your opinion? It's not ideal, but I mean, like we've been saying, the Commonwealth is in a pick your poison situation. No matter how you shift the timeline, you create a problem for yourself somewhere else. So is this fatal to the case? Absolutely not. Would it have been great for them to be stuck with this timeline? Oh, yeah, because no question, the timeline where the Commonwealth is alleging he gets hit by the car and then hits the lock button is extremely implausible. Gonna have a hard time buying that he gets hit by a car, checks his messages, sees that text from Jen McCabe, and then turns his phone off and lies in the grass for the next 6 hours. But they still have a problem with the timeline at the other end. And now, yeah, you best believe my cross-examination is going into the changes of the theory. So you've given me something else now too. You've given me another piece of information that I didn't have coming into this trial, which is that midway, you're going to have to decide, you're going to have to change your timeline. You're going to have to decide the evidence means something completely different than you've been working with for the last 3.5 years. 3.5 years in. And you're only just now deciding what you think the facts are? Isn't that the reverse order of what you should expect with a prosecution? Shouldn't you figure your shit out before you charge the case? So I don't know that this is, hugely damaging. It's not ideal. It's going to be a major pain in the ass for the defense. Yeah, they're going to have to shift. They're going to have to deal with it. But we already know it just creates a problem for them at the other end. And now they've gotten handed this kind of free issue to work with. They're about to rest their case and they're still trying to decide what happened. Oh, and by the way, only after we showed with Ian Whiffen that their existing theory was garbage. They didn't even spot that coming into this trial. They didn't even know. They thought they had it all figured out then. Realized they had a major issue and, oh, they had to scramble to change it in the middle of trial 3.5 years after the guy's dead. Yeah. I don't know that this particularly hurts the defense. It's not ideal. It's going to cost them, going to cost money, going to take time, going to take away from the other things that they would surely like to be focusing on and preparing for as just the rest of the ordinary trial prep they're already planning to do. But in terms of the substance and how it hurts the case, it doesn't matter how much the Commonwealth tries to fit the pieces to try to make a car accident here, because no collision happened. That's why the evidence doesn't fit. And it doesn't matter how far you go with the times and the actions and the key cycles and so forth, you're going to have a hard time overcoming the fact that John has no injuries on his body of the type that the medical examiner looks for with this type of collision. But he does have a cut on his eyelid that's consistent with a punch. They're always going to have that problem. So, no, this is far from like game over for Karen or anything like that. Far from it. It's a pain in the ass they're going to have to deal with, and they will. Dawn on me, in your opinion, what has the defense left on the table you wish they emphasized more or brought up? I would say the big one that I don't like being left on the table is the chain of custody of John's phone. I don't really like that being left on the table, because I think that's how you get to Carrie Roberts. Carrie Roberts has put herself in the cover-up in two different ways. One of them with the trip to Lanks, where she's parroting the story that Jen McCabe has told, and as it turns out, is contradicted by the location data. But then the other piece is the phone. Carrie says, here's when I got the phone, and I gave it to a first responder, but I don't know who it was. Her timeline of when she got the phone does not add up with the movement on the phone data. Phone starts moving a good 10, 11, 12 minutes before the point that Carrie Roberts identifies on the camera as the time when she got the phone, when they the first responders lifted John onto the backboard. And then she gave it to some first responder, none of whom has ever stepped forward and said, yes, Carrie Roberts gave me this phone. I really would have liked that to have been followed up on, because I want to see. I want to ask every single one of the first responders. I want to put every single one of them on the stand if the Commonwealth doesn't call them. Did Carrie Roberts give you that phone? Good. Seraph? Mulaney? Whitley? Nuttall? Everybody. Every single person who was there at the scene. Lank? I want to know if you're going to be the one who claims, yes, Carrie Roberts gave me the phone. I would just like that to be nailed down, because I'm not buying at this point that happened. And the big reason why I'm not buying that it happened, story isn't consistent with the data. And then there's that group chat, that little group chat from Jen. We handed the phone to Carrie. Tries to explain that as Jen McCabe is handing her own phone to Carrie. But that really doesn't make sense in the context of that conversation. So I'd say that's the main thing. I would like to follow up more on John's phone, because I think there is potentially some there. Carolyn Smith, thanks for giving me something great to listen to on my 90-minute drive today. Well, you're very welcome. I always love having stuff to listen to on the drive. You certainly get more than 90 minutes on a trial day here. So glad that I could be Be of service. Appreciate you joining us on your drive. John Beattybot, didn't first trial reveal unrelated glass fragments? Now we deduce extra apparent taillight. Will defense be able to highlight how and when confused? I guess they're not going to get to use their chalk, but it seems like they went through and did that organization in order to produce the chalk in the first place. So it should be something, it's information that is available and organized and can be communicated, if not shown in a visual format, at least communicated in where you typically pull all your pieces together like this, which is in your closing. It's really what your closing is for. Point out, Ashley, you'll have a section of your closing. There's a lot of ways you can do it. I'm just, imagining one possible approach to it. You'll have a section of your closing where you specifically deal with the frame up. What's in police custody? How do we know that this is a frame up? Why is that the interpretation of this evidence that we should reach? Motive, opportunity, etc. Go into all that. But then the actual proof that is what happened. You don't have to just infer it from what they said in their text messages. You don't have to just infer it from these personal connections that many of these officers have with the Albert family. You can look at what the actual evidence is, such as what's the glass doing on the bumper that doesn't match anything else, doesn't match it physically, doesn't match it chemically. How do you explain that if not somebody put it there to try to add to the case? Where else did it come from? Commonwealth has given no explanation for where that glass came from, why it's even there. Taillight pieces, you heard from Ashley Vallier, and the Commonwealth went to great lengths to describe to you all of these different searches that they conducted and how many different people were there and how many different pieces of plastic were recovered from the yard of 34 Fairview. But when it was Ashley Vallier's turn on the stand, you heard that only 23 of those pieces went into Karen Reed's taillight. So where did the other 23 pieces come from? What are they? And what are they doing on the Albert's front lawn intermixed with taillight from Karen Reed's car? You tie it together in closing. Do it something like that. She Godin, 17. If Bev had ruled Welcher and Burgess had to testify to their old numbers, if their opinion is those numbers are wrong, wouldn't that be her ordering them to be untruthful? How would that have worked? She's requiring them to testify to the opinions that they reached in their initial report. That's it. You reach this position in your report. This is the position that you disclosed. You can testify to that, or you cannot testify at all. But that's the limits of what you get to do. You can leave it out. Don't testify about it if you think it's a problem. The issue is they are required to adopt a position before trial and then present their case in accordance with that position. That's what the, we don't do trial by ambush principle is all about. So if your position before trial that you adopted turns out to be a bad one, too bad. So sad. That's what you committed to. So if it's going to create some huge moral problem for you that, you didn't have at the time when you wrote your report and disclosed that opinion, if it's going to create some huge moral problem for you to change it, then maybe you just don't testify. That's how I see it. Kitten Fire Department. Can Bev use possible jury drama to declare a mistrial and give Commonwealth a third try to start over, or is jeopardy attached no matter what? So a mistrial has to be justified by manifest necessity. Otherwise, jeopardy attaches. And so manifest necessity is going to require something far more specific than just jury drama. You have to show that the trial has been undermined in some way. If it's just a particular juror that's causing problems, you can remove that juror. If there's juror behavior that's causing problems, you can do what you did today, give them an instruction. There's many, many, many ways you can try to solve issues with a jury that fall far short of declaring a mistrial. And that came out in a lot of the law that we looked at with this double jeopardy issue with the appeal and the writ and the going up to the Supreme Court and the First Circuit and all that. That was one of the issues that got really fleshed out, was that for there to be a manifest necessity, it has to pretty much be your only option. You have to have considered other options to address the problem and found them insufficient. So drama is not going to be enough to get to a mistrial. You typically need, misconduct. You need some kind of taint. You need the entire jury to be tainted. If just one person is going out and doing something they're not supposed to, you just get rid of that juror and the rest of it's fine. If a juror goes out and does something they're not supposed to and then tells 7 or 8 of the other jurors about it, then you might have a little bit more of an issue. But typically what you do in that situation, you have you interview them, you bring them into the courtroom, you have a colloquy, you ask them about it. Okay, you receive this information. Are you going to be able to disregard that? For example, same kind of thing as in the initial qualification of the jurors. You can know stuff about the case, but can you put it aside? Can you follow the instructions and just rely on the evidence presented at trial to reach your verdict? And as long as they say they can, they're qualified to serve. So same standard should apply. Yeah, they told me this, but I don't really care. It doesn't matter. It won't hold any weight with me. Then you should be fine. So I think there is a long way from a hypothetical situation where a juror may be called the judge an asshole to declaring a mistrial. A lot of steps you'd have to go through to get to that point. Lisa Sides, can the defense request all communications between the prosecution and these experts? They should be able to, shouldn't they? If it's allowed with ARCA, it should be allowed with them. Why do I have the sneaking suspicion that suddenly it would become work product when that standard is applied to the Commonwealth? Why do I have a sneaking suspicion that it's a totally fair game inquiry for the Commonwealth to ask of the defense, but when the defense asks of the Commonwealth, suddenly it will become protected work product? And no, we couldn't possibly do that. Sure, they should be able to. And I think if they were taking the gloves off and fighting fire with fire, they would have already made that request a long time ago. If that's how the Commonwealth wants to play, then you can have it right back. But I don't know that they have. Amanda, Bev is going to tell them now that she'll hear them out later and she's going to deny them. Well, she's going to let the Commonwealth do what they want. We know that now. Whatever they say doesn't matter. Go ahead and talk. Say your words, Mr. Alessi. My decision is already made. I mean, that's what's been communicated, I think, pretty loud and clear. The rural juror, could the defense have a witness display every piece of taillight not included in the reconstruction? Which witness could do that? Anybody that reviewed the reconstruction. If ARCA did that, then they could. If they reviewed the reconstruction and formed opinions based on it, then they could. Otherwise, the person to do that would have been Ashley. Would have been Ashley Vallier. That would have been fun. So go ahead and open up all these bags. Let's go through bag by bag. Identify which pieces didn't match. That would have been fun, wouldn't it? Really good visual. Perhaps a missed opportunity there. I don't know. Alyssa Ramirez, Rick Astley, we're no strangers to glove. You know the rules, and so do I. Never going to give you up. The one that's been in my head all morning is could you be gloved? Could you be gloved? Don't let them change ya. Don't let them rearrange ya. Could you be gloved? Greg, at what point does Bev's bias cross that line and start leaning towards corruption? Because I'm starting to find it hard to say this is just bias. Corruption is something specific in the law. It means like she's getting paid for it. She's getting some type of quid pro quo. So the answer to when it crosses that line is when you can prove that that is happening, that she is getting some undisclosed benefit that is not being revealed in order to conduct the case in the way that she is conducting it. So I think plenty of people may already suspect that. I know there was that prior to the first trial, one of the little embarrassing things that came up was it Venmo payment, some kind of payment like that on Julie Nagel's phone that went to Frank and Beverly. Just happens to be the name of Judge Cannone, and her husband just happened to be Frank and Beverly, but she's like, no, that's not me. See, Beverly was spelled with an extra E. It's not spelled right. So it's obviously not me. It's a totally different Frank and Beverly. I know some people question that. But that's the basic answer. As soon as you can prove that there is some benefit that she's receiving for doing all of this, then you've established corruption. That's where the line is. Z, LawTube and access to courts online is leading reform. I hope so. I think a big part of it is just more cameras in more courts, more visibility, maybe even more interest. You know, true crime. People have always been interested in crime and crime stories, but it is a very big genre right now. Maybe that's part of it too. I don't know. I can't say it's grown, but it just seems like it has. Totally anecdotal, but I think a lot of it is just more eyes, more opportunities to see and realize, oh wow, here we are watching another case that appears to involve some significant corruption by law enforcement. That's crazy. We just finished watching Delphi, where there was significant indications of law enforcement corruption. And you start to realize, oh, this isn't rare. This isn't unique. This isn't isolated. It's actually pretty systemic. Happens all over the place. I think there's a lot of reasons why this type of thing is happening. The Mad Mystic, if the criminal justice system in Massachusetts is this blatantly biased in the case of a murdered cop, imagine how bad marginalized communities have it up there. I've been wanting to ask, how white is Canton? I don't know. I'm just wondering, how white is Canton? Because I'd be willing to bet, like Brian Albert, for example, works out of Boston. Be willing to bet that a lot of his work, like in most urban communities, probably tends to disproportionately focus on the Black people. And guys, there's a lot of reasons why this is. Very complex problem. Very complex problem. Some of that reason does have to do with disproportionality in perpetration rates, but not all of it. Not all of it. And there's just been study after study after study that shows pretty much every opportunity throughout the entire processing of a case, from identifying a suspect, initial contact, all of it up through conviction and sentencing, at any point where there is an opportunity to exercise discretion. If you look at the practice as a whole, routinely that discretion is exercised far more harshly against Black people in the system than against white people. It just is, guys. I've been assuming Canton is pretty white, but I have wondered about that. Nathaniel Hooper, legal AI can do that. I have a legal AI subscription I use every day in my practice. It's probably talking about the scraping. like I said, it would not surprise me that there's all kinds of tools like that out there now. I mean, there would be a major market for it, right? Let the AI go in and do my case analysis for me. It would save me so much time in reviewing stuff and reading everything and thinking it through and researching it. Just let the AI do it at the, astronomical speed that the AI can do that in. Good to know. Thank you for the confirmation. My dog is my ears. We saw this in first trial. So many issues, evidence marked wrong, poor investigating, fired law enforcement, evidence appearing reversed, vid. Can it be stopped externally? How can this be seen as fair trials? If the Commonwealth starts losing, then, you'd think it would self-correct. So that's one way. Juries can start holding them accountable for the defects in their case. That depends on the will of the people that are called to serve and stick around to do it and follow what's presented, not just the outcome you may want to reach. I don't like the accused, so we're going to take a little nap, find him guilty at the end. Same answer, political remedies. Political remedies are, it's a very unsatisfying answer, but the reality is that most of the time that is going to be the solution. You got to vote people out, vote new people in, go to the legislature, change the laws. That's how these systems become so entrenched, because those things are hard to do. Requires a lot of energy and coordination, time, convincing people to care. That's how these systems get so entrenched, because it's hard to exercise the rights that we have to be able to fix them. But I tell you what, if the Commonwealth started losing cases over these issues, bet they'd fix them. Dawn on me, can you explain the numerous violations the defense have made that Bevs keeps saying publicly? No. As a matter of fact, I can't. I went and pulled out my notes from some of the pretrial hearings because I was trying to think through that. Like, when and where did this come from? And what happened on March 18th of 2025, the first day scheduled for hearings on motions in limine? She came out, and the first thing she did was announce her decision on the Commonwealth's motion to exclude ARCA. She made a finding that the defense had not shown the candor required of all lawyers. She said there were repeated misrepresentations. They were deliberate. They were at sidebar, in open court, and in pleadings. That on 7/25/24, a payment was made to ARCA, but on 2/26/25, the pleading says ARCA was not hired or paid for by the defense, that it's material and deliberate and flagrant. That's the only thing she's really ever said. It's the only thing she's really ever said. At the end of the same ruling, she said she's denying the motion to exclude ARCA as long as the defense complies with their reciprocal discovery. Defense complied with their reciprocal discovery. There's been no finding defense didn't comply with their reciprocal discovery. So I'm not sure that there's even been a single Rule 14 violation by the defense, let alone like multiple and repeated ones. She's just got it all spun up in her mind with the candor thing that she jumped on and decided those are willful, flagrant misrepresentations about the paying ARCA, when they're in a completely different context addressing a completely different issue, paying ARCA for their opinions, which did not happen. So I can't explain it. If other folks have a different memory of how this has gone down, let me know. But no, I can't explain it because I'm not sure there's been a single violation of Rule 14 found. Lucy Fair, hi Andrea, sending so much love today. If Karen Reed is convicted, cases reversed on appeal, is Bev barred from presiding over any new trials in the case? Almost certainly not. Almost never. Almost never. The Court of Appeals has the authority to remove a judge from a case, but they're typically only going to do that if bias is an issue. So if bias is one of the issue that's raised in the case and they find, yeah, there's a problem with bias here, they can kick it back down and assign it to a different judge. Otherwise, no, it's going to go back to her. Almost always it's going to go back to the same judge. They prefer that. It's more efficient that way. The judge is already familiar with the case, the issues, the parties. It's just like changing a lawyer midstream. You got to get somebody new, completely up to speed on everything. They like to keep the same judge on. So unless there's an issue with bias that, the Court of Appeals agrees with, then no, she's not going to be removed. It will be back in front of her again. TBD, what more can Bev do to the defense if the defense were to push back harder? Well, she'll start finding them in contempt and, she can start sanctioning them. She could, don't threaten her. She loves to flex that authority. We already know. I mean, I'm still very suspicious of that little sidebar conversation they had during that ruling I was just talking about, the one on ARCA. Remember that she calls Karen and the lawyers up to the sidebar and they have the little sidebar. And all we ever hear about it is she says she asked Karen if Karen wanted to stick with her own lawyers. And Karen, of course, said, yeah. Yeah. I have long suspected there was a little warning in there. You can keep them. I'm not going to remove them. But if there's any more trouble, you might lose them. Because there's no other reason to have a sidebar like this. Right? Do you want to keep your lawyers? Like, how is that even a question? Unless there is some trade-off to keeping the lawyers that you need to be aware of. So I've kind of long suspected that part of what happened at this sidebar is a little implicit threat. These guys have to behave because now I'm going to have them on a very short leash and any future misbehavior and they're gone. Something like that. Yeah, she can make it worse. Believe me, she can make it worse. Lori Webster, how long do we need to endure? Yeah, but ARCA. Yeah, but ARCA. ARCA is a very sore point for the Commonwealth, isn't it? They have to try to dirty up ARCA because otherwise ARCA is very powerful and compelling, independent, not solicited by anybody in this case, totally outside agency, wants them to look at whether the laws of physics and the biology of the human body substantiate this theory that Karen Read hit John O'Keefe with the car and concluded solidly, no, it doesn't. Didn't happen. It's very, very compelling. So that's why they're so fixated on it. They have to try to dirty ARCA up. Bill T, I'm afraid for closing. Is there a way for the defense to object to any lies? Brennan says. I know the Commonwealth goes last. Can they have a reclose? You can object during closing. And it's just like an opening. You can object in opening too. There's, I guess, a bit of a culture that like you shouldn't. It's not sportsmanlike, I guess, to object a lot in opening or in closing. But you really should object in closing if objectionable things are happening. A lot of prosecutorial misconduct happens in closing. And the standard that gets applied to that on appeal depends, certainly in my state, probably not the only place, on whether you have objected or not. And it's the same principle that if you object at the time, there might be a way to fix it. There might be some way to cure it. But if you just sit on it, then it might be that you're sandbagging. So it's got to be really especially bad for us to take it real seriously. You didn't take it seriously at the time, so we're not going to take it seriously now. So you really should object in closing if objectionable things are happening. And yes, stating facts that are not in evidence, for example, prosecutorial misconduct to do that, very objectionable. Misstating the law, very objectionable. Hank is up there, specifically addressing your question. Lies. Hank is up there lying. Yes, that's objectionable. He's saying things that are not in evidence. That's objectionable. So they should, and that would be the way to cure it. They would not get a reclose. They would not get a new argument. They would object. The jury would either be instructed to disregard or not, depending on what the judge thinks of the objection. But you've made your record now, and it can be addressed on appeal. Buzzcat, I think Bev hates the defense because they're the kind of lawyers that she never was. She sees her incompetence. Did we get a little confession by projection there with that, Mr. Alessi? Is this a Google search? You see, you over here presenting information from a Google search? Why, no, as a matter of fact, Your Honor. No, I'm not. I've long been severely unimpressed with Judge Cannone's legal acumen. Her research, what she relies on. She cites cases for things that they don't say. She conflates dicta with holdings. Dicta is part of the decision that is not essential for the ruling. It's just like an aside, or just not part of the chain of logic that follows necessarily to whatever outcome the decision reached. Does things like cite the rule that tells you what canons of construction, rules of interpretation are to be applied to the other rules, as if it is itself a rule about what comes in and what doesn't. She's just legally not particularly sharp, and that shows in her appellate record. Go back and look at that on my Substack if you want. It's way back there because it was, during the last trial. When legal issues get complicated, she flails and she makes a lot of mistakes. So she's not a bright legal mind. And that confession by projection makes it sound like she wasn't a particularly resourceful investigator. So I could see it. It does reek of intimidation, doesn't it? Insecurity. Reeks of insecurity. I got to put you in your place. I'm the one with the authority here. I'm the judge. It's the vibe I get. So I could see that. Elf, as a nurse, I know that drinking alcohol can affect hypothermia. Has this been mentioned? It has not been mentioned. In fact, it's come up in the chat now a couple times, and I got tagged in something on X last night too. Kind of explained in a little bit more detail. So what happens is alcohol causes your blood vessels to dilate. And what that does, it does two things. One, it makes you actually feel warmer because it feels like, more of your blood is at the extremities. So you're going to feel warmer. But because more blood now is in your extremities and being exposed to, where your body interfaces with the cold temperature outside, you're going to lose heat faster. So that's how alcohol can affect hypothermia. It both makes you feel warm when you're not and makes you get colder than if you weren't otherwise intoxicated. Has not been mentioned so far in the context of this trial. It's the kind of thing, again, I would expect from the defense's forensic pathologist. It sounds like that's going to be related to her theory. I mean, at least if they're looking at alcohol consumption contributing to John's stomach ulcers, then I would think that they have looked at alcohol as part of the contributor to this overall circumstance. Don't know for sure, but That's where I would expect to hear it from, and certainly hope to hear it from. J-Man is a YouTube member now. Welcome, J-Man. Appreciate having you with the channel. Coffee Addiction is giving us a super sticker. Thank you so much for that. Appreciate your support as well. Michelle, does double jeopardy have anything to do with the Commonwealth altering their theory of the case? If the theory is altered, Karen isn't being charged twice under the same circumstances. So double jeopardy, from my perspective as a defense lawyer, it's largely a doctrine that doesn't have very many teeth to it. All it really establishes is that you can't be retried after you've been acquitted of something. You can't be tried for the same crime twice. But that not being tried for the same crime twice it really is nearly toothless because the way that the courts interpret that is that as long as there is a statute that has different elements to it, slightly different requirements to convict that person, then you could convict them of it. And so, for example, if Karen Reed is acquitted of well, this gets a little bit more complicated. If she's acquitted of, for example, second-degree murder, and you can't retry her for that, but I don't know. There's some type of negligent homicide that she hasn't been tried with, and it's got different elements than the murder. Could she be tried for that? Potentially. It's not the same crime. It's not the same crime. And that's why you see, for example, you can be charged with murder and manslaughter and all these other things and, potentially have multiple convictions for the same act because they're different crimes. Same thing, Karen could be acquitted by a state jury, and if there was a federal basis to prosecute her, the feds could come in and charge her anyway because they're a separate sovereign. So they're not, it's not, they don't implicate double jeopardy. So the worst position to be in is to be a tribal member, an Indian tribal member. You can be prosecuted by your own tribe, the state that you're in, and potentially the federal government. 3 separate sovereigns all potentially could come at you for the same act, same thing. So double jeopardy offers very little protection that way. Where this seems to fit into me, where it would seem to make sense is that it's hard for me to understand how, because we don't do indictments in Washington. We have prosecutor files a charge. They submit a probable cause affidavit to a judge at the very beginning of the case. Judge goes thumbs up or thumbs down. And it's, almost always thumbs up. Yes, it establishes probable cause. And that's it. You're done. No preliminary hearing, no indictment, nothing. Like you're going forward to trial at that point. You can go back and challenge the probable cause. You, the defendant, can go in and file a motion to challenge it. But they're just going to look at what's in that affidavit and be like, yep, looks good. Previous judge found it. We're moving forward. So it's hard for me to kind of shift my mindset to a different system where you use the indictment process. But that's where it seems to me there should be a problem with this, because if the indictment is based on presenting a certain set of facts and circumstances to a jury, a theory, if you will, to a jury, and based on that, the jury returns, a finding that the certain charges are justified and should be brought, then if the theory is changed, why would you not have to go back and get a new indictment? Vet your new facts with a new grand jury. That's what I don't understand. But seems to be that that's not required. Once she's indicted, it seems to be that the Commonwealth can proceed on any set of facts at all that they want, whether it has anything to do with what the grand jury approved or not. Definitely no double jeopardy protection, because double jeopardy gives you very little to no protection anyway. And the legislature can deprive you of a lot of your double jeopardy protections. They just adopt laws with different elements, different requirements, and then you can be charged with all of them, and there's no violation. But I don't see how We can be like, yeah, grand jury decided these facts warranted a finding of probable cause, and now we're going to completely change the facts and not have to revisit the indictment. But apparently they don't. Lucy Fair, how are there appeals if defense wins? There aren't. There aren't. Defense wins, then all of this is off the table and none of it gets corrected. It's just all kind of falls under this umbrella of, well, no harm, no foul. She didn't get convicted, so nothing to worry about here. No reason to follow up on it. Nothing to see. No appeal if she wins. From one Adam. Karen Reed case was Auntie Bev's first criminal trial. I don't believe it was. I remember hearing about another murder case. Wasn't there another murder case she presided over and like made a mess of it? I can't remember the name of it. I don't think she's had a lot of murder cases. But I do think she's had criminal trials as a judge. She was on the criminal judge docket, when Karen Reed's case was assigned to her. She's a former public defender. She's had her own criminal cases. Like it shouldn't be this hard. It really shouldn't. But here we are. Factual lie. Instead of locking his phone, he would call for help. You would think. Wouldn't you think? You get hit by the car, you fly through the air. It's probably not going to be the time you're going to check that text message from Jim McCabe and then turn your phone off. No, of course you'd call for help if you're conscious. Makes a lot of sense. Yes, Michael Chesna. Thank you for reminding me of the name of that case, Michael Chesna. I've heard about it. Haven't dug super into it, but it's just what I've heard. Another murder case she was on apparently ended up, I think it got reversed on appeal. Michelle Bellinger, Hank's gaslighting is so triggering to any of us who have been abused by a narcissist. Not convinced he's not like that in real life. Even his voice is triggering. It's Alessi, Mr. Brennan. Bob the Dragon, not their father. Well, you're just being told what you need to think, regardless of what you yourself have observed, what you yourself believe, what you yourself think is fair. You are to be instructed by Hank Brennan because he says so. That's his approach to arguing. And it is a rather narcissistic approach, isn't it? Put aside what you see with your own eyes. Put aside your own memory of the case. You're not entitled to rely on any of that. All you're entitled to rely on is me and what I say. And if I said something different last time, it doesn't exist anymore. It is a very narcissistic perspective where what I want is the center of the universe. And therefore you're expected to adjust your worldview to accommodate what I want. Yeah, I can see the parallels. Reality check. Can they go in and ask for ARCA to be able to come back on after Commonwealth witness who comes after them? She's not going to give it to them. They can ask. She's not going to give it to them. So what's going to happen? Commonwealth is going to put on their case, and their initial case is just going to address the things that ARCA testified to in the first trial, things that the FBI hired them for. ARCA is then going to testify. They're going to testify about the same stuff they testified to in the first trial, and then the new stuff that the defense has asked them to follow up on. And now in the meantime, we've had no indication of any kind of deadline for Welcher or for Aperture to provide their rebuttal materials to the defense. Nothing about that before they testify. Just we're going to talk about the scope once things become more clear. So not clear that ARCA is even going to be able to have notice of what Aperture is going to testify to in rebuttal. They may not even get notice of whatever critique Aperture has to what ARCA does, because normally they would get that and they would address that when they testify. So that's how I'm seeing this be set up, where Aperture is going to get to do a free rebuttal, and there will be no opportunity for ARCA to even know or address it in real time. And is she going to let them come back on? Of course not. Of course not. Can they ask? I mean, they can ask. But if she's not even going to give Aperture a deadline to produce their rebuttal so that ARCA can address it in a meaningful time, in a meaningful way, and she's not going to allow that. Annie Abramson, arm scratches, vertical rows of sharp connectors in telecom junction box. Top of its open metal door matches tears in chest of sweatshirt. This is a new theory. It's a new theory. Once again, just where's the blood? Where's the tissue? How does this work from a mechanical standpoint? Like how does this work? How does he end up on the junction box, but then over somewhere else? Don't know. But if they're sharp connectors and that those are the causes of the cut, then they should be the ones that have blood and or tissue on them. So where is it? Duncan, Idaho, these sorts of trials make me think about all the evils we do unconsciously as a society when we relegate any sort of process to a system which will inevitably steamroll over innocent people. Well, it's one of the oldest ideas in the world that power corrupts. Power corrupts. You give somebody a little bit of power and they will find a way to abuse it. And you do that on a large scale and in a complex system like an organized society. And you just have a lot of corruption acting in concert, and it just has a way of taking on a power of its own. Because then people see, they get feedback from the rest of the system. And then that affects them and how they do their jobs and how they interact with the system. And the bigger it gets and more powerful it gets, the more entrenched it gets, and the harder it is to root out these problems. And the more these problems just sort of get taken for granted as an inevitable cost of having the system in the first place. Yeah, this is what happens when we delegate power. It's always been a risk. It's a problem the founders were deeply concerned with. Came up with this rather complicated way to try to diffuse that as much as possible so that too much power wouldn't get concentrated in any set of hands. But states have their own. They have their own rules, their own powers. Some limitation from the federal constitution, but when it comes to what are we going to delegate to whom and to do what, got a lot of their own independent authority to do that. And have not necessarily done that with the same care and caution that the founders originally tried to do with the structure of the federal government. Power corrupts, guys. It's just part of human nature, unfortunately. And the more complex the system gets, the more that power aggregates and that corruption aggregates, and it provides feedback and it gets entrenched. And then people just assume that that's how it must be. Accept it as a cost of doing business. J-Man, if Kerry had John O'Keefe's phone, they would not have needed to cut his back pocket to get it out. But I think we cut his back pocket to get his wallet out, not his phone. That's what the comment that somebody posted the other day that I was talking about. I haven't gone back and looked at any of this video myself, but the comment was he's putting his phone in the left pocket, not the right pocket, or just the other pocket. I think, yeah, the left, not the right. And that the right has the outline from the wallet, and that this is kind of routine that ER first responders, they will cut the pocket to get the wallet out. So that would remain possible if that's kind of how everything is lined up. They would cut his pocket to get his wallet out, not necessarily his phone. Reality check. Can defense pull ring video with snowblower and point out why pieces weren't found in closing? If the snowblower part of the video is in evidence, absolutely they can. They can use anything that's in evidence, whether it's been shown to the jury already or not. As long as it's already in, they can use it. So if the entire ring footage for the day is in evidence, they can use any of it to make whatever point they want. It's the only limitation they have. Brittany Sampson, will Alessi be able to ask those witnesses why they changed their timing or anything regarding it? Oh, absolutely. Absolutely, he's going to be able to cross-examine them on this report, their previous reports, and from my perspective, their previous theories. I'm probably not even asking at this point. I'm not going to ask for permission to cross-examine this representative for the Commonwealth about the fact that this is, like the third version they've come up with over the course of two proceedings. Oh, I won't say the bad word. I won't say the big bad word trial. But you absolutely believe I'm going to be cross-examining about the changes in the theory. Trooper Paul didn't get you the conviction. His entire rationale was ridiculous. It was laughable. So laughable that the Commonwealth ditched him when they couldn't put Karen Reed in prison based on that. And now they fished for somebody else whose theory was also ridiculous, as we know from Ian Withen. And so now they're changing it yet again. Yeah, he better be able to ask questions about all of that. Michelle Bellinger, plastic theory, clear ones don't seem put together. It's very hard to know what's what, and how these pieces fit in. 23, let's see, for example, got to keep track of what's what here. Remember, for example, 7-6 was just clear pieces. Did 7-6 have any pieces that fit into the tail light? It did not. All the rest, I think, were mixed. Mixed red and clear and so forth. Yeah, there was only one bag that was nothing but clear plastic, and we don't know what parts from the rest of the bag fit in. But the problem is those parts didn't fit each other either. Remember, very, very few of the pieces within the bag fit each other. Yeah, I don't know. I mean, you need a visual. You need it all laid out. You need the visual. The problem is that piece that's missing, that's still missing after she does the reconstruction, pretty sure that is clear plastic. Where do we have the tail light? Where do we have the tail light? Let's see if we can find where that taillight is and what it was supposed to look like before. Was it clear? No, it looks like that is also red. Looks like that is also red. Oh, hey, sorry. It pulled up a picture from my Substack. Let me see if I can find it in Sleuthy Goosey's spreadsheet real quickly. got the trial 1.0 exhibits. Okay, let's see if we can find the tail light or the SUV. Lexus and Sallyport, a lot of those images. See if I can find a good one that shows us the back. Here we go. Here's one from the opposite side. I'm going to go ahead and share this with you guys. All right. Can we see that? Can we see that? Oh, no, it's showing something else here. That is not what I was trying to bring up. Where did it go? Here, that's what I want. Let me see if I can share this. Okay. Is this it? Yes. So that's the tail light, right? That's the tail light from the left side, the one that is unbroken. And so you can see it looks like the pieces that are missing in that right here. That's what they weren't able to find. It does look like those are some, if not all, of the clear pieces. So problem is that if their clear pieces are from this taillight, then they should match, right? They should go right into that spot. They should go right into that spot, but it doesn't seem like they are from the taillight, or they would. Would be nice to have all the pieces laid out, wouldn't they? And be able to sort through. These ones matched, these ones didn't. Maybe we'd be able to detect a pattern, but we get incomplete information in this context. Ape Baboon is a YouTube member. Welcome, Ape Baboon. Welcome. Have yourself a great time here. Lucy Fair, does Court of Appeals look for all reversible issues or throw it back at the first one they find? Can stacked sheer number of issues suggest bias? So one, the Court of Appeals only considers the issues that the parties raise. They do not independently go and look for issues. The only exception to this is what's called an Anders brief, which is where it's a public defender is handling the appeal. They've read through it. They're like, there's nothing here. There's no issues. There's nothing I can argue that has any merit. Then the Court of Appeals will go and do an independent review of the case and look for error. But outside of that, they just consider what the parties present to them. So the parties have to raise bias if they want it to be considered. There is cumulative error. That is a general theory of error on appeal, which is basically like, look, there's a ton of mistakes. None of them independently were enough to warrant a new trial, but the collective effect of all of them it renders the trial unfair. And so you should reverse it for that reason. Very, very, very rare for cumulative error arguments to go anywhere. Common to bring them, especially if you got a lot of issues that you're arguing on appeal. But throw it back at the first one they find. It's not necessarily that they throw it back at the first one they find. It's just do they find a reason to reverse? And if they find a reason to reverse, does that take everything else off the table? Often it will, because other issues will be mooted. If these other issues would also support reversing, then you don't need to get to them. Like you got multiple grounds. That said, the court will address them sometimes, because if they're likely to recur on remand, then we're going to anticipate it, so we don't have a problem if we send this case back and it gets retried and they make the same mistakes that they made before. but the Court of Appeals didn't address it. So it really just depends. Some of this, it depends on context, but bias is going to be something that has to be specifically raised. Alleging a lot of errors or even finding a lot of errors is not going to establish bias in and of itself. It's going to be something that the defense has to argue if they want the Court of Appeals to do anything about it. Michael Muddragon, who's afraid of the big bad wolf? The big bad wolf, the Dr. Wolf. They're terrified, as they should be. As they should be. What a good witness. He is so professional, so charming, very well spoken. He's got that great voice, wonderful voice. Had that boyish enthusiasm over the cannon. It is cool. Yes, what a cool job. You get to build a cannon and shoot it at a taillight and see what happens. Who wouldn't want that job? How do you not like that guy? They're terrified of Dr. Wolf. Sandy B, don't forget Ryan said he got there at 12:30 to 12:35 and the prosecution didn't correct it. That's a good point. They didn't correct it. That is still floating out there. We've been waiting. I've been waiting for Julie Nagel to pop up in the Commonwealth's case because one, she's the black blob person. We got Sarah Levinson who like hinted that Julie Nagel said something, but she's not allowed to say what because it's hearsay. Julie Nagel is the black blob from the first trial. She just like suddenly decided a few years in that she had seen a black blob as they were driving away from 34 Fairview, but she never said anything to anybody about it. And it never came up in the days following when we discovered John O'Keefe found in this area where now you say you saw a black blob. I've been waiting for Julie Nagel because it's her text message with Ryan that kind of established this time frame. Jen McCabe had specifically asked for the copy of her text message, and the jury has heard that she asked for the text message, but then also kept it for herself. It was there to assist her with making her timeline. Seems like it's got to come in through Julie Nagel for just authentication purposes. I don't know if it's going to. I don't know if they're going to call her. It would be very strange and out of place at this point to call her, but maybe they're going to. I don't know. But you're right. That has not been corrected at this point in time. Jonna, did the 129 pieces match? Did any diffuser pieces match? Did she understand how they fit into the interior of taillight? She should know. It's her job to know if they fit together because she'd be seeing broken pieces and then matching them together. So she should know just based on what's presented to her and what's broken and what isn't broken, how it fits together. As far as the rest of your questions, we don't know which of these pieces are from the 129 search because all we have are a bunch of bags that David DeCicco taped and initialed and sealed on February the 4th from, a bunch of different efforts during this point in time. We had the search on the January the 29th. We had the search on the 3rd. We had the search on the 4th. So we don't know which pieces the cert pieces are. Don't know if any of the diffuser pieces match. We know that the two from bag, what was it, 7-6? 2 pieces of the plastic, clear plastic from bag 7-6, sealed by David DeCicco, labeled February the 4th, have 2 pieces of diffuser. Those did not match up with the rest of the taillight. We know that. But there were other pieces that looked like diffuser pieces in bag 7-15. 3 clear, 5 red. All we know about 7-15 is that 2 of the pieces in that bag fit to each other, and 4 of the total pieces fit into the taillight. But we don't know which ones. It could have been all the red. Couldn't have been all clear. Has to be at least one red. We don't know. We don't know. Lady Di 2, can the defense file an interlocutory appeal just to prove a point and halt the trial, or is that only allowed before the jury is seated? You can file for an interlocutory appeal at any time. You're just very unlikely to get it, and the court is going to have to stay, the appellate court is going to have to stay the trial for this to be effective, and they're extremely unlikely to do that. You're going to have a showing of such clear and obvious error and such obvious impact, prejudicial impact, that it's like a no-brainer. And you're almost never going to get that with discretionary types of rulings. They can be wrong, but they're rarely like really obviously wrong. So the Court of Appeals is going to be aware, if I stay the trial pending an appeal, jeopardy has attached. The jury has been seated, the jury is waiting, and then things can happen. You know, things can happen if we just tell the jury, hang on and wait. And it takes us time. It always takes time on the appeal. Things do not happen quickly. Things are calculated. You know, if it's a real emergency, things are calculated in terms of weeks rather than months. But normal appeal timelines are calculated in months, if not years. So very unlikely that this would happen. And it just comes down to a trade-off. What do you focus your energy on? Your number one priority right now is win the trial. And so if this is going to take energy away from that effort to pursue something that has a very low likelihood of success, no, you don't do it. You can't afford to right now. Time is not an unlimited resource. It is very zero sum. John Beatty bought undefended expert testimony equals constitutional fail. Deprivation of the right to defend, isn't it? If they don't get an opportunity to answer evidence from the Commonwealth, no opportunity to prepare, to evaluate it, address it, yeah, that's literally saying she doesn't get to defend it. They get a free shot, unchallenged, to say whatever. Yeah, looks like a Sixth Amendment problem to me. Pearls of Wisdom with a super chat. Thank you so much for that. Appreciate your support. Dawn on me. Sorry to go back in time, but Bukaki said he was on traffic duty when he acknowledged. Thumbs up that text from Proctor. Why is a homicide detective directing traffic? Don't know. Could have been, you know, sometimes they get off duty, extra work. They pick up overtime assignments. It's part of the retirement plan, because your retirement in Massachusetts was based on a percentage of your last however many years salary, and that would incorporate overtime. So you can go in and just blow up how much your income is in the last couple of years, and then you get a big pension. Buchanan's not retired now, of course, but it's part of the scam, guys. Part of the gig with law enforcement is the overtime gig. So it could be that, just take on an extra shift to work traffic for some event. Maybe there's a ball game or something. I don't know. I don't know what they have in this area, but he's Massachusetts State Police. He could probably go a lot of places, direct traffic, a lot of different areas. So that would be my guess. But of course, I'm speculating. I have no idea. No idea. AG 4981. Do you think Valerie DNA is on the taillight? Was Yanetti implying that when he asked her if it was tested before and after she got it? You the best. Oh, Vallier, the test person. I don't think that was what he was getting at. What he was getting at was that none of the taillight pieces had been tested for DNA, because Maureen Hartnett didn't test any of them. And in their sequence of events, the taillight, the pieces would have gone for DNA analysis before they end up in Ashley Vallier's hands to do all this reconstruction work. So it wouldn't have happened after her. That's all he's nailing down, is just that there was never any sort of swabbing, testing for blood, body fluids, DNA, nothing like that of the pieces that were recovered from 34 Fairview. That's what that questioning was about. Michelle Bellinger, only saying because maybe YDF didn't ask. Maybe. Reality check. Text message with BH. KR knew how cops were with cameras, so why would she do the crime in front of a cop's house, in front of two cops' houses, right? We've got Kelleher right over on the other side of the street. We've got at least two cops right here. And then she's going to go home to a cop's house. Yeah, she knew how they were. I think Karen understood this real clearly, and that's why when she got arrested the second time, and they have her on video down at the station. We saw this in the first trial, but haven't seen it here, probably because it's not particularly helpful to the Commonwealth. Where she's like, "Are we all in on the same joke? We all in on the joke here? They beat the shit out of John. Brian and Colin beat the shit out of John and hucked him out on the front lawn." She knew exactly what they were the whole time. So she knew what they were capable of. I think there was just that doubt because of being gaslit, not remembering, being a little bit drunk. There's media reports that they have this on video. So she has that phase of questioning her reality. Maybe it was true. Maybe I did hit him. Don't remember it. But if all this stuff exists, then maybe I did. Maybe I'm crazy. But then the evidence starts to come in and you realize, nope, I was right all along and all of this was bullshit. Then you go back to, oh yeah, I know how these cops are. Annie Abramson, did Karen bolt mad because she thought Julia was Marietta? John just got out of car, told her he was talking to Higgins. He just read his text. I don't think so. I mean, I think this is Julie Nagel. Julie Nagel would be hard to from my eye to confuse with Marietta Sullivan. Julie Nagel has a little bit of a hard Appalachian backwood look to her. I think Jeff might back me up on that. Certainly with her attitude. Little Appalachian backwood attitude to her. Marietta Higgins is more of that. She's a pretty girl, very pretty, Marietta, but got some attitude, little attitude. Julie's more of a tough girl. Julie is not the looker that Marietta was. So seems unlikely to me, but my read on this is that he went in and he was supposed to, check things out, make sure it was okay for them to go in. And he just never came back. Just ditched her, left her sitting there. Maybe she hadn't wanted to go in the first place. Maybe she was like, look, just go say hi, make it quick. See if you can get a ride back. I'll hang out until you see if you can get a ride back. And he just never followed up with her. Then he doesn't answer the phone. And she's like, fine, fuck you. And she's out of there. I think the phone calls are a little bit of a giveaway. He's brushing her off. He's just blowing her off, just like he did, all morning. I don't know. Would love to hear from Karen. Don't know that that's going to happen. Half Irish, excited utterance has a special stream tomorrow about wrongful conviction of Zachariah Anderson. Please join us 7 p.m. Eastern. Thank you so much for this. For the reminder, I had wanted to mention this too. Excited utterance, of course, one of our fabulous mods here on the channel. Really appreciate her and everything she does. I have for years now, because it's been a couple of years now. It's been 2, right? It's the 2-year anniversary of the conviction. I wasn't able to watch this trial when it happened. I know a lot of folks did. I know a lot of folks definitely don't agree with the outcome that was reached in this case. But it's not something I know a lot of the details about. I just know like trace evidence and not a whole lot else. problems with witness credibility, stuff like that. Very similar to some of these other miscarriage of justice cases that we follow. So I am definitely interested in the stream because I want to know more about the case. And I just haven't, it's been on my list for 2 years to go and get caught up on it. And I just haven't been able to. So thank you, Half Irish, for sharing that. Do check that out. I would like to know more about this case as well. So hopefully maybe I'll be able to pop in. Carrie Mache, lawyer calling for people to call the Massachusetts governor. What remedy do you propose? The remedy for what? The governor is the one who appoints the judge, right? So I don't know if there's a process to remove a judge. No idea. I don't know what that looks like in Massachusetts. But holding the governor to account for the choice that he already made, yeah, that's an option. It's not going to really fix anything, but it's going to put the pressure on to do what you can do. If there is something that can be done, you should do it. Massachusetts governor, you are the chief executive. The Massachusetts State Police, I would assume, in most jurisdictions, that is an executive agency. It's created by the legislature, but it's overseen by the executive branch. So Massachusetts governor should have some type of oversight, some type of authority over the Massachusetts State Police. Perhaps it's time to do a little cleaning house. Perhaps it's time to do a little auditing, a little special investigating, things like that. There's no way to fix what is happening now or to make it stop. The wheels are in motion. The only way this is going to stop is if the prosecutor in charge of the case, comes in and says, we're dropping it. Not doing this anymore. We're done. That's the only way this train stops. Based on where we're at right now. Everything else is mitigation. So there isn't really a remedy for it. Problem goes back to Michael Morrissey. He's the one that appointed Hank Brennan. He's the one that is, ultimately in charge of whether this prosecution proceeds or not. He could change the special prosecutor. He's not doing it. Rachel Hager, do you think maybe Judge sustained some of those objections yesterday because they lacked foundation? Heard that on EDB. I know you think it is clear bias. I'd have to go back and look at specifically what some of the objections were. What I was talking about was we were looking at it from the Rule 703 standpoint, the basis of the experts' opinions. And the problem as I saw it is that the Commonwealth was allowed to ask any number of questions which would have foundational problems like this. Are you aware of? That's been kind of an ongoing theme in this trial so far. We saw it with the have of voir dire of Trooper Buchanan. Ask him if he's aware of these other text messages that Michael Proctor sent with his friends, for example. The text message with Courtney Proctor. That's the foundation that she seemingly requires in order to be able to ask that question in front of the jury. So when Buchanan says he doesn't know, then they don't get to ask that question in front of the jury. So rule seems to be need a good faith basis to think there is some awareness on the part of this witness before you can ask them if they're aware of it. The problem I saw is that the Commonwealth is allowed to ask all kinds of questions about what Dr. Scorti-Bello was aware of that she not only was not aware of, but would not have been aware of. There was no basis to ask her if she was aware of Karen's interviews at the time that she wrote her April 2022 report, when all of Karen's interviews took place at least a year later, long after the fact. So I don't think it's just foundational, because the Commonwealth had no foundation for all of those questions that they were allowed to ask. And those objections were overruled. She'd let him go through the list of the closing. Are you aware of this? Are you aware of the other thing? And then she would say no, and she wasn't aware, and he'd still ask, and then she'd be like, oh yeah, I learned about that later. But when the defense wants to ask her, are you aware of these other facts? Are you aware of these other circumstances? Are you aware of limitations with the Commonwealth's case? They're not allowed to ask it. No foundation for that. So no, I don't think it's a foundation problem, because the same rule didn't get applied to both sides. The Commonwealth did what she said the defense can't do. Mr. Alessi, you can't do that. But she let the Commonwealth do it. And if that's a foundation basis, it's not a consistent one. So that's the issue as I see it. I think if there's a lack of foundation here, yeah, that would have been valid, but you needed to also sustain that against the Commonwealth, and she didn't. That's the problem. MMG enrichment, you're fucking great, Andrea. Well, thank you so much for that. I appreciate that enthusiastic endorsement. I try not to, I try to be conservative with the use of the swears. My grandma watches the show sometimes, guys. I don't need to drop an F-bomb like every other sentence, but sometimes there's just no other way to communicate what you're saying. Just no other way to communicate it. So try to keep it minimal, but it just happens. But we do think of Nana here. We're looking out for Nana. Nana's 95 years old, 96 years old. Holy cow, Nana's 96 years old. Still with us, still doing great. She's a real inspiration. So it's very much a privilege to be nearing 50 myself and still having my grandma watch my YouTube channel. It's pretty cool. So guys, hey, I just saw this come up. Want to address it real quick. Lindsay, wow, Andrea, did any of the taillight pieces that CERT found match? Just heard your comment. Any taillight didn't have to match them. We have no idea if any of the CERT taillight pieces matched, because the CERT taillight pieces were not kept separate from all of the other pieces that were found between January 29th and February the 4th. We have no idea. All these bags are just identified as sealed by Trooper DeChico on February the 4th. And we have no idea what is what. So based on what's been presented, it's entirely possible that not a single piece of the CERT taillight piece matched her taillight. Entirely possible based on what's been presented so far. Yep. Interesting, huh? Always kind of made me wonder if this was a frame up, even if it wasn't a frame up. Okay, but either way, if this was a frame up to get Karen Reed's taillight out there at 34 Fairview for CERT team to discover, or Karen Reed's taillight just happens to be there for CERT team to discover, wouldn't you have bent over backwards to properly log and document the chain of custody of those pieces of taillight? You know how to do it. Wouldn't you lock that down? That would be part of the frame up. That would be part of what made it so compelling. It's actually Karen Reed's taillight, and it got booked into evidence on the night of January the 29th. And CERT team showed up, started showing up at the scene before Karen's car was ever in the Sally port. Wouldn't that lock it up? Just seems like that would have been one of the essential steps if that's how the frame up was done. But I'm not convinced they even had to. All you needed was just some taillight. some plastic pieces out there for CERT to discover, and you have an unattended crime scene the entire day. Seems like it could have been from anything. MMG enrichment. Sorry, Nana. Please forgive. We just love AB. Nana will forgive you. She's a good woman like that. She's not going to hold the swears against you. She just finds it unladylike when I do it. I understand. Well, guys, week 4. They still can't make a case, so now they got to start. Now they got to start fighting cheap. Now they got to start hitting below the belt, getting the ref on side, not calling the shots. That's where we're at in the case. All because of how terrified they are of ARCA. And rightfully so. So next week, we've learned, will be short. We'll finish after the half day on Thursday and then have no court on Friday. So not quite the marathon we have to get through next week compared to this week, even though we still did have that surprise day off and then a whole extra half day today. Guys, I'm gonna be able to mow my grass tonight. I'm very excited about that. Didn't necessarily have that on the schedule, but I think I'm gonna be able to get that done. Sometimes there's just little hidden blessings, even in the middle of all the frustration and aggravation and injustice. Still little blessings, guys. You gotta seize on them where you can find them. So next week we'll get Monday, Tuesday, Wednesday, and a half day Thursday. And it's not entirely clear the Commonwealth is even going to be done by then. Sounds like Hank was suggesting maybe calling Aperture after the holiday. That doesn't sound like on track to me. That doesn't sound like the timeline that was represented to us before trial. So I'm not sure what to make of that, but either way, Commonwealth continues to run out of time on making the case that this car accident occurred. And I just don't know how you're going to overcome this fundamental problem that is John's injuries. Any person with a pair of eyes can look at and be like, doesn't look like what it looks like when somebody gets hit by a car, but sure does look like what somebody looks like when they get beat up. Sure does look like somebody got beat up. Sure might explain these blood patterns, why there's blood on the instep of his shoe, blood dripping all down his front, blood on his t-shirt where it shouldn't be. Sure does seem like a fight. My Melissa, maybe John O'Keefe was on the ground being attacked by Chloe. Right arm up and left pushing on the ground to get away. Explains the grass stains on his left pant buttock. Puncture marks from pinch dog collar. It would be very close. Those would be very close, studs on a dog collar. I have not accepted and do not accept that his left pant buttock has grass stains on it. They are red-brown stains, according to Maureen Hartnett, and she did her swabs of the red-brown stains, and they tested positive for blood. So I'm not buying that there is a single grass stain anywhere on John's clothing that comes from nowhere but the mouth of Trooper Buchanan, and he is not credible. He's not credible. So, possible that some of this just has to do with Chloe. I think it bears repeating. None of this theory of the defense requires a motive to murder John. None of this requires an intent to murder him. Things can just get out of hand. You're drunk. You're getting aggro. You get in a fight. You take it too far. Things happen. Things can happen. Don't fight on concrete. I always, I'll see the street fight. I don't really care for street fight videos because they're usually trash, usually not good fighters anyway. But you'll see them sometimes and it's like kids out fighting at the park on the concrete. Guys, don't do that. It's idiotic. It's idiotic because yeah, you can fall and crack your skull, go into seizures, make yourself a vegetable. If you must do stupid street fights, don't do it on concrete. Take it out to the grass. Why? Because grass, far less likely to crack your skull, even in the middle of winter. Even in the middle of winter. So none of this requires any type of premeditation or anything like that on the part of anybody at 34 Fairview. Just got aggro, got in a fight, and things got bad. And then that's what led to the need to the cover up. So I think there's a lot of different ways this could have gone down. I doubt we're ever going to know for sure what happened. It's unfortunate, but just think that's where we're at right now. I don't think we're ever going to know for sure what happened to John. Sean and Michelle, hey, it's me again, obsessing. I think the holes and bruises are related. That would make sense, wouldn't it? It would make sense. They're both in the same place. He didn't have that bruise on his hand earlier in the night. Didn't have the punctures, I wouldn't think. Didn't hear anything about it. So when did he get them? Sometime between when he was last seen and when he was found the following morning. So it does seem to narrow the range of possibilities of what either or both of these came from. The puncture is such a mystery. It is. Oh, I wonder if we'll hear something from the defense's forensic pathologist. I'm not going to get my hopes up. I'm going to manage my expectations and hold open the possibility that we'll never get an answer for this either. We will wonder about this forever. What the hell are those punctures on the back of his hand? I'm prepared for that possibility. It seems like a probable outcome here. I am too. I really would like to know. Seems like that could help unravel the story of what happened. We could identify these puncture wounds and figure them out. Look at how much unraveled once we figured out that those arm wounds. Oh, those those look like dog bites. And then all of a sudden, creates a whole image of how things went down and why, and a whole view of the behavior. It makes sense. I feel like those punctures could maybe help solve it, but don't know if we're going to find out what they are. All right, guys. Well, hasn't been our favorite day, hasn't been our favorite week, but we've made it through. We've made it through. It's Friday. We're done early. We still have afternoon or at least a little bit of evening, depending on where you are. Actually, if you're over in Australia, go to bed. Go get some sleep. We've had folks watching from all over the world. It's really been amazing to see a lot of people reaching out with their perspectives and comments and so forth. So don't want to be too self-centered about having a whole afternoon ahead of me to be able to go catch up on stuff, play with the dog, get some sun, get that grass mowed. Looking forward to that. Take a nice shower, all of it, all the wonderful things you get to do with some extra time that you find in your back pocket. I might even get some time to work on the bonsai trees. I will take some pictures and share. Let you see where we're at. So not necessarily our favorite week, but hey, it's over. And we don't have to suffer from it anymore because it's no longer happening. We don't have to cling to the discomfort that the last couple days has given us. Just go ahead and let it go. Enjoy what the moment brings. Right now, the moment is bringing new opportunities, and we can revel in that. And then, when it's Monday, we'll be back. We can worry about what happens on Monday. So, getting ever closer to the end of the Commonwealth's case and still waiting to see how this is all going to come together. I waited the first trial, was unsatisfied. Don't have my hopes up for this one, but getting closer and closer to time running out on the Commonwealth's ability to present that evidence. So we will see what next week brings, guys. Thank you again for joining us. Thanks for your support. Thanks for your comments. Thanks for your awesome contributions to the chat. All of you smart people, all of you witty people, more songs, more glove songs to think about, get stuck in my head. Yeah, there's been a few of those. Glove potion number 9. Oh, it just goes on and on and on, doesn't it? Thank you to the mods. Check out Excited Utterances stream tomorrow night, 7 p.m. Eastern. If you're interested in the Zachariah Anderson case, which you should be, I am, and have been far less diligent than I would like to be on getting up to speed on that case. So I'm going to do my best to check it out as well. And otherwise, guys, again, just look out for yourselves. Look out for your mental health. This stuff can be very challenging, very frustrating. It can be real hard on a person to have to fester in. So do make sure you're putting on your own oxygen mask. Yes, it's good to be concerned about what you see. It's good to care. It's good to want to see change. It's good to have those outside interests, but you do also have to look for yourself first. So make sure that you are in the best condition you can be in to go out and make those changes. So do what you need to do. Enjoy your weekends, guys. I'll see you back bright and early Monday morning, and we'll see what week 5 has in store in the trial of Karen Reed. Take care, everybody, and we'll see you then.